it is now time for the inquiry to resume. First of all, mobile phones, please. Check my own, actually. You could turn your mobile to silent, that would be helpful. Thank you, sorry. Thank you. Yep, that's great, thank you. Next, the fire alarm has already, or the practice has already been and gone, so if we hear the fire alarm, it is the real thing. So we exit by one of the two doors either side and down the stairs and congregate in the council's car park. Don't obviously come back until we're told it's safe to do so. Everybody all right for stairs? Yes? Yes, good, thank you very much. Right, okay, so it's Mr. Gardner, first of all, isn't it? And so he's going to be, you've got down here an hour and a half, is that about right?
Yes, I think so.
You think so? Okay. Mr. Simons, you've got an hour and a half, is that about right?
I think so as well.
Oh, good, right, okay, well. And Mr. Young, half an hour. What do you think? Well, I mean, just if you'd like to review it.
Sure, Mr. Simons will cover it.
What, so it might be longer if he doesn't, is what you're saying, is it?
Yeah.
Jolly good, all right. All right, so that'll take us three and a half. Sometime after lunch then. So
Yes.
hopefully we've then got Mr. Finch.
Yes.
So we might finish him today, depending, I think, is the...
Yeah, I did say about Mr. Finch, let me just quickly remind myself of what I said. I'd said that I think there's unlikely to be, we'll see what he says, obviously, but there's unlikely to be much I've got in cross-examine. I mean, it might be 20 minutes or something. It's not going to be an hour and a half.
Not an hour and a half.
Most of it is stuff with which we don't particularly disagree.
Okay.
It goes to the reasons for considering viability at all and things like that. Anyway, so so I mean, it would be nice to think that we could at least do Mr. Mitford Slade in chief today, but let's see how we go. You don't think we will? Sorry.
I think we will. And I think it was very helpful, Malone Friends' indication yesterday, because he indicated he's obviously got a transcript of what was there, but that they don't question why we're interested in the viability. We've explained why we're interested, and I don't think there's any criticism. And Mr. Gearing, I think says, well, this wasn't during the discussions and so on, but Mr. Mitford Slade himself produced a revised financial viability appraisal in April, reflecting the fact, in his words, that there was greater certainty over the Section 106 contributions. So if I don't have to sort of extensively justify why we're raising this issue, then that's going to save time as well. And if that's not the subject of cross-examination, we are where we are, and we have an interest in this, and we've explained why we've got an interest in this.
Okay.
We're not the local authority. We don't produce reasons for refusal, but we did indicate quite some time ago that we were, together with National Highways, commissioning a report on the highway infrastructure costs, and you've obviously seen that, and that's been provided, and a lot stems from that. And so if it's well understood why we're examining the viability, then that'll save time. And I agree with Malone and Friend, to make sure we finish tomorrow, it would be useful if we started evidence in chief with Mr. Mitford Slade.
So how long do you think you're going to be with Mr. Finch then?
I would think about 45 minutes, maybe.
Yeah, you said that. That's right. Okay, and then Mr. Bell?
I don't have any questions.
You're not going to... Right, I see. Okay, well, you never know. We might then in that case. Let's wait and see, shall we? Okay. Anything else anyone wants to raise before we start? Right, so shall we start then? Mr. Bell, if you'd like to introduce your witness, please.
So, good morning, Mr. Gardner.
Good morning.
And you're Chris Gardner. You're an associate director at Continuum.
Yeah.
And a chartered member of the RICS.
Yes.
And for this inquiry, you're acting on behalf of the Five Parishes Group.
Yes.
And you have produced an executive summary,
Yep.
which is at 42.8.3, a substantive proof of evidence at 42.8.1, and appendices, plus an Appendix 5, and a rebuttal proof of evidence at 42.8.4 and associated appendices.
Yep.
I'm going to turn to your main proof for the purposes of this examination in chief, and we're going to go through the first 4 sections quite quickly, because I want to get on to section 5, which is your section on key issues, and then section 6, which is your assessments. So turning to section 1 first, which is your introduction. At 1.2, we have the details of your background and expertise, and you explain at 1.2.1 that your area of expertise is in viability, planning, property development and regeneration, and that you've been providing viability and planning advice for around 9 years for the public and private sector. And this has included appearing as an expert in inquiries and examinations. You explain that during the 9 years you've worked on in excess of 250 viability cases, and that you've also been involved in the development of viability assessments for the direct delivery of schemes, again for both public and private sector clients. You explain it's covered areas of mixed use, town centre, residential, leisure and logistic developments, and that you have a specialism in green book valuations and have secured grant funding on behalf of local authorities where your green book valuations and assessments have been scrutinised by various funding bodies, and you've set out your CV in full at Appendix 2. We come on to a section of particular cases in which you gained some experience in. The first being as a viability expert for Trafford Metropolitan Borough Council in a cross-bank appeal. Do you just want to explain a bit more about that appeal?
Yes, I was involved in this appeal, was it a few years ago, acting for Trafford Council. I am the sole viability consultant for Trafford Council and undertake all their viability assessments as well as some of my colleagues. And yeah, basically the inspector agreed with my case that this scheme was always eminently viable and could support full policy compliant affordable housing, especially around my approach to benchmark land value. The inspector agreed with that compared to what the appellant had put forward.
At 1.2.3, you explain that you've supported colleagues at Continuum who've acted as expert witnesses. What do you mean by supported colleagues?
So obviously I supported the barrister through, assess their cross-examination, and supported obviously colleagues in terms of did the original FEAs, but my director obviously took it through to appeal and created the proof himself. Obviously stating the proof that he had some, obviously as organisations do, some help with evidence, bringing that forward in terms of data analysis and things like that. But yeah, it was his proof and his own thing.
And you note 3 particular cases, including the Warburton Lane case that I suspect we'll hear more about later. We heard a bit about it yesterday. And then you carry on setting out your experience in the last 2 paragraphs of that section. You explain in the final paragraph of 1.2.5 that in addition to the detailed knowledge of planning gain, land value capture theory gained through your master dissertation on viability in planning, this demonstrates your suitability to provide an expert assessment of matters relating to viability in planning. Now, moving on to 1.3, here you set out the PPG on viability and the relevant RICS guidance. I don't propose to take you through this, but is there anything you want to particularly highlight within the section to the inspector?
I guess probably one of the most important elements is paragraph 10, which is pretty much how we set out viability in planning, which is obviously the aspiration, striking a balance between the aspirations of developers and landowners in terms of against risk and the aims of the planning system to secure maximum benefits in the public interest. pretty much how we do viability. It's almost kind of the definition of viability per se in viability and planning.
Thank you. To be clear, that's paragraph 10 of the PPG on viability, which is the core document reference 16.11. Is there anything in particular in respect of the RICS guidance that you want to draw to the inspector's attention?
Yes. I think one of the more key parts of the RICS guidance, and let me just get to the specific bit, is around cost evidence base and the evidence required of you. One is at page 17. There is a table which tells you at the decision-making stage what you need to have.
Just pause you there. Which document?
It's CD 27.1.
Thank you. I think it would be useful just to go there quickly. Apologies. So this is the RICS guidance assessing viability in planning. And which page did you say? Was it page 17?
Page 17. Is it page 7? Oh, wait.
Sorry, it's 27.1.
Yes. Page 17.
Is that the PDF page 17?
It's the page on the document, maybe not the page on the PDF. And let me just check. It's 23 of the PDF document.
Thank you. So just carry on explaining what part of this.
Sorry.
No, that's fine.
So this is a table kind of explains the role of viability assessment plan making and development, and it basically says under this point the evidence base that is expected of you through the RICS guidance. The first column after evidence base is about plan making, and the second one is about decision making. So because we're at the decision making stage, let's focus on that. And if you look at the second sentence of that, it says FVAs will reflect details set out in plan applications in terms of the size and built form of the proposed scheme. Detailed build cost plan and schedule and values should be provided.
So we'll be coming on to this in a bit more detail at the moment, but why do you say this particular passage is important in the context of this appeal?
Because no cost plan was provided, and the original FVAs didn't even provide a schedule, the detail behind the values in terms of, so they didn't meet the evidence-based requirement of the RICS through this table. And then I'll go on, there's another more detailed bit which Mr. Spilsby did reference, which is at page 43, paragraph 4.2.15. Again, that's the 43 of the document of the PDF. So the doc is 49 of the PDF. And the key bit here is the first bullet point of 4.2.15 in the brackets when it says about expected build costs. And again, this is about decision making stage. It says a full quantity surveyor's cost report showing how costs have been estimated should be made available for site specific information. In relation to plan making, they say, yes, there's a reliance on BCS, etc. But when you're at the decision-making stage, there should be more knowledge of site-specific information, which is why the RICS expects, as the gold standard, a quantity surveyor's cost report.
Thank you. So if we can turn back to your main proof and moving into section 2, here you set out the background and context. We don't need to go through this in any great detail, but at section 2.3 onwards, you start to set out your understanding of the FVA that were carried out before we come on to paragraph 2.20. And at paragraph 2.20, you explain that attempting to clarify exactly what is being required through the section 106, excluding affordable housing, is challenging. Just explain what you mean by challenging in this context.
there's no real detailed breakdown of what the Section 106 asks are. There was no detail on the timing of the 106, which is very important. And obviously, as we now know from KCC, in terms of their timing of the highway infrastructure, it is very critical to know this. And actually, through all the FEAs, no one has really properly assessed the timings of the Section 106 in any FEA. I haven't done it, Mr. Spilsbury hasn't done it, nor has Mr. Mitford-Slade, because to me, I haven't had that information to be undertake that. Now, from my experience, I've recently involved in a strategic site in Barnsley, which has just got planning permission. The key thing when I was working from a private sector client with the council's assessor was the timing of Section 106 infrastructure, and the timing as well as specific infrastructure such as road infrastructure, which can have a massive impact on your finance costs. And there's a balance to be struck there. Usually when I'm advising a council, you don't want to ask for everything all at day one, because the scheme will be unviable, because you'll see, £500 million worth of finance costs could likely come out of a scheme of these scale. So there is a balance to be struck, but unfortunately from the information provided, we didn't know what was in the Section 106, didn't know what the timing is, so there's a lot of unknowns. And then obviously there's this unknown about what the affordable housing contribution is, because there's a bit of confusion when you look into the committee report for one of the, can't remember which site it was. I do outline it in my proof.
We'll come on to that. Moving on to section 3, can I, before we go to this point in particular, you do speak quite quickly.
Okay.
I know the inspector is trying to take a note, so if you could just, the easiest way to obviously direct your answer to the inspector, and in the old-fashioned guidance, keep an eye on the inspector's pen, and if there's smoke coming out of it, slow down a little bit. So section 3, this is dealing with the statement of common ground. Before you'd seen a statement of common ground, we received that on Monday, and just to confirm, I forwarded that to you during the session. Just for clarification, did Mr. Spilsbury send you a copy as well?
No, I have not been sent a copy by anybody else.
And appreciating that there hasn't been a huge amount of time to look at the statement of common ground, do you have any specific areas within that document that you want to comment on, or you feel you need to comment on?
The only area I think was quite important, which actually Mr. Spilsbury does highlight himself, is the area in relation to Mr. Mitford-Slade, saying that the site-specific infrastructure costs have come from the in-house QS of the applicant. Now, so if you get to the statement of common ground, assume it's under the Northern, let me just get the page. It is page 6 at the very bottom under infrastructure costs.
And this is the second column,
Yes.
sorry, the third column at the bottom. The costs have been assessed by the applicant and their internal cost consultants, excluding the interim junction section 278 costs.
So yes, this is the first time this has ever been stated anywhere in any documents provided by Mr. Mitford-Slade. So when you look at his FEA, it doesn't explain anywhere where his information comes from, it doesn't explain in his proof, doesn't explain in his rebuttal. It only comes here, obviously, from the highways. Obviously, we now see the Jacksons, the tier 1 contractors cost plan for that, but every other element, we've never seen his internal cost consultant. We don't know who they are. We don't know what their qualification is. And we don't know if it was done or isn't done, because we haven't been able to see it, unfortunately.
So just moving on to section 4 in your substantive proof. This is the section where you set out Swale Borough Council's affordable housing policy and the section 106 contribution ask as understood by you. Is there anything within this section that you particularly want to draw the inspector's attention to, particularly having heard the discussions over the past few days about the section 106 triggers, and in particular the non-occupation provisions?
Yeah, so obviously at the time, as I've already mentioned, it was not known, or it wasn't outlined in detail when these are. Obviously, as we know, I don't think the triggers, do we know if they've been fully discussed yet, but it's critically important to viability planning what these triggers are, when they are, when does the school need to be delivered, for example, what's the requirements of these 106s, because at the moment we've almost taken a very per year assessment over the lifetime of the project on these 106, all of us. We've not actually detailed look at each element and cash flowed them properly, which I would have expected usually, but when the information is not available to you, it's impossible to do. And in relation to the point about the affordable, it was the southern site where there's that issue around what is the actual affordable housing contribution, which Mr. Spilsbury did mention in his evidence in chief.
Thank you. And if we could, thank you. If we could now come into section 5.
Hesitate to interrupt, sorry. The witness is factually correct that he did not receive the statement of common ground, but upon a friend asking me on Monday, Mr. Spilsbury did send it to yeah.
So there weren't two questions, there were Mr. I wasn't sure if sent directly to him. Sorry.
Is it Monday whenever you received that? Whatever
Yes.
the day was, yes.
So
Yeah.
there hasn't been a direct connection between Mr. Spilsbury and Mr. Gardner.
No, I obviously never had the opportunity. Obviously they were discussing it last week, so I never had that opportunity to obviously just. It's exactly that. Obviously, although if required, I'm more than happy to fill in the box and help you out there as required.
The sending of a copy directly by Mr. Spilsbury wasn't meant as any criticism. It
I
was just
see.
to clarify a
Yeah,
point.
it's clarification, yes.
Yeah.
Section 5, we move on to your key issues, and I have some questions to ask you in respect of this section. You heard me yesterday put some questions to Mr. Spilsbury about his view on the quality of the FVAs that were submitted as part of the original planning application. I want just to find out from you as to what your views are on the quality of those FVAs.
When I obviously reviewed the original FVAs, I was pretty shocked. It was one of the worst I've actually seen, and I've obviously reviewed so many FVAs across the country from all manners of consultants and applicants. I mean, just for details, if you look at the Northern FVA, it was 13 pages long, and only 6 pages that actually related to inputs and outputs. And with the Southern, again, 16 pages, but again, only 6 pages related to.
Sorry,
can
microphone.
you say that?
So the Northern FVA was 13 pages long, only 6 pages actually related to inputs and outputs. The original, the Southern, again, was 16 pages long, and only 6 pages again related to inputs and outputs. And actually, this is just, there was no cost plan, there's no evidence base for sale values, so virtually all of the inputs, there was no evidence base behind them apart from the benchmark land value in terms of the existing use value. So the only area he provided some evidence base to support his assumption. I would, for comparison's sake, I'm currently involved in a planning appeal hearing for a very small 9-unit scheme in Wokingham, and that FVA, just for your information, is 23 pages long, excluding the appendices, 38 with the appendices, and that includes a cost plan to support it. So you can see that the evidence of a very small 9-unit scheme compared to these are significant scale scheme, you'd expect the evidence base to be of significance because it's quite a critical application.
Do you think it's slightly different doing a FVA for a detailed application of relatively small scale to a strategic application, outline application with everything reserved?
In essence, they're very similar in terms of the evidence base behind is that you need to be required evidence for each one. Now, obviously, yes, a detailed application, you may know more, so there's less assumptions at the stage and there should be more knowns. But in terms of the FVA, in terms of the detail required, in terms of evidence base, the evidence base should be still just as strong. And actually what I find is a 9-unit scheme or a 1,200 unit scheme, the FVA reports can be very similar length because you're having to explain the exact same sale values, build costs, everything in fine detail of those inputs.
I will. So thank you. In respect of the quality of the FVAs, appreciating that, as you've explained, that these were the worst that you've seen in your experience, the issue of a cost plan was raised yesterday and will be raised again today. What impact do you say that had on the quality of the FVAs?
For a scheme of this significance and scale, it's critical. I believe that no viability appraisal really put forward to yourself is credible without this cost consultant expertise input involved with a cost plan. I agree, Mr. Spilsbury, it is a material consideration in terms of no cost plan, no weight can really be attached to an FEA without this expertise. And actually, as we know from evidence Mr. Spilsbury, from Mr. Mitford-Slade and Mr. Earls, is that the cost plan in relation to strategic infrastructure and the abnormal cost element is critical. It massively affects viability. It is one of probably the key piece of affecting viability is this. So in terms of how much the cost is and the timing of that cost, now those two elements, the best expert to have provided that is a cost consultant. Us as viability consultants, we probably know cost to a certain level, so we can review a cost plan and say things if it don't feel right, but we would always be instructing a cost consultant to undertake this. And for example, the Barnsley case I'm being involved in with the developer for the application, we had a cost, the in-house QS started with the applicant, and I advised them to have an independent cost consultant review it just to provide that credibility and that independence. And so that's what they provided, and obviously it was accepted by the council once it was reviewed by their cost consultant. The issue for the council is they had no cost plan to review, so they couldn't instruct a cost consultant. We have no cost plan to review. We can't instruct a cost consultant. It's not the onus on the reviewer to provide this information because we aren't privy to all the information of the site, as well as just the cost implications of creating that first cost plan, because the cost plan from the applicant's side is a significant cost. The reviewing is obviously cheaper because you're not coming up with the original elements and design. It's obviously cheaper to review than it is to create from scratch.
What impacts does that have on the transparency of the assumptions and the evidence that you're able to take into account when you're reviewing?
There is no transparency around the costs, and I would pull to the fact of the Holborn Studios High Court case. I think it was 2020, about transparency of viability inputs into the public domain. We don't have any transparency of these viability inputs into the public domain. So there is a big issue. And if you look at obviously the PPG, it's clear in the PPG that there's transparency of information. The RICS, again, in terms of its guidance and professional statement, both also state about transparency of this information. I would obviously point to the fact that they have now obviously provided a cost plan in relation to the highway costs done by the Tier 1 contractor, Jackson, or JCE as they call it. So that now meets the requirements expected. Obviously now KCC have obviously reviewing with a cost expert. So that element, as we know from this inquiry, is now being reviewed, but all the other site-specific infrastructure costs, excluding highways and the abnormal costs, have not been assessed to the requirement expected of the RSS guidance, or I would say from the PPG's perspective.
Well, the cost plan for the highways, strategic highways, has been done by the county council, hasn't it?
Yes, so obviously, yes, as well as now in the rebuttal stage, obviously, as we've seen, the applicant has now produced one of themselves by JCE or Jackson's, who are, I understand, a Tier 1 contractor.
This is my ignorance, but can you just explain by what you mean by a Tier 1 contractor?
So yeah, obviously they are the main contractor who basically build out significant infrastructure of this scale. They are the largest contractors in the UK. There are multiple companies you probably know of, such as Kier, Eric Wright, other ones. I've dealt with many Tier 1 contractors delivering town centre regeneration schemes, but yes, the credibility of a Tier 1 contractor is strong to a certain extent because they are ones who deliver these things. Pardon? Tier 1.
Just so everyone's aware, Mr. Gardner may not have read it all. There's quite a lot of evidence on what a tier 1 contractor means that's coming in the evidence from all of us the week after next. Just so everyone's aware.
I will stop wasting time. Fine. Now you heard me ask Mr. Spilsbury yesterday about how he would advise the council had he seen the FVAs when they came in at the application stage. Very, very succinctly, what advice would you have given to the council?
I wouldn't have validated it. So one of my clients, Trafford, we created a viability validation checklist, and I almost say this is gold standard that all local authorities should have, and you'd almost run through that, you go, no cost plan, should not be validated, as well as there was no evidence base behind all the inputs. I would have basically gone back to the applicant and gone, please do your homework, please provide that information, that is the minimum expectations. And obviously you would have allowed the applicant to provide that information, and actually, in a sense, a point of review is to point to them and make them do the work that's required of them. So when we get to, you shouldn't be at an inquiry stage doing this work now. This work should have been done during the planning application. They've almost been given a second chance, which is highly unusual in my professional career of what I've seen.
So you've touched on that now more material is coming in respect of viability. In your view, given the material that's come in the proofs and the rebuttals, and anything subsequently, are the viability assessments up to standard?
And I welcome the comparable evidence that has now been provided, but apart from that, obviously he already provided evidence around these benchmark land values. He's provided a little bit more evidence around the neighbourhood land, so he's provided comparable there, but every other input has not really been evidence-based, so the answer is no, especially obviously the critical piece, as we said, is this lack of a cost plan for the strategic infrastructure and abnormal costs.
Thank you. I'm going to jump a little bit in your proof now, and if we could turn to 6.6 of your main proof, which is on page, it's PDF page 21. And this is the abnormal and infrastructure costs section. And I want to jump to this because it became a bit of a focus yesterday. And I want to just ask you, you've seen the site, haven't you? You visited the site.
That is correct.
Having seen the site, are you able to just set out what you consider may or may not have been assessed by the applicant in respect of abnormal costs?
So having seen the site, having discussions, obviously my client is very knowledgeable of the site, having looked at their proof, and obviously my experience of sites of this scale, involved up in one in Greater Manchester, which was delivered by a local authority. So one thing obviously you probably know is the levels. There is definitely large cut and fill required, especially around of the southern site. That is a significant cost. I would have expected, a cost estimation, a calculation of volume per metre cubed with a rate applied of how they've estimated this. Now, it's not fully clear where this cut and fill is. There's this site prep and enabling works. Then there's this abnormal cost that he puts in as well at £1,750 per unit that he kind of says is around cut and fill, but it feels light. But then there is this site prep enabling works. We don't know, but yeah, the evidence base is just lacking. Other things that almost kind of relate to the cut and fill was obviously in terms of noise attenuations. You'd be, cut and fill, you make those noise attenuation bunds, you've got acoustic fencing, lots of these things I can't see in here where these individual items would be, but you'd expect this, these costs from these mitigations, having seen the site. I know from discussions with my client that there is worry of contamination around the Kent Science Park. Now, it's unclear how that's been allowed or been incorporated in this. It's impossible to know from the evidence base. Other things that are very there are pylons on the site that need to be diverted. Pretty clear to see walking around the site. I'm pretty sure, obviously, there is the pumping station around there. I'm assuming there's sewage diversion works around that element. Obviously, I don't fully know. So there's a cost for utilities, but is there a real, what was the cost for utility diversions in that? What's the cost for utility upgrades that are on site? And we know that a new pumping station will be required, a new primary substation will be required. What's the cost for this? What's been allowed? We do not know because the evidence is not there. Utility upgrades off-site. We know that the statutory consultees in terms of National Grid will require upgrades to the grid, and we know in terms of sewage and water there is significant upgrades required from the statutory consultee there. Again, have they spoken to the consultee? Have they had discussions of their estimation of a cost? Because in my experience working on town centre regenerations, we pick the phone up to the statutory consultee and they can give you an estimation, without prejudice basis of an initial assessment of this. But again, has that been done? We don't know, and in my opinion, I don't feel it has been done. Other costs that I don't know have been accounted for. We know that there are bridges required over elements such as the stream and the railway. How has that been accounted for in cost? We know there is a significant amount of attenuation ponds, and a significant number. So again, where is that cost? Where's that cost assessment? Where is the cost per the attenuation pond? You can see in the plans there is estimation of where those are, but so they do have the detail to at least provide an estimate per the pond or per someone's expertise of that. So the final one, and this is not an exhaustive list, is the busway cost. We know that there's a busway required. That is a cost that would be over and above as normally expected of a road down, the strategic road down the development. How has that been allowed for? Where's the cost for that? And when you actually look at the costs, if you look at the southern site, the strategic drainage has been estimated at £3,000 per unit. The strategic landscape, £3,000 per unit. The ecology, £1,500 per unit. The utilities, £5,000 per unit. It's clear looking at that there's no science really behind this cost. It's been I would say, a finger in the air assessment of I'm just going to put £1 per unit without really thinking about what are the elements. And yes, it's outlined. There are all these reserved matters, but the detail can still be undertaken. You can still look at this, and a cost consultant using their expertise will go, I expect these are the elements required, and the conversations with consultees in terms of the off-site reinforcements required around utilities could be done now. You don't need the full details of the scheme because they can give you those costs. There will be estimations and allowances, but that detail could have been undertaken. But it's clear this detail has not been undertaken, and because it's not been undertaken, there is no material weight we can apply to these strategic and abnormal costs, and it's critical. As everybody has, Mr. Oz says, Mr. Spilsbury says, Mr. Mitford-Slade says, the site-specific infrastructure costs and the abnormal costs are critical to the viability. They have a massive effect on the viability, and I fully agree with that. These costs could be significantly higher. They could be significantly lower, but we don't know because, and unfortunately, Inspector, you unfortunately won't really know because the detail and the homework has not been done by Mr. Mitford-Slade and the applicant. Now, they say they have got in-house QS, but where is this work? And it's not before us, which is unfortunate. And as I said, if I was working for the council, I would have asked for that straight away and got the applicants to do the work that was required of them.
Now, just to be clear, obviously, you acknowledge that we're dealing with an outline.
Yes.
We're not dealing with detailed matters. You're saying that this critical information should be present for the purposes of this inquiry and this application.
Yes.
Can you just be clear as to why it has to come at this outline stage as opposed to as part of the detail?
Well, obviously, we shouldn't be kicking the viability can down the road through a review mechanism, which is almost affects that what Mr. Mitford-Slade almost says when he goes, it doesn't matter if I'm wrong on these inputs. There's a review mechanism. The PPG a review mechanism to review the viability. Obviously, we haven't had sight of this review mechanism, I would like to say. So,
Just on that, sorry, yes, you have. The Rule 6 party was sent copies of the 106 alongside the council weeks ago, and I'll find the emails. I say you, sorry, I didn't mean to say you haven't, but the Rule 6 party has, so I just wanted to say that in similar way to Mr Young.
I would just say, from when I looked on the 106 stuff that was on the inquiry website, there was nothing there of a review mechanism. It was less blanked. It was a blank saying, so obviously assumed it wasn't there. Now, obviously, if there was information there, I've been asking the council, Matt Diggin, to send me over the copy. He said obviously there wasn't a copy to share to me, so obviously I haven't been able to see that. But from my perspective, at this stage, is that viability should be done properly. It should be done correctly to guidance, and we shouldn't have this almost, we don't have to do it properly, we can just have a review mechanism to kick the can down the road because we didn't do it properly. A review mechanism is only there if the site is truly not viable, and we're not talking about if it's undeliverable, we shouldn't get blank consent, I agree, but if it is, 22% affordable, 20% affordable housing, for example, that Mr Mitford-Slade says, if that is the true point, then yes, there is a review mechanism, but obviously you need to do the work properly to know that, and so we can't rely on a review mechanism because the work hasn't done properly.
Just before we leave it, just for your note, the review mechanism drafting was sent to Mr Bell and others on the 7th of May.
That's the latest. Which one is
Yeah, with the review mechanisms included. Anyway, sorry, I didn't mean to cut you off.
That's perfectly fine.
Your microphone needs.
That's perfectly fine. As I say, obviously, I was in conversations with Matt, the planning officer. Is there a version that could be shared to me? And he obviously said there is no version at the moment because there's negotiations, I think, with the council and yourselves for me to have a conversation with you, hence why I put it in my proof and rebuttal. But
never mind.
as I said, I would like a right to probably have an input or create for my Rule 6 party, just create some,
we're having a section 106 session.
Yeah, assessment on that, because it is critical clear. If the answer is, for example, to you, Inspector, that it can't be policy compliant and it's not undeliverable from Matt Spilsby case, as in the scheme is deliverable, then the review mechanism is critically key, and there are requirements of the PPG and the RSS how they should be done. So I need to check to ensure it's been done properly as requirements of the PPG.
So we've touched a lot on highway costs, and you've listed a number of other points or costs that should have been included by way of abnormal costs. What do you make of Mr Mitford-Slade's abnormal and site-specific infrastructure costs?
In relation to... Well, as I've said, it's when I've looked at them in terms of a per net acre basis, £600,000, £500,000 per net acre basis, including all those elements, they are high, but they are not the highest I have seen. But I would agree they are on the upper end, but they're not crazy. In that, and it's a common assessment for fibre consultants to look on these costs on a per net acre or a per gross acre basis. It's more important in relation when you're looking at benchmark land value. But I agree they are significant and high, but they are not obviously the highest I've seen. But obviously, for example, brownfield sites, you can see specifically a lot high in touching the millions. Now,
obviously had Kent County Council's assessment of highway costs. And do you want to comment on those in particular? Kind of what impact they have in your view as the assessment of Mr Mitford-Slade's costs?
I mean, the KCCs, obviously I'm not a highway expert, but as you said, looking at the costs, they are significantly higher. They have a significant impact, especially when putting the scoping and additional risk elements into it. It's not something unheard of. I've seen it before. I work, as said, in town centre regeneration. I work on county highway costs, section 278s all the time, so I see these costs at early stages, but yeah, it's significantly higher than the cost, or at least the original cost that was presented to by the applicant, which was before they got a cost consultant in. Obviously, it's still higher now from the rebuttal cost by Jackson or JCE.
So we have the highway costs assessment by JCE. I don't think we need to turn those up at the moment, but they for the northern site it's CD 37 14.2A, and that's a kind of a sum of £34,381,200 odd, including professional fees, contingency, and commuted sums.
Yes, that's correct.
And for the southern site, it's 188,693,355 odd, again including professional fees, contingency, and a commuted sum of around 20,000,075.
Yes, that's correct.
Now, has Mr. Mitford Slade, in his appraisal assessment, inputted these costs into his northern site appraisal? And I think it's. Oh, sorry. I'm focused on things other than the traditional fire alarm engine that we seem to have. Traditional. We haven't had the. We've not had the motorbike for a while. So sorry. So I think now, if we turn up the applicant provided a document which is CD 37 14.4A5, which is Appendix 2 to the Quantum Report updated side by side, I think is the title. Yes, madam. It's 37.14.4A.5. Yes, .5 I think it is, and it's entitled Side by Side Comparison Dadswell Costs v Jackson's Costs. I think it's an ID. I don't know if it's been.
It's an attachment to the rebuttal of Mr. Gearing. It may be easier to see it on your computer because you may have to zoom in because it's one of those A3 PDFs.
Sorry, it was forwarded to us yesterday by Mr. Kernow.
What was it again? I'm so sorry.
37.14.4A.5.
Right.
It may have another number because I've seen the number as CD 37.14.2A.4.
Oh gosh.
So. Yes.
His second rebuttal. So this is the one from
Oh, have you?
one from yesterday. 37 point.
Pinks and blues.
Pinks and
Bit
blue.
of green thrown in.
Hooray. Point 5, I think, wasn't it? Point 5 at the end.
Yes.
Yeah. So it should be. That's all.
It's effectively a 2-page document. Lots of relaxing colours.
Where we are breaks them down into, I don't know, can you see the bar chart on the bottom right hand? On the second page there's a bar chart. Oh right, bottom right hand. Yeah, the bar chart is a sort of summary of everything on that page, which it tabulates what the differences are in M2 south north, and then breaks them down into construction, non-construction, contingency and risk allowance. So it's a very high level sort of try and squeeze it into a page where things stand on costs, which obviously we'll get into in 2 weeks time.
Well, the fact is this will need a bit of looking at.
Of course. No.
I don't know if I'll understand the questions you're going to ask.
Well,
Not
Mr.
you.
Gearing will obviously go through this in his evidence
I
in
know,
a couple of weeks.
I know, but what you're going to ask.
So, Madam, yes, the question, we felt this was a fairly useful table to reference in respect to,
Right.
in respect of the northern and southern sites. When we're talking about the new highway costs assessment by JCE, has Mr. Mitford Slade, in his appraisal assessment, inputted these costs?
No, he's
So
input.
if
sorry.
you could just explain, if we do it site by site,
Yeah.
if we deal with the northern site first, just explain your answer.
So for the northern site, which is the far furthest table in the pink at the bottom, you can see a total cost of professional fees, contingency and commuter sum of 34,381,200 million and 28 pence.
So we're on the first page.
On the first page.
Yeah.
So you have got this. You haven't literally got it. The programme officer has it for you in hard copy. I don't know if that.
I
if
have
you
got a
want.
hard copy, but
Oh,
it's
right.
quite small, isn't it? I
Fine.
don't know if
I'm
I
not
can
sure.
read it.
Fair enough.
30. Well, I can see on the bottom right hand
Yeah,
column there's 34.
Yeah, £34.38 million. Now, when you look at Mr. Mitford Slade, he doesn't create a new appraisal in his rebuttal. So obviously these costs came at rebuttal stage. He doesn't redo his northern appraisal. His northern appraisal's costs in relation to highways, when you add in the professional fees and the contingency, gets to 39,605,500 million. So let's say 39.6 million. So there's a difference of around about £5.2 million between JCE or Jackson's assessment of highway costs and the actual costs that Mr. Mitford Slade has put forward before the inquiry. Now, as we know from Mr. Spilsbury, a shift in £4 million has a massive effect in affordable housing. £400,000 as 1%. Now, this is a shift of £5 million. Again, there will be further impacts on finance costs because if you reduce the cost, etc. So clearly, there is not an appraisal before you, Inspector, that actually relates to the Jackson's costs at this inquiry. And actually, if they were in this, the northern site should have been rerun at a significantly lower cost at this current stage. Now, I know these costs may change, as Mr. Simmons has said, at later date. So, but yeah, at the moment, the Jackson costs have not been run correctly in appraisal. Now, obviously, I haven't run an appraisal on this because it came at the rebuttal stage.
Sorry, what did you say?
I was going to say that I'm sorry. I wouldn't mean to. It was suggested that I'd said that these costs were going to change.
Oh, they could change. Sorry.
I wasn't
yeah.
suggesting that at all. I was suggesting.
You weren't.
I wasn't. I'm just saying this is the evidence that we put in yesterday. Is what I'm saying.
My apologies. There may be some difference. Yeah.
There's no new evidence coming at all.
So will we get a new appraisal with these figures in or not? Are we expecting that?
No.
At the moment?
No. No more appraisals. No more evidence on costs. No nothing. It'd be too late. I mean, we can't. This is the viability evidence this week.
Always do more. An application.
Well, it's an
It's not
inquiry
a-
as well,
it's not
though.
a
I mean,
deal.
well, I appreciate that, but I mean, this is the week, as you said yesterday, or was it the day before, that we're supposed to be examining the evidence on viability.
I'm only asking.
So it's not exactly this new cost evidence. That's a bit.
Exactly. Well,
You'll appreciate our position, which is, that's new evidence on costs, which feeds into it. We've got a separate session on costs. costs.
I know we have.
So that's fine. But, whatever comes out of that, or whatever we say, or what my cost consultants say, they've got their costs. They've said all that out, and I'm sure they'll probably, well, I can't speak for them, can I? I haven't had a chance to look at it, but it could have implications for viability. There's two types of implications, though, and I perhaps didn't make myself clear yesterday. If you'll forgive me just for a second, Mr. Bell, that's right. One is something where we could just put in a note, where we say, yes, that moves that part, and the implication is this. And that, that's often, or that in my experience, happens at inquiries. You don't need to reopen the inquiry, or you don't need to rehear evidence, because it doesn't have a dramatic effect. If there are more significant consequences, I don't know what this evidence says. We have received it, I should be clear, I haven't read it myself. Does it have implications? Is any ground being given? Are the costs, I think what I picked up, are they shifting £5 million? Are they lower on the northern side? I don't know. So I'm just laying down a marker about that. For our purposes, though, we're happy to deal with the costs in that cost session. And I've made that absolutely clear. Also make it clear I haven't read Mr. Goodwin's, and I didn't know there was more evidence from Mr. Gearing, but it sounds like there's another rebuttal from Mr. Gearing as well. Yeah, okay.
Can I just add a point that this PDF was actually provided in Mr. Gearing's original rebuttal. So this evidence wasn't the evidence that we've received on the Monday, Tuesday.
It's actually an updated version.
It's an updated version.
Same idea.
But it's the same. It's got the same figures, isn't it? The same total costs. Yeah.
So thank you. So I think we were dealing with the northern site.
Yeah.
Is there anything you want to add in relation to what you just said, or should we move on to the southern site?
Yeah. So obviously, as I said, northern site. There's obviously a £5 million over too high. His costs in his appraisal. It was basically around £5.2 million too high, his northern appraisal, because it doesn't reflect the JCE costs. He didn't attempt to update in his rebuttal his northern site, where he does on the southern site based on the JCE costs. We'll come to that in a minute. And obviously if he'd done that exercise, his output would have been significantly different. And as I said yesterday, Mr. Spilsby said, £400,000 is 1% affordable housing on the northern side. So you can see that's a significant factor.
And so the southern site?
So for the southern site, it's a bit harder to you have to add the two numbers together. So I've kind of done that exercise in terms of the 58.3 million and the 137.2 million, which gets to we'll just do rounded, £188.7 million. Now, again, unfortunately, Mr. Mitford-Slade has put a different figure in. This time, it's lower. So he's put £167.5 million in his rebuttal-based appraisal, which he does state this is based on the Jackson costs. It's unclear why he's now £21.2 million lower than the Jackson cost that he says he relies upon. I know there's arguments about commuted sums, but even when you look at the commuted sums, it doesn't look like that's the difference. So, yeah, again, his appraisal does not reflect the Jackson's costs. Now, for the southern site, it's different in this regards. The costs are higher, which means the viability position is worse based on Mr. Mitford-Slade. So it's not his affordable housing contribution should be lower if he actually put in the Jackson costs. So yeah, this is just question the expertise around this cost element when there are these mistakes here that I would, in my opinion, are pretty simple to spot. You get a cost, you see the total cost, you put the correct cost in. So obviously his mistake where he said he's used the Jackson cost, but he hasn't, because he's used a cost. He's used a cost that's £21.2 million lower, even though in his rebuttal appraisal he says he uses the Jackson cost.
So Jackson do another assessment which was different?
No. So Mr. Gearing's rebuttal provides Jackson's assessment. in the rebuttal at the time, Mr. Mitford Slade says he's used that cost in his appraisal. When you've added it together for the southern site, he doesn't do this for the northern site, he only redoes appraisals for the southern site, bit confusing. But when you do that exercise, there appears this mistake of £21.2 million of his cost is lower, so and it's unclear why. He doesn't state why or anything there, so in reality his appraisal should be based on a higher cost of the rebuttal when he said he was using the Jackson costs, and if he'd done that, the viability of his output would be significantly different. It's a bit, yeah, numbers a bit numbery.
Thank you. I want to ask you about the robustness of a viability assessment which hasn't included a full detailed cost plan of the abnormal and site-specific infrastructure costs. What's your opinion as to how robust such an assessment can be?
As I've stated earlier, it's not robust. It can't really be relied upon. There's no weight really that can be attached to it. And this is the issue for inquiries, that in relation, you could put the highway cost to one side. None of us have actually provided a robust enough viability appraisal because we are relying on, in my opinion, flawed costs, because there is no evidence behind those costs as required by the RSS guidance.
Thank you. Is there anything else you want to draw the inspector's attention to in respect of abnormal costs?
No.
If we can turn back to your substantive proof, and at this stage it's probably also helpful to have your rebuttal open. And I want to take you to paragraph section 6.2 of your substantive proof. Which starts on PDF page 13. This is the section relating to residential sale values. And in your rebuttal proof, you deal with this in section 2, I think it is, market sale values.
That's correct.
We just have those two passages open. I want to ask you to be clear as to what your assessment of market sales values is, and how does that compare to Mr. Slade and Mr. Aust's assessments?
So yes, I've done a detailed comparable analysis and actually a detailed individual site assessment of value. So I've not just taken general ranges, I've looked at specific comparables that relate to that specific unit type and attached a value to it, as outlined in my rebuttal.
So, and in respect of your rebuttal, are we talking about the table that can be found on the tables that can be found at PDF page 8, section 2.18?
From basically page 7, you can see I highlight individual units and highlight how that relates to, for example, small 3-bed units. Here are the specific comparables that relate to that I believe are comparable, and this is how I get to my value when taking account of incentives. So it's very detailed and very clear. I've gone this unit, these sites, this bit for that. It's not looking at a general assessment of a scheme which can basically lead to false narrative, because different unit types and mixes will have different values, story heights will have different values. So you have to always look at the detail. You have to look, as well as Mr. Mitford Slade, for example, has basically not provided for his comparables what the unit types are. Are they semi? Are they detached? Are they terraced? What story heights they are? And it appears he's relied on EPC ratings for areas which is known to be it's not reliable. I've basically gone through Planning Portal on each of those schemes, as well as the house builder's website, to accurately assess the areas the units, what beds they are, what types they are. So I've done probably, in my opinion, the most detailed assessment of those comparables. Now, probably getting back to the original question, is my value assessment is similar to Mr. Olst, slightly higher, but it's at £401.62 per square foot for the northern site and £401.47 for the southern site. Mr. Olst was at £400. Now, as we know, Mr. Mitford Slade and now obviously Mr. Spilsby has now said through his statement of common ground that they're at £390 per square foot for the northern site and £395 per square foot for the southern site. Now, for a scheme of this significant scale, you know, you don't have to change the values by much to make much of a difference. You know, got over £1 million square foot of GLA. You add £1 a square foot to, let's say, a million. That's £1 million shift. So there are significant shifts in small changes in values, which will make a big impact on values.
And in respect of the amounts reached in the statement of common ground, what's your view on the adequacy of them?
Well, we're looking at, you know, obviously Mr. Spilsby, he hasn't provided a detailed comparable assessment, so I'm not sure what he's done, so I can't comment on that. Those not one to the inquiry, but obviously Mr. Mitford Slade has. Now, there are asking price data is the lowest in category A data in the hierarchy of evidence, but it's very crucial because it gives a tone of value of what house builders expect. Now, house builders typically sell within the asking price data. They usually use incentives, you know, so you have to take account of incentives of asking price data, which I have done.
If I can pause you there for a moment, I'm going to ask you
Yep.
ask you to take the inquiry through the comparables you've assessed, and if you can do that by reference to your proof of evidence or your rebuttal, that would be helpful. I'm slightly hindered in that my Acrobat is frozen, so I can't move from any pages, so I'm going to try and sort that out. But could you just take the inquiry through your comparables and how you've assessed them?
Yeah, so obviously, just to finalise that bit, in terms of Mitford Slade, when you look at his comparables, most of his comparables are historic. They're over a year old. He's relied on indices. Now, in the RSS guidance and comparable evidence, that's called a category B evidence. So historic evidence or indices are category B. So in the hierarchy of evidence, they are seen as less than a category A evidence, such as asking price or very up-to-date schemes. So that's one thing to add. The other thing to add, as I've always mentioned, is that, you know, he's relied on EPC data for areas which we know is inaccurate. He's not provided the beds, the types of units, the story heights. Now, a critical thing around story heights is 2.5 story, 3-story units will have a lower value than a 2-story unit. Usually around 85 to 90% of value. On the flip side, the build costs of a 2.5 and 3-story unit is typically 85 to 90% lower. Otherwise, why would a house builder build out those units? But my opinion is the cost assessment is only really looked at more the 2-story. So as at Warburton Lane, for example, we only really focus, and a lot of time you only really focus on 2-story dwellings, almost ignore 2.5 to 3-story, assume everything's 2-story, because in reality, if there is 2.5, the build cost will be lower to the reflective nature of values typically in the marketplace. Now, in terms of my evidence, as you can see from in my rebuttal at page 7, for example, or I think it even starts at page 6. If you looked at my appendix 5, you can see the detailed outline of every single comparable, the beds, it's detached, it's 2-story. I've provided the asking price. Nobody else is providing an asking price. I've only provided data since January 2024. Relying any further than that, I think, is too historic in nature. And then what I've done is I've obviously highlighted unit types. So for example, if you look at 3-bed small units, I've looked at the Archford Applegate unit, for example, 832 per square foot, and shown that the asking price is at £460 per 72 per square foot. The Letchford Amberfield scheme, for example, I've looked at that unit type, the Barton at Oakwood Meadow. So you can see for 3 beds, I've done that exercise. For the 4 beds, larger 3 beds, I've done a similar exercise. For the 4 beds, I've done that exercise. So you can see I've provided detailed, specific unit types to attach a value to the unit types we have seen. And as I said, looking at this from here's a scheme, the average value in that scheme over 4 years is X. That's inaccurate. It doesn't show a reflective nature because there's different scheme mixes, there's different types, and there's the historic nature of the data as well, especially when you look at asking price, tone of value. I have also, I would point out, factored in incentives. So in my opinion, I've done the most detailed comparable evidence here. It's really outlined in here, each individual unit, each value specifically done as to how I've got to those values. Mr. Mitford-Slade, for example, provides all his comparable evidence and says, based on that, I'm going to X, and doesn't say how he's gone from A to B. So we don't know the steps he's taken. He's just presented data and gone, I give you this. Where I've presented data and showed you the step of how I get from A to B, which I think is critical of what a surveyor should do. The final point, and I may be jumping above you, is the location of the scheme. Markets, towns, areas like this are very sensitive to specific changes in location, which is why I provided the heat map, for example, at Appendix 4. So Sittingbourne, there's different values in the area, as you can probably see from the heat map. The north of Sittingbourne is a lower value area than where this site is located, which is in the south, especially the southern site down that way by Highsted is pretty much the highest values you will see in Sittingbourne. It is the highest value. It is, people will expect to pay more for a house in the southern of Sittingbourne than the north. So Mr. Mitford-Slade, has relied on all his comparables. Mainly, most of the comparables are in the north of Sittingbourne, and he has not stated how he's factored that in, how he's taken into consideration that, hang on a minute, most of these schemes are in the north. Most of these schemes are pretty much located slap bang in the middle of basically warehousing distribution. Now, obviously, yes, we've got the Kent Science Park, etc. But so they're in the lower value area of Sittingbourne. So that's why my values, I would argue, are always going to be higher than the northern comparables, because we are in the highest value area in Sittingbourne, as shown by the Heath Price map, as shown by my data comparable evidence, also shown by one of the other schemes in the south, the David Wilson Home scheme. Again, I would argue it's slightly lower value than the site where we are, but that has higher values, for example, achieved than the north of Sittingbourne. So it's critical clear that you need to look at the comparables, but you also need to look at the location differences and the difference in values, and that's why heat price map piece, a house price heat map is very good as a visual aid to kind of as a starting point to really understand that, because obviously people will know that if you're a local from Sittingbourne, you'll want to live in, and you'll want to buy a higher house price. You will buy a higher house price based on the higher values that people are paying in the south, especially the southeast, compared to, let's say, the north. So that's a critical piece that is lacking for Mr. Mitford-Slade, and I am the only one who's actually done that analysis on top of my detailed site type specific analysis, and that's how I get to my value, which is not too dissimilar to Mr. Ulst. It is slightly higher, but then Mr. Ulst hasn't viewed. I'm not sure he's updated. Oh no, he has updated his comparables in a document. But yeah, it's only about £1 per square foot, which does have a major implication. But yeah, similar risk, but a bit higher. But yeah, it takes into account the location, the unit types, and a really detailed assessment of the comparables, which is required of us.
Thank you. You set out some of your concerns in respect of the assessment of value that Mr. Mitford-Slade has arrived at. Is there anything else that you want to draw the inspector's attention to?
I pretty much covered it, as I said earlier, about the EPC, the unit types, etc. No asking prices, so it's pretty much that. So yeah, it's in my rebuttal, but yeah, I have covered it satisfactorily. Thank you.
Thank you. And in respect of how Mr. Mitford Slade has dealt with any of this evidence between his original FVA and the updated viability evidence and inquiry, is there anything you want to raise with the inspector?
Sorry, in relation to?
In relation to Mr. Mitford Slade and his original FVAs and the updated evidence.
So obviously in his original FVAs, he didn't provide any comparables. So, which is the bare minimum expected out of a survey. You can't be given a value without comparables. I mean, it's critical clear in the RSS guidance. You need to provide a comparable. That's even before the cost. That's the gold standard, especially as a viability consultant where you are a specialist in values. So yeah, that never provide that evidence, which is critical clear. And obviously, yes, in the rebuttal, he does provide the evidence, but as pointed out, there is flaws in how he has done that. The one thing I would point out is that Mr. Mitford Slade, in his original FEAs, says that if you add placemaking premiums to my values, you get to around about £400 a square foot. I am interpreting it that I probably may be useful trying to look at the document, but he basically says he expects values to be about £400 per square foot to be achievable as the market improves and an element of placemaking is added to the scheme. So he says this in his original FEAs. Now, obviously, in his updated proof and rebuttal, he now argues he is taking into consideration placemaking premium. His northern site, he hasn't changed the value. So he's gone, there is no placemaking premium. Originally in it's 390, there is now placemaking premium, it's 390, though I do say if there was placemaking premium it should be 400. So there's a contradiction there. Obviously in the southern he has changed his position on values. He's gone from the 390 to the 395, but again there is this argument around, he says in his original FEAs, I expect values of £400 per square foot to be achievable as the market improves and an element of placemaking is added. So there seems to be this contradiction between his original evidence of value and to his rebuttal and his proof.
Now, I want to turn to neighbourhood centre land, which is something you raise as one of your key issues in 5.4, but you discuss in detail in section 6.4 of your proof, where I think it's kind of lumped together with commercial land values, and you also discuss it in section 3 of your rebuttal. I want to be clear as to what are your concerns about the way neighbourhood centre land has been dealt with?
So there was no value attributed to neighbourhood centre land, which I find highly unusual. I know Mr. Spilsbury has mentioned Gilston Garden Village. I know that Turner Moram, in their assessment of the southern site, applied values to the neighbourhood centre land, and they actually applied a value to the community uses at a significant value. It all, as a developer, unless there's an imposition from the planning that you've got to provide this land for free, as a transfer, a developer will seek optimal use and will seek optimal value from their use within the neighbourhood centre land. So I was shocked that there was no value attributed to an area of land that will always have value. And obviously, as Mr. Mitford Slade, he's rightly corrected his assessment to say there should be value, but he's only corrected for the southern site. There still is not a value applied to the northern site neighbourhood land.
And how have you approached the valuation of neighbourhood centre land?
So, look, I agree there is a very lack of comparables for this. So the only comparables I could obviously find at the time was convenient retail stores, Aldi, Lidl type stores, which gave an assessment of, this £1.9 million an acre. I take into consideration Mr. Mitford Slade has now provided some evidence of some different use mixes. So obviously, I think his one was nursery use with some retail use, which is £500,000 per acre. So I did in my rebuttal undertake a sensitivity at a lower value of £950,000 per acre, kind of a blended approach, reduced down by half. Because yes, I do recognise there are a mix of use, but a developer, and RS's guidance is all about optimal development. A developer will seek the maximum value they can. So there will be convenience store type mix in this. So there will be these £1 per million pound per acre sites. I do concede there probably will be some lower uses of the retail. So the 1.9 I concede is probably a little bit on the high side. It's good I've done my sensitivity analysis on this lower value of about £950 per acre, which is kind of a midpoint position between the two. As I mentioned before, this Gilston Garden Village, interesting enough, the values they adopt are very high. I've done a residual valuation method, about £5 million per acre for retail, £3 million per acre for D1, former D1 uses, and 1.4 million for the community uses of D2. So you can see there can be high values attributed to these land, and consultants have adopted high values before elsewhere. I agree it's hard comparables, but there is a value to this land that should be attributed. It's likely my sensitivity analysis at 950 is probably more the cautious, more sensible assessment than my more, I agree the 1.9 was probably a little bit more optimistic.
Thank you. And just to be clear, can I take you to page 18 of your substantive proof?
Yeah.
And there's a table under 6.4.11. Are these the neighbourhood centre land comparables that you've used?
Yes, that's correct.
Thank you. Commercial land values, which are within this same section. Just want you to explain what your assessment of the commercial land values is.
So obviously, the one thing to take into consideration, there's a significant difference between service site and an unserviced site. So what a developer will pay for a service site is significantly, especially service site with planning, is significantly higher than what you would pay for an unserviced site. You know, take a house, you're not going to pay the same value of a house that has basically nothing in it, needs work to be done, compared to a house that's, you know, turn and key, completely done up to scratch. So land has a similar thing. If you've done the work to the land, which is what is being assumed in the appraisal of the site infrastructure costs, the allowance for servicing of the site, the values will need to be different. So it's critical clear when looking at the comparables, knowing the difference between serviced and unserviced. So I'm still the only one to have provided comparable evidence of this use, until obviously Mr. Spilsby has provided one comparable in his statement of common ground. And basically I looked at the comparables and applied an assessment in relation to service, because they were not service sites.
So if we have a look in your substantive proof, page 17, there's a table under 6.4.6.
That's correct.
So these are the comparables that you've used?
Yes, that's correct.
Thank you.
And then From my understanding, when I've reviewed them, I do not believe they're on a fully serviced basis. No, not to the same extent. I know Mr. Mitford Slade, for one of the comparables, questions, and I'm sure he will get to that, whether one is serviced and one isn't. I would also take into consideration where they're located compared to where this site would be. I know from the socioeconomic evidence, evidence from on Monday and etc., is that, this site is, especially around the Kent, there's high demand. To meet this, there's I also will understand that from the socioeconomic evidence that was provided, that the use that they believe is actually going to be provided is mainly B2, B8, advanced manufacturing, industrial, warehousing use. So they put forward, that's their opinion, it's mainly that use. So that is the assumption of my value on industrial warehousing use, which kind of matches up when I reviewed the Savills document. Can't remember the specific reference, and obviously hearing the inquiry of the socioeconomic evidence they put forward to you. I've also, in my rebuttal, provided some further evidence base, which kind of reflects service land values. So LSH.
Can I just pause you here for a moment? So I'm going to come on to this bit now, but in respect of the evidence to support your approach in respect of commercial land values, there was some criticism of your approach by Mr. Spilsbury. Now,
Yes.
I think you were about to bring us on to your rebuttal proof, page 11 at 3.4. Were you about to start discussing the LSHs?
That is correct.
Right, so thank you. So if you could just take us through that by reference to the rebuttal.
Yes, so obviously I provided some more evidence base. So you know, a lot of the big surveying firms provide a assessment of development value for logistics and industrial land. This is LSH's one, Q4 2024. And what they helpfully do is usually these land values are done on what they call almost a greenfield basis, which is pretty much a service basis. And as you can see, in Thurrock, for example, they estimate that the average land they expect of an industrial and logistic land, you know, on a service basis, there's no abnormal costs, etc., of £2.75 million per acre. And unfortunately, they do the southeast, but they don't cover Kent. Obviously, they cover Thurrock and Essex. But as you can see, the lowest values they argue for industrial logistics in these key centres they highlight is Milton Keynes at £1.4 million per acre, and obviously then there's Luton at £1.6 million per acre.
So at 3.5, this is where, sorry, in your rebuttal proofs, this is where you explain, because LHS doesn't provide values for Kent, that you've taken these as being similar locations.
Yes. Sorry.
So
yes.
Can you just explain why you think they're suitable similar locations?
In terms of logistic hubs, as we know from the socioeconomic evidence provided, the positives that were, you know, presented by the applicant in, you know, the demand, especially around the Kent Science Park, for these uses. There's high demand. It's linked for motorways. It's links to ports. I know Sittingbourne has a number of ports. So it is in a key area. It's location to London of a industrial logistics type hub, advanced manufacturing type hub. So that's why I believe, you know, it should achieve values, you know, Milton Keynes, Luton, etc. There's similarities, and that's why I think, you know, this supports the value I assumed in my appraisal.
Thank you. So having applied value to the commercial land for both sites, has Mr. Mitford-Slade done the same?
So he's obviously applied value to the southern site, but for the northern site, he has not applied any value whatsoever to the element of the northern site. That is highlighted in the development structuring plan.
And is there anything else you want to say in respect of Mr. Mitford-Slade's kind of the value he's attributed to the southern site in respect of commercial land?
So obviously, yes, you know, in light of comparable evidence I've provided, he has shifted. I assume it's in light of, obviously he can talk on that, but he's shifted his evidence from £400,000 per acre to £700,000 per acre. So, you know, he has agreed that he didn't provide any comparable evidence, and considering that, there's adjustment to be made once you start looking at the evidence. Obviously, it's different to me.
So thank you. Turning to standard build costs, which is section 6.5 of your main proof and 10.2 of your rebuttal, just want to be clear as to what your approach was to base build costs.
Yes, so the approach I've taken to base build costs is approach similar as the Warburton Lane appeal. And it's similar to cost consultants across the country now take the Rossendale local plan assessment in relation to the weakness of BCIS data. Basically, you know,
if I can just pause you here for a moment. So Warburton Lane, it's already been raised. I just want you to explain as to why you adopted the approach that was taken in Warburton Lane and what that approach was.
So I've taken adjustment down to the lower quartile BCS figure, as was done at Warburton Lane appeal, as was also done at the Eves Green appeal, and actually as based on my experience of house builder costs across the country, recently involved in schemes in Wokingham, recently schemes up in Lancashire, all across, is that house builders do not supply data to BCIS. You can see this through my analysis. So I have analysed BCS data from 2019 to present day, as outlined in my proof, And from this analysis, basically all of the data comes from contractors delivering schemes on behalf of local authorities or registered providers. And the issue is that there are economies of scale achieved by house builders, as well as the overhead and profit is factored in from a house builder elsewhere, aka they undertake the contractor and developer role themselves, as highlighted in the Warburton Lane appeal, and therefore, incorporating this overhead and profit is double counting because it's incorporated in the profit margin, which was highlighted in the Warburton Lane appeal, highlighted in the Rossendale local plan assessments, as well as many other local plan assessments by cost consultants I know of.
Can you just be clear as to what was your adopted standard build cost?
So my standard build cost, what I've done is I've looked at a blend between houses, so 2-storey estate houses, as well as apartments. So I've done 3 to 5 storey apartments. I've taken the lower quartile figure. I've applied adjustments to that figure to account for the embedded overhead and profit that should be stripped out as per the Warburton Lane appeal. Some house builder efficiencies. You've got the economies of scale. For the northern site, we're looking at over 1,000 units. House builder has significant economies of scale. I then applied a 15% external works, which is agreed pretty much now, I believe, between most parties through the statement of common ground. I've then applied future home standards at £5 per square foot based on my experience of other schemes, and that's how I get to my blended build cost between houses and apartments based on the mix at 142.50 per square foot.
Have you undertaken any sensitivity assessment in respect of your standard build costs?
Yes, so I've also taken sensitivity testing where I've not adjusted by house builder efficiencies, so that increases the cost to 149.37 per square foot. And then I did a final one which was just based on lower quartile BCIS, which is pretty much the opinion by Mr. Spilsby, for example, though he has a couple of things extra, and I get to 160.20 per square foot, which is higher than Mr. Mitford Slade's when you include what I govern is his standard build plus the external works on plot infrastructure costs. I know was discussed yesterday. He has a 150. You add that £6.70. I say 78. It's 79. It's around that figure, and I get to his cost of 156.78. So my highest cost sensitivity test at 160.20 per square foot is higher than his figure. So I have tested costs a range and of above Mr. Mitford Slade just to take a stand back approach and view costs at different levels.
Yeah, are you able to set out what any substantial difference is in between your cost assessment and that of Mr. Mitford Slade?
I haven't got the figure of the top of my head. No, I do. Sorry, apologies. For the northern site, it's about £17.8 million once you include professional fees and contingencies. So it's a significant amount. Again, as you say, from the £400,000 is a 1% affordable housing. That can make a massive difference. For the southern site, the service land value appraisal, so we're just looking at a 120 unit scheme, the difference is £1.6 million when accounting for professional fees and contingency, which is about 13,000k, so £13,000 per plot of land value. So again, it is significant. I would also point out that, again, when we looked at the RSS guidance, it does ask applicants to provide a cost plan of how much it costs to build a house, etc. The applicant is a house builder. They could have provided that detail to us, but it was not provided.
So what did you said that there was a difference on the northern site of 17.8 million.
Yes, that's correct.
What was the difference on the southern site?
So for the southern site, because of the way they've done it from this master developer service land value assessment, on that appraisal, which is the hypothetical 120 unit scheme, the difference is £1.6 million. Now, how that affects the land value outputted from that is it basically means that there's a £13,000 per plot roughly land value difference between adopting my lower build cost assessment and Mr. Mitford Slade's. So obviously when you multiply that out by selling, all those residential houses at the southern site, it's a significant difference.
So what you're saying is that per unit, per service plot, which is 120 units, the difference is 1.6 million.
Yes,
Right?
but obviously we're selling 7,150 units.
Yeah, no, I appreciate that. We ought to have a break. I don't know how you're getting on.
I'm over 2/3 of the way through, so I'm going to be a bit over, but I think it speeds up a bit.
You've
the
done your
latter bit.
hour and a half now. Okay, so, well, we will have a break, I'm afraid. So we will have a break until, well, it's going to have to be till 12 o'clock. Thank you.
Till what time? 12 o'clock. James, do you want to have a quick catch up?
Chris, I don't think we're not going to do much today.
Yes, sorry. I've just sent section 106 over.
It's now 12 o'clock, so it's time for the inquiry to resume. And so we'll just keep the air conditioning on low, shall we? Like it is, because it got a bit warm. I don't know about anyone else. Yeah, I think it was turned off, wasn't it? So no, don't turn it off. Leave it as it is. Just leave it as it is, Mr. Gehring. I think if people can't hear, please say. Right. Okay. So you think what, another half an hour?
I think that's another half an hour to 40 minutes.
Or could you try and keep it to half an hour?
I'm going to try and kind of get succinct answers.
If you could, because otherwise we're going to run into trouble.
Yes.
Yeah. Okay. Thank you very much.
So thank you. So, Mr. Gardner, I want to turn now to finance rates and cash flow. So this is dealt with in section 6.11 of your main proof and a short response in your rebuttal at 6. Now, succinctly, can you just set out your approach to the finance rate you adopted?
Yep, so I'm the only person who's actually provided evidence to support my finance rate. So I've actually provided some supporting FEAs of strategic sites, one of 1,200 units and one of 1,800 units.
And they're found at 6.11.3 of your substantive proof at page 26?
That is correct, and I've basically taken the midpoint of those. The point I would add is that these are, in terms of the northern site and the master developer, these are schemes that are delivered over a significant amount of time. So for a strategic site of this scale, the approach to finance rate is looking at what's the finance rate now, but also looking at what's the estimated average finance rate over the economic cycle of that period. Otherwise, you're given a false outcome because these sites are delivered over a significant scale over economic cycles. So it's better to have a blended approach, which is the approach I believe was taken by these two strategic schemes and an approach I've taken. The one element also is to include a credit rate, which is an approach that the district valuer takes, which basically means when there is some revenue and when you've got a surplus in your cash flow 1 month, basically you get a bit of a credit rate, like you would if you had your ISA. You get a couple of % in the bank, so that should be applied as well.
So thank you. And I think, what's the finance rate you adopt for the northern site?
So I adopt 6.5% with a 2% credit rate.
And the southern site?
So for the master developer, I again adopt 6.5% with a 2% credit rate. But for the service land value, now because this isn't as big scale, it's a smaller scheme, it's 120, I've taken a higher finance rate of 7% and a 2% credit rate.
And at 6.11.13, you start discussing kind of main cash flow areas. I just want you to explain to the inquiry what are the issues you take with Mr. Mitford Slade's cash flow assessment?
Obviously, it was hard because there wasn't really much. The detailed cash flow for the northern site wasn't around at the time, and the southern site it was there, but it wasn't the easiest to digest. But my main issue, especially around the northern site, was the assumption that all of the land would be bought at month 1. Significantly different to the southern site, but so for the benchmark land value, that all came in, or the residual land value, all came in at month 1. Now, in reality, the RSS guidance is about optimal development. What would a developer typically do? Now, a developer typically would be buying the site of a scale of this, over 1,000 units in tranches. The finance implications of this are substantial. So that's it. And another element is about affordable housing. Now, standard practice and what happens in reality is that RPs, registered providers who provide affordable houses, they buy them on a golden brick basis. So in effect, when you start construction, they pay a bit towards the land, usually around 20-25%. They pay over the development of it, and then they almost pay what I call a bullet payment, a payment at practical completion. So this is a beneficial cash flow that should have been assessed and done if the cash flow was done correctly. It's a bit more fiddly and a bit more technical, but it gets more closer to the reality of a cash flow. But obviously this approach was not taken.
So just two quick points arising from that answer. In respect of a developer, why wouldn't they buy the land in one tranche?
Because it would massively increase their finance costs. Now, there are instances where developers do. Generally speaking, they would probably get a significant discount to the value they get, but a developer wouldn't want to, and actually most landowners wouldn't want to sell their site all in day one. A lot of landowners want to, sell over tranches as well from tax purposes, etc.
So, and in respect of the approach that registered providers take that you've described, why do they tend to take that approach?
Mainly the golden brick approach, again, is a tax purpose approach. It's to reduce stamp duty liability, which is why they do the golden brick payment, and then it's just the way they fund schemes, so they do fund over the development. It's just the standard industry practice by registered providers who I've acted for or worked for before.
Thank you.
Did you say that was for the northern and southern sites?
Yes, the affordable housing, it would be for both.
No, for the purchasing initially.
It's only in the northern site. So the southern site, that assumption has not, so that has been tranched out. So that's correct. They just, for some reason, didn't do it for the northern site.
Thank you. So moving on to 6.12 of your proof, your substantive proof, and 7 of your rebuttal, I want to ask you about profit margin. Can you just explain what profit margin you adopted in respect of the northern site, and how does that compare to the one taken by Mr. Mitford Slade?
So I have adopted the same approach as Mr. Orst, the council's assessor, at 17.5% on GDV for the market, and we're just focused on the market because the other profits are agreed. And Mr. Mitford Slade adopted a slightly higher profit margin of 18% on GDV.
And how do you justify your profit margin that you've adopted? Bearing in mind you have said it's the same as Mr. Orst, but just explain how you justify that approach.
Yes, obviously I've provided some appeal decisions. I've also provided a bit of a risk-adjusted return analysis. A point I would make is that, again, because it's a large scheme delivered over a significant period, over significant different economic cycles, it's less exposed to risks in the market in terms of reductions in value, shocks in the markets, compared to, let's say, a 3 to 5 year scheme, which is one of the reasons why I take this approach of why a lower margin should be, why the 17.5% margin is justified in terms of looking against other schemes. Actually, the strategic sites, they can weather that risk in economic cycles that a smaller scheme cannot.
Thank you. And those appeals are listed out at 6.12.8 of your substantive
That is correct.
proof. Turning to the approach to the southern site, same exercise. What profit margin did you take, and how does that compare to Mr. Mitford Slade?
So we are in agreement in terms of the master developer at 15% on cost, and I do a reference to an appeal decision which supports that approach, though it's slightly different, but it supports the approach at Horton Park in Bolton. In terms of the service site profit margin, Mr. Mitford Slade adopts the 18% on GDV, and I've adopted a profit margin of 16% on GDV.
Thank you. Mr. Mitford Slade, in his rebuttal, provides some research by Litchfields. Do you have an opinion on that research?
The Litchfields research, if you go and actually look into it, is historic. The range of data, most of it predates the PPG update, so it's 2016 up to 2019, 2020. When I looked through, the research they looked at, it looked at local plan viability assessments only, and actually a lot of these were affected by the old historic Shinfield Reading appeal, where 20% on the GDV kind of was crystallised. But since the updated in PPG, the approach to profit margins has changed, especially when you look at appeal decisions and you look at more recent local plan viability assessments. And one example would be the Wokingham Borough Emerging Local Plan, undertaken by BNP Paribas, which is obviously part of Stratton Parker, or Stratton Parker of them, and they've adopted 17.5% on GDV profit margin in that local plan. So there are local plans now. I'm seeing them more, most of them adopting this 17.5% since the update of the PPG, and as appeal decisions, and as the way vibes in planning has changed over time through that update.
Thank Thank you. I want to turn to benchmark land value. And that is found at 6.13 of your substantive proof and 8 of the rebuttal. Now, you take issue with Mr. Mitford-Slade's gross acre areas used to assess his benchmark land value. And you heard me put a point to Mr. Spilsbury yesterday about what had been incorporated into the gross area. What issue is it that you take with the approach?
So, especially for the northern area, he's taken the full red line boundary. Now, when you go and look at the development structure plans, for example, the 2025 one, I think CD 2.7, it is clear that there are areas of land that the developer would never buy or would never be required to buy to do the planning permission, such as existing roads, residential areas, or retained farm buildings. So, in effect, he's included areas in his gross acres that should never have been included there, which has only had the effect of inflating his BLV based on his methodology. In terms of the southern site, obviously he has deducted some of those areas off. It's unclear how he's got from A to B, but he has taken a lower area than the gross, especially taken off the Kent Science Park. The areas of questions that probably to both the council and the applicant is around things such as the ancient woodlands. Is all of that area required, for example, for the plan application? And if it is not, it shouldn't be included in the gross area. So there are questions around this which would be, you generally ask the council, if I was working for them, are these required for development? And if they're not, basically the developer would not need to buy them and they should not be in the gross acreage assessment.
So what approach did you take to assessing the BLV at both the northern and southern sites?
So I've taken an approach that was obviously highlighted in Warburton Lane Appeal. I called it the Warburton Lane Appeal methodology, but it's an approach adopted not just at Warburton Lane Appeal, it's adopted through many FEAs by different consultants. Cushman and Wakefield were the ones, obviously, as well as my organisation Continuum, who both adopted this methodology, and I've seen the methodology or similar methodologies adopted by other consultants such as Avison Young, such as Savills, etc. So it's not in isolation. Loads of other consultants have adopted this methodology. There are, as we say, other people adopting different methodologies, but one advantage of this methodology is that it is not, if the gross area is wrong, it's not as affected by, for example, Mr. Mitford-Slade's methodology, because the amount it applies to those gross acres that aren't to be developed is significantly lower, so the difference in BLV from a mistake is nowhere near as high.
Can you just explain what you mean by that?
So the Warburton Lane methodology basically only applies the premium to the net developable area. And in effect, it only applies a premium to the areas of change of use, which is exactly the same as what a residual land value does. So our residual land values, we're only applying value to the areas that are net developable. We don't apply value to the gross acreage. So it basically almost does what an appraisal does. And then for the gross remaining area, we apply what the existing use value is. We keep that the same. A reason why you would want to do this is that if you've got a site that is, let's say, its net developable area is 80% of the gross area, and you've got a site where the net developable area is only 50%, based on Mr. Mitford-Slade's methodology, you have a benchmark land value for both of those sites, which should not occur because both of those sites will never generate the same value. And an expectation of a landowner or developer is those sites will never have the same value. So this is what the Warburton Lane method allows. It allows basically assessing the site typology and the site gross to net area through that methodology, which his methodology does not allow for. And I believe it's critical that the BLV should assess that, as well as obviously the premium to reflect abnormal cost, infrastructure, etc.
Thank you. I just want to ask you about the premium for the site. And how did you approach the premium for the site?
So the PPG is very clear how the premium should be assessed, and one of probably the more important elements, which was again approached in Warburton Lane Appeal, is about the implications of normal costs and site-specific infrastructure costs.
For the inspector's notes, are we referring to the PPG at paragraph 14?
That is correct.
I don't think we need to set it up, but if you want to continue.
And yeah, so obviously what I've done is the normal costs are at a high level, especially when looking at Warburton Lane, especially when looking at other viabilities I've assessed. And so because the abnormal costs are high, I've applied a similar premium as the Warburton Lane decision, which is the 10 times, which was obviously the same premium applied by Mr. Mitford-Slade or Mr. Spilsbury, but obviously I don't apply the premium to the undevelopable area.
And just succinctly, what did you conclude in respect of BLV for both sites?
So my benchmark land value for the northern site is circa £10.8 million, 113,500 per net acre roughly. And for the southern site, it's £68.1 million, circa 112,000 per net acre.
And Mr. Mitford-Slade deals in rebuttal with evidence to support his BLV. Presumably you've considered that, and do you have anything to say?
So yeah, the lacking when he's reviewed this evidence is he's not looked into the abnormal and site-specific infrastructure costs, which is critically key because what the PPG asks you to do when you look at evidence in relation to benchmark land value. So
you may just have to ask you to pause a little bit as you're speaking.
Sorry. So the Cherwell District Council one, for example, when you look at that evidence, I can't find what the abnormal site-specific infrastructure costs are through the cost plan they're provided, so you're unable to come to a comparison. The Canterbury Council local plan viability evidence, the assessment one predates the PPG, and no abnormals or site-specific infrastructure were assumed in that local plan viability assessment anyway. So it's not a like-for-like comparison again. And finally, you've got the Ronston Road, North Hertfordshire scheme. When I looked at that scheme, the site-specific and abnormal costs were significantly lower, only at £84,847 per acre. So, again, they're not comparable. You need to make an adjustment to take into consideration that. And obviously, the last was the Optipol option agreement. Now, I looked at Optipol, and from my review of the planning portal, I couldn't find a viability study. It looks like it was policy compliant, so there was no viability and planning assessment of it. Now, in relation to market evidence, the PPG clear, it's a cross-check, but you need to make sure that you adjust for things such as site typology, abnormal cost, site-specific. So this adjustment and that assessment I don't believe has been done, so actually we don't know if it is comparable or not in relation to abnormal costs, etc. And anyway, yeah.
And just where you refer to the PPG being clear, are we talking about paragraph 16?
That is correct.
Now, before we move on to the next section, you heard Mr. Spilsbury and the points that he raised about BLV. Is there anything you have to say in response?
From my experience, I know he said he's never seen plot per acre at this level. Obviously, Warburton Lane was less than £50,000 per gross acre, and I have obviously seen FVAs across at this level. But yeah, different BLVs are adopted across the country by different consultants, so there always will be differences.
I just want to ask you about plot values and residual appraisals. Now, what does Mr. Mitford-Slade provide in relation to plot value comparables?
So, in order to challenge my service site southern land appraisal, he's provided some residential comparables and highlighted them on a per plot basis. So he says on a per plot basis, values in around Sittingbourne, and not all of the comparables are in Sittingbourne, is around about 45,900 is the lowest, up to £77,200 per plot. And then he's obviously assessed that against my one, which is circa £95,000 per plot. However, his comparables aren't on a service site basis. So those schemes, the developers bought that on a per plot basis because they've got to put in all of the infrastructure, all of the abnormal costs, etc., which means you deduct that off and you get to a lower per plot value. So actually, when you look at, for example, my northern site appraisal, which includes all the infrastructure, includes the abnormal costs, on a per plot basis, actually is less than £40,000 per plot. It's actually 37,873 per plot. So actually, his evidence supports my northern site appraisal. You can also do the maths on my southern site appraisal. You've got £95,000 per plot. If you take off the infrastructure costs in the master developer appraisal of about £48,000 per plot, you deduct off a bit of finance costs. Again, you deduct down my value and it becomes less than £50,000 per plot, and actually comes around about £37,000 to £40,000 per plot, my southern site appraisal. So again, it is actually supported by his evidence, because it is lower than that of the evidence he's provided when you take the service site and make it into an unserviced site.
So on the subject of your appraisal outputs, you deal with these at section 7 of your substantive proof and section 10 of your rebuttal. In your view, what is the maximum level of affordable housing, the section 106 contributions, that the northern schemes can support?
So, based on my appraisals, I believe the northern scheme can support its full policy compliance at 40%, and the full section 106 at £20,777 per unit. This is even when including the KCC's higher highway costs. Now, I will, however, caveat this, that the evidence of Mr. Spilsbury in relation to the triggers of KCC highway in relation to having to complete the highways before a disposal can occur will have an effect on my finance costs, and that actually could change the findings. So that could significantly increase my finance costs, I concede, as well as the outcomes of the section 106 triggers. Currently, they're on a more simplistic basis. If they are on a more, what the triggers are, I'm assuming the school needs to be an earlier delivery. I obviously had not had the triggers at the time. That would obviously affect the outcome. I can't say whether that would make it still 40% affordable with the full section 106 or not, because I have not run that appraisal, but I would flag that approach to finance costs could have a significant impact.
And in the same question in respect to the southern scheme.
So in relation to the southern scheme, when you looked at the applicant's new highway costs, I believe that the scheme can support the 40% affordable housing and the full section 106 contributions. However, when you adopted the KCC's full costs with the risk scope and the additional risk contingencies, then the scheme could only support 25.83% affordable housing with the full other section 106 contributions. Again, I would caveat that with a point in relation to finance costs. If you've got to deliver all of the road before you can dispose of a scheme, the effect on my finance cost is going to be in the tens of millions. So it could have a substantial impact. And again, with section 106, obviously at the time that information was not available to us. If that information is available, we could rerun it, and it could have a significant impact, but it's unclear what that is until that exercise is undertaken.
On to the last few questions. Section 11 of your main proof deals with the review mechanism, and will feed into the section 106 session on that. So I'm not going to ask you anything there for now. You recall yesterday at the end of his evidence, Mr. Spilsbury had some comments to make about the potential involvement of Homes England. Is there anything that you want to say about that?
Yes, so I have significant experience in grant applications, in funding applications. As you said, I specialise in Green Book valuations, so I do the full Green Book BCR assessments as well as the viability in that, levelling up funds. I'm working on, so there's a Brownfield Infrastructure Land Fund, BILF. So yes, I am well aware of the Homes England grant funding, and if Mr. Spilsbury's case is to be believed, then yes, the scheme would need significant grant funding, but you'd expect early discussions with Homes England. They would like you to undertake the assessment properly. They would rigorously assess your viability appraisals, as they have done to myself in an application I've got at the moment up in Stockton-on-Tees. So they expect a cost plan, for example, of your infrastructure costs you are asking for in terms of what they would be funding. And there'll be a mixture of grant as well as loans. Unfortunately, the loans are not the best rates at the moment due to public work loan pool finance rates over 6%. So they're not as favourable as they used to be. But yeah, Homes England would definitely be usually interested in sites like these. So yeah, I just add that.
And we also heard Mr. Spilsbury's views on the 5-year cash flows in respect to the northern and southern sites. Is there anything you want to add to those?
You mean the 5-year, as in the KCC?
Yes.
Yes. So as I've already mentioned, you know, the 5-year in terms of the point in terms of the disposal will have a significant impact on the finance costs, which has not been assessed by anyone, myself or Mr. Mitford Slade. As on top of that, obviously there's this requirement, the 6106, which could have a big impact. Now, it hasn't been tested. I would have loved to have tested it if this information was provided me. You know, that is best practice. Looking at Mr. Mitford Slade's cash flow in terms of that, you can see that, especially for the southern site, although he's selling land at year 2, you know, if you sell land at year 2, he assumes that a house builder is going to build their first house within 12 months. Well, they won't be able to. So you're likely going to be pushing back your sale of the land at a later date, which have a significant impact on the finance costs.
Now, finally, in respect of the conclusions that you've drawn in your written evidence, has anything you've heard or seen since you filed your rebuttal led to any change in your conclusions or analysis?
Not particularly, because I think from the main premise of my analysis is that the viability evidence put forward in terms of from the applicant cannot hold weight because there is no cost plan. It hasn't met the minimum requirements of the RSS guidance, and it hasn't met the professional standards in terms of the professional statements. So in that regard, I think the viability evidence from the applicant is not up to scratch and can't be relied upon. There may be differences of opinion between me and Mr. Spilsbury, but the premise is the same, that the evidence it cannot be supported.
Thank you, Mr. Gardner. I have no further questions in chief.
Right. Okay. Let's do.
Half an hour or
No, a bit longer than that, I think.
45?
Yeah, I mean, or even an hour, maybe.
Okay. Well, so you do say we'll start and do obviously say if we get to 1:30 or something and you'll fit.
We only started at 12, though.
It's fine by me. 1:30 it is. Right then. Good afternoon, Mr. Gardner. Now your fundamental conclusion, just to take a massive step back, there's a lot of detail in your evidence and Mr. Spilsbury's evidence. Your fundamental conclusion is that the scheme, on your analysis, subject to the caveats that you've given, is deliverable, both north and south, and is deliverable with the ability to fund all of its 106 contributions and indeed to provide affordable housing to different levels, obviously.
Yeah, that's right in my proof, obviously subject to the caveats on the finance
Subject
costs.
to the caveats on finance costs. And the reason that you do that, so obviously just to state the obvious, I'll just to summarise, that puts you're saying literally the opposite of what Mr. Spilsbury's saying, because he's saying that it can't be done, as he was explaining yesterday. But you're saying that that not only that it can, but that it will be, and the way that you get there, in a nutshell, this is not a question, this is just to tee up the way I'm going to ask you questions, is by going over values, and you think the values are higher than we do, or that Mr. Spilsbury does, and you think that a lot of the costs are lower than we do and Mr. Spilsbury does. And I know that's an incredibly basic way of summarising it, but it's really just to say I'll be going through some of the higher values and also some of the lower costs in order to examine those key inputs. But that's the nub of it. And in a nutshell, just again, subject to caveats about finance costs and cash flow that you've made there at the end, your view in your rebuttal is that the northern scheme you think is deliverable at 40% affordable housing and the southern scheme's deliverable at 25.83% affordable housing.
That's with the KCC's costs.
Sorry,
yes,
I should have said that. That's a very important caveat, yes. Both of those are assuming that the KCC's costs were on the highway, on the road, strategic road and M2
the full cost, exactly.
are accepted in full. On that assumption, from our point of view, a worst case, to put it mildly, assumption. But anyway, your position is that your evidence to the inspector is scheme deliverable, affordable housing at the levels that you've outlined would be forthcoming in a nutshell.
Yes, with the caveats as
with
stated.
the caveats about finance. Okay. Right then, so we'll go through some of the particular items. That's not everything, but the items being residential values, residential costs, commercial values, benchmark land value. Those are the really big ones, and there will no doubt be some others that come up as we go, but those are the big headliners. Okay. Just to set the scene, you've outlined in your proof of evidence in your, is it 9 years? You've done an awful lot, Mr. Gardner, in 9 years. You've worked for a whole range of different authorities,
yes.
And indeed you've talked about your private sector work as well. Do you have any direct transactional experience of the North Kent market?
Not the North Kent market particularly, but other markets in the southeast.
Either residential or commercial. So far as the North Kent goes, is the answer no?
No.
And you mentioned experience of a scheme, I think you said, quote, of this scale, but I'm not sure if I wrote it down right, in Manchester, I thought you said. Is that right?
Yes.
Which one's that?
Godley Green. Godley Green.
Godley, is it?
Godley.
Oh, right. What a great name. Godley Green. And who are you acting for in that case?
Tameside Council. So this isn't viability in planning. This was a submission of a grant funding application, so a HIF bid, and then supporting through the landowner negotiations. Now, I did all the my director did certain elements. I mainly was in charge of the viability elements and that assessments there.
Could I ask you that? Sorry, I didn't mean to cut you off. Sorry, finish.
That's fine.
I thought have you ever done before, in your experience, a financial viability appraisal exercise on behalf of an applicant for a new community or a development of the scale that we're talking about today?
Yes.
Which one was that?
Barnsley West.
And can you tell us just a bit more about that? Barnsley, what was it?
Barnsley West.
And you acted for the applicant who was?
Strata Homes.
And what stage has that reached?
It's been granted consent.
At the local level?
Yes. Granted consent, subject to the signing of a 106.
Thank you very much. What scale was that scheme?
1,800 with significant commercial land.
Okay. That was outlined, presumably, was it?
Outline, it was hybrid.
It was a hybrid?
Yes.
Okay, let me have another go at then maybe asking a more specific question. Have you ever provided financial viability advice to an applicant in respect of an outline application for a new community? And maybe, just to be clear, I'm talking about not just a strategic land parcel of 1,800, but something even, 5,000 plus. I mean, we're talking about something on the sort of scale that's before us today.
So not just an outline, no.
Not just an outline, and that's an important answer, because the inspector said to you when you were talking about one of your schemes you've got experience of that was, I think, a 9-home scheme, which presumably was a full detailed application.
Oh, sorry. I would. Godley Green was outlined, by the way.
Yeah, but wasn't. But you were acting for an authority, and it wasn't a planning application.
So in effect, I am the developer. The authority is in effect the developer pursuing the plan application. So in effect, I was working for the developer because the authority was the developer, if you get what I mean.
Right. Okay.
Now, obviously, they didn't run a viability in planning argument, but I was acting for them through the outline stage, doing their viability assessments, doing the grant funding bids, doing everything else.
Now,
so
how big's the Godley Green one?
Around 2,000 odd units.
Okay. So here's my question. Have you ever taken through the application process a financial viability appraisal for a new community for an outline application? It's all, I mean, have you?
For the applicant, obviously the Godley Green, no. Obviously I've reviewed for councils or other parties.
The reason I've asked the question is because you suggested it was actually an answer to something that the inspector asked. You suggested that the approach was, in your words, very similar or what you'd expect to happen in respect of, essentially, it was a 9-unit scheme was the example, but obviously doesn't have to be, a smaller,
Yep.
detailed housing application, say, versus what we've got here. Do you remember saying that?
That is correct.
And what we've got here is a situation where it's outline. Obviously, that's the first thing, obviously.
That's correct.
Not only is it outline, but as you know, you were talking about all the things you'd expect to have been modelled or valued. There's no detailed road design that's before us for determination, no detailed drainage strategy, no detailed earthworks strategy. All of these things are all to be reserved. You understand that?
Yep.
And so the approach that one takes to the situation that we're in now can't possibly be very similar, because the level of detail of the applications is just, they're a world away.
So yes, they're a world away, but a cost consultant would still be required to estimate that. So they would estimate the cost based on other schemes. They would probably do an estimation of what the cut and fill volume could be. They can do exercises with engineers to help them to come to this assessment, which is pretty much what we did at Godley Green when we were assessing the scheme. Had a cost consultant, had some engineering advice, and that's how we came up to the cost. Again, it was an outline application. So it can be done, and it should be done.
Whereas, by the time of the different stage reviews in the Section 106 that I appreciate you've not seen, so
yes.
This is not a question about the detail of it because you've not seen it, but I think you will have, or your client or you will be able to come back and comment on it at the 106 session. So anyway, by the time of the different reviews, the point is by then we will know where the roads are going to go specifically, how much they're going to cost. We'll know where the earthworks are going to go and how much those are going to cost, what the detailed drainage strategy is and all of that. All of those matters will be filled in as the viability review mechanism works its way through. You understand that?
I understand that, but that's...
Oh, go on.
I understand that, but at the same time, the assessment now needs to be done properly. A bit like local plan assessments of these strategic sites.
Yeah.
You do have cost plans reviewing them. For example, Gilston and Harlow. The council did an infrastructure delivery plan, brought in cost consultants to test what infrastructure costs were, same with the Northern Essex. So that assessment can be done and still should be done because we need to do viability properly now.
Yeah.
I agree that a review mechanism will get and find the detail at a later date, but we haven't done it properly now, and we need to do it properly now. A viability review mechanism isn't almost, I haven't done my job properly, so I'll throw my hands up, we can do it later.
Yeah.
That's not how it should be done.
No, I don't think anyone's suggesting we throw anyone's hands up, but what I'm suggesting is that the level of detail that it's possible to bring to bear on a question like this is just completely different for an outline application for a new community comprising 8,400 homes and so much else, 34 hectares of employment space, new strategic roads, all the rest of it, given that everything's outlined, versus a small detailed scheme where you could just cost it all up. It's completely different.
I agree there's difference in terms of level of knowledge and evidence there, but you still need a cost consultant advice as the RSS guidance requires you. You still need the cost plan. You still need the evidence base behind your units. A cost consultant with an engineer can still do, mock up some cut and fill estimate. We know how many attenuation ponds there are. We know, what diversions there are. You don't need to know at the outline stage. Don't need the detail to know that there are pylons that need to be diverted. Where is that figure for that cost? We know as well, in terms of statutory consultees, we can speak to them now and go, what upgrade reinforcements do you need? We know this at the outline stage. You don't need to know that at the reserve matter stage. Again, where is that detail? Where has it been costed? It is not here.
Okay. There does seem to be maybe we'll see when your barrister asks questions of Mr. Mitford-Slade, a divergence in approach to what the level of detail into which it's appropriate to go at a stage like this. But I'll leave it, as you've made your position clear. You did say one thing that was important. You said that small changes in residential values can make a scheme much more viable. That was your position.
Yeah, a small change in any input can make it one way or the other way. So more viable or less viable. It's very, as Mr. Mr. Spilsey said, there's
He thinks it's going down, you think it's going up.
but any input can make a massive change. It's
Yeah.
very sensitive to any
Doesn't
input.
that sort of speak to one of the limitations is the wrong word, but the health warnings, I suppose, of any FVA exercises is that they're a picture in time, aren't they?
That is correct.
I'm sorry, go on.
No, you go.
No, i.e., and this is just what the nature of the exercise is. There is a snapshot, is the word I was looking for. Snapshot in time at the moment for which they're being prepared.
Yes, that's exactly correct, which is why the RSS guidance places the importance of sensitivity analysis.
Yes, and
Which
also...
is-
oh, sorry, go on.
Yeah,
Go on.
which obviously the FEAs originally produced by Mr. Slade, as well as in his proof, did not have a sensitivity analysis.
right.
I know he's only just provided one, which is not that detailed, but that is the importance of sensitivity analysis
Yeah.
and the stand back approach, as Mr. Spilsbury has highlighted.
Yeah, just to be clear, to try and give Mr. Mitford Slade a little bit of credit, he spent some time, as you're aware, reaching a position of agreement with the local authority on the topic of viability over months and years, right?
It's not in public information.
All right,
I'll
fine.
take the Holborn
Well,
Studios
it's
case
proof
in
of
terms
evidence,
of,
Okie dokie. Well, he can be asked about what he did. Right then. So we need to be careful. Is one of the things that you're telling the inspector. We need to be careful about being too pessimistic about what's going to happen to residential values and indeed viability overall, because you say things might actually, however it might look today, snapshot in time, as it were.
Yep.
Things might change. We're talking about multiple economic cycles, is what you're saying.
Yeah, that's correct.
And therefore, you say, Mr. Spilsbury thinks it's all going south, but you think values might go up.
Yes.
And if they went up, happy days, as it were, because then the scheme becomes even more viable than it is already, and that only what's the right sort of bolsters the ability to fund affordable housing.
Yes, that can occur.
And one way of capturing that occurrence, fingers crossed, obviously, would be through a staged viability review mechanism that seeks to capture precisely these changes in revenues and indeed whatever costs actually end up being in the end.
2 points to that. One is if the review mechanism is strong enough and good
Okay.
enough. A lot of my experience, a lot of review mechanisms are not, which is the importance to review this. Obviously, opportunity to review,
Fair
make
enough.
right comment.
No, fair enough.
If the review mechanism is on inputs that are wrong, for example, not policy compliant in relation to, I don't know, benchmark land value, a difference
see.
of opinion, that has a massive impact on how the review mechanism works.
Okay.
And as I said before, viability should be done properly now.
Yeah.
And if there is a review mechanism, then that's acceptable. But viability
Good.
hasn't done properly now, so we can't just go and kick the can down the road.
Yeah. Let me just
Yeah.
try and short circuit some of it. No one is suggesting that we don't try and do viability now. Here we are, sitting having this conversation, or that we kick any cans down any roads. But that's not my question. My question is, given that what viability shows us is the snapshot in time,
Yep.
and given that things, as you say, can improve materially over economic cycles, it's important that there be a viability review mechanism to capture that in the event that values go up, in the event that costs go down, or whatever.
Yeah, so as the PPG says, I believe, can't remember the paragraph, but the PPG says that if you can't get full compliance,
Yeah.
you should have a review mechanism.
mechanism.
So it tells you to do that. It does also say that review mechanisms are not tools to protect the developer's profit margin,
Yeah.
they're tools to seek maximum of public benefit. So
Maximum affordable.
exactly. So
Okay.
the review mechanism also needs to follow that guidance, but it's only in the case of a proper assessment's done.
Yeah.
And
I've got it.
it's not policy
I
compliant.
know you don't think it is. Okay, right. So far, so much sort of broad agreement, really. Let's get into things that we don't agree on. Residential values.
Yep.
The first way in is, I think, in your proof of evidence, your not your rebuttal, your main proof. You've got a section called Conclusions that starts on page 42, where it's all tabulated, SP's inputs and your inputs. So just let the inspector find that one. Have you got that one as well, Mr. Gardner?
Yep.
Thank you very much. So this table, 8.1.1 introduces table for the north, just to orient.
Yep.
And then a couple of pages on, if you would. 8.1.2 on page 44. We've got the south.
Yep.
And the first series of boxes is service land value appraisal in the south.
Yes.
And then, just to again finish the orientation, over the page, one more page, towards the bottom, you begin the master developer appraisal in respect of the south.
That's correct.
And just to be clear, doesn't need saying by now in the evidence, but at the master developer appraisal, the very first thing the very first line is the service land value per plot, per unit, as it were.
Yep.
And just the inspector's clear on the logical relationship. There's a difference between us. Your differences are explained in the table above. The table above being where you set out your service land value appraisal. So your service land value appraisal stuff then feeds into the master developer appraisal in that first line in particular.
That's correct.
All right then. So that's that. Now, each time when you set out, this is obviously only your summary of your evidence, but you set out what the SP figure is, which is Mr. Mitford-Slade. You set out your figure, and then you set out the delta between them, where there is a delta.
Yep.
And this is a big one. Market serviced land value. Sorry, back on. It's southern site, master developer appraisal. So it's page 45. Sorry. Page 45, master developer appraisal. The first line is market service land value. So these are the revenues, the residential land sales, aren't they?
Yep.
And the applicant side, and indeed Mr. Spilsbury broadly too, are at. That figure's not quite right anymore, but it doesn't matter. It says it's 75,175 per unit. We did look into the basis of that figure yesterday. The inspector may remember.
Yeah, this is based on the May FEA.
Exactly.
So yeah,
it's not a criticism. Just the figures have moved on slightly. It's gone up a little bit to 76 something. But anyway, you're at, and that's as between us and Mr. Spilsbury. You're at 96,400 per unit in terms of the sale of serviced residential
yes.
plots.
So in my rebuttal, I'm slight adjustment on values based on my. So I'm now at 95. So
You're at 95. So things have narrowed slightly.
Yes.
However, it was the case on the arithmetic at this stage that the delta between us added up to £136.6 million. And it's now going to be somewhat less than that, but still well over £100 million.
By delta.
Delta is the difference between the two. Are we happy with that term? Say again.
No.
It's Greek.
Firstly, yes, it's Greek. I learnt it from viability consultants. That's the only reason I use it.
I've never heard that.
Really?
I'm not gonna lie, I've not heard of it.
Really? Oh God, I feel like a real outlier. Right, I'm going to say difference instead. I thought I was using the correct technical lingo. All right, so difference between you. Difference is on this topic of market service land value. The difference between you is well over 100 million, regardless of exactly where it is. It's a big topic.
Yes,
of
that is
difference.
correct.
Okie dokie. Right. Now, what are the key inputs that feed into that whopping great difference of over £100 million? They are, again, just for the inspectors, just to be clear, they are the inputs that flow out of the table above. That's if we want to understand why we're over £100 million apart, it's because of all of the things that are set out above in your service land value appraisal.
That is correct.
Thank you very much. So, if we turn to the service land value appraisal bit, the first line, won't do all the lines, but just some of the biggies. The first line is one that you talked about in your evidence in chief. It's this input of market sales value, which is at the top line.
Yep.
And this is, I won't go over the figures. You went over this in your chief. You talked about what your case is. Your point is about to do with comparables, and you're at essentially in excess of over £400 per square foot as being the basis upon 402. It says here.
Yes, slightly small. It's about 401.57, whatever.
Fine.
Yeah, but yeah.
So it's circa 402 as per pounds per square foot as being essentially the average pound per square foot upon which you've calculated your residential sales.
Yes, on
values.
an individual basis. Yes.
Yeah. Okay. Right. Now, Mr. Spilsbury thinks that our rate is being optimistic, and it already includes a placemaking premium. But you say that we're being pessimistic, and that's even excluding a placemaking premium. Is that right?
That is correct.
Okay. And the basis upon which you seek to support your 402-ish pounds per square foot relates to the comparables that you talked through in your evidence in chief.
Yes, mainly the rebuttal.
And just if we could just have a very quick look at those. Those are Appendix 5 of your rebuttal, which is on they begin on. Find your rebuttal. Rebuttal appendices. This is of Mr. Gardner. Lovely. And it's all paginated. Thank you for doing that. And it is page 6 of your appendices. Just make sure that you've got it, I think, Mr. Gardner.
Yeah, I've got it up.
Thank you very much. Just wait for the inspector to find it, and then I'll ask you about it. Page 6, PDF 7, but you've got it hard copy. Thank you. And so we've got, it should be Appendix 5 comparables as the heading. Have you got that, Mr. Gardner?
Yep.
And then there's several pages of asking prices and also transactions and so forth. Yeah?
Yep.
Now, just to break this down, not a criticism, but just to establish the facts. I don't think these aren't sales that you were involved in yourself, any of them. Is that correct?
That is correct.
So you don't know for sure, and we'll hear from Mr. Mitford Slade as to whether he was involved in any of them later on in the inquiry. But when it comes to things like incentives that would have the effect of essentially reducing what the effective price paid per square foot was, you're making assumptions, but they're not assumptions from first-hand knowledge.
It's assumptions from review of the websites, the incentives on offer at the moment, so you can actually work that out from incentives of the moment, as well as experience of house builder schemes across the country.
So it's sorry, I don't mean.
But obviously, Mr. Mitford Slade has not provided anything to inquiries,
Fine.
have not ever had any evidence to support his assertions. But
Well, you've got, so when it comes to incentives, you're making assumptions based on experience and websites rather than any direct experience of what actually happened in any of these sales.
that is correct.
Putting incentives aside just for a moment, you for both your, not for your asking prices obviously, because those are just asking prices, but for your achieved sales, you update or whatever, upscale them to March 2025 values, and then from that, and then towards the right hand side of your columns, you then adduce a pound per square foot number.
Yes, same what Mr. Mitford Slade has
Same
done.
approach.
Yes.
Yeah. And you've got samples of. We've counted them. We think you've got 98 achieved and 82 asking prices. But anyway, something like that. Quite a few. And the what you talked about in your evidence in chief was using this evidence to establish a tone.
The asking price is more establish a tone.
And what about those? What about the sold prices?
Obviously, if they are recent, then they are the strongest comparable there. But asking prices still are very
What
strong.
does a tone mean?
It provides a tone of where values are now, especially when you've got evidence that is, Mr. Mitford Slade, for example, I think it's 2021, 2022.
I see.
You need to just check that, the March 25 update with a tone of value from the asking price, just to give that sense check in terms of when you're looking at indices basis, because asking prices, are very, can be some of the best evidence there,
Can it?
subject to obviously some of the caveats you
Right.
need to do to that data.
Do you know what the average pound per, let me get this right, pound per square foot? Yeah. And in terms of pounds per square feet, have you averaged your sales prices? Do you know what the average is of your comps?
So I know per scheme, I couldn't give you
per overall.
Yeah,
of the
I couldn't.
98
I haven't
you-
done the overall
Well,
on
I'll
that.
tell you, and then obviously it can be checked and you can be re-examined
Yeah.
on it. But the average overall from all of the sales prices that you have in your comparables is £392. And do you know what the average asking price rather than so those are the sales prices, but you've also obviously, as you've said, you've included asking prices, and you've got, I think, we think
Yep.
82 of them. Do you know what the average asking price is across all of the comps?
So again, I've not done it through the whole. I've done it for individual
I
schemes.
see.
So I've showed you for the individual scheme. Not for, again, as I've said before,
Yeah.
you can't take an average of all because they're all in different locations.
Sure.
They've got different house types. So
Sure.
it's not a reflective nature of what would be achieved here when you have
I
to take
see.
into consideration the beds, the type,
Sure.
the height, etc., as well
Yeah.
as the location of this site.
The average asking price, the average sales price in your comps is 392, and the average
Yeah.
asking price in your comps is 389, slightly lower per square foot across your sample of 82. So if these numbers are establishing a tone of anything, they're establishing that there's no basis at all to be assuming £400 plus on average in this part of the country.
No, because about 80% of that data is taken from schemes that are of the north of the borough, north of the location. So again, as I've explained before, you need to take into consideration the location, as you can see from the house price heat map. You can't just take averages of schemes, because different, as you know, there may be lots of, has this taken into, I'm assuming his average includes 2.5 and 3 story units, which impact the value. Now, I've made the assumption that all schemes are 2 story, which
You made
is
a scheme what, sorry?
all
What did you
units
say?
all units are 2 story dwellings,
Right.
because, as I said, I outlined in my rebuttal, the values are based on 2 stories and the costs are based on 2 stories. If I base my costs on 2.5 stories, then I would obviously have a lower cost. So it's important to basically individually assess each individual unit, because you may have, for example, one scheme over the point of period in time in that 2024 period where all of the units are, I don't know, a very large detached house which is achieving a lower value per square foot than, let's say, generally speaking, small houses achieve a higher value per square foot than larger ones. So you've got to look at that. You've got to look at location. You've got to look at heights. You've got to look at, for example, a detached house sells for more per square foot than a semi-detached.
It's difficult to do this, isn't it?
So
in a world where we've got 8,400 houses that are being proposed with no detail on the proportion of them that are going to be detached or semi-detached or whatever that's before the inquiry. How are you asking the inspector to reach a reasoned analysis of your comparables to upgrade them to the scheme that's before her?
So obviously we've used pretty much the mix, subject to slight changes that Mitford Slade has adopted, which is similar, such as the Warburton Lane appeal. When it was the outline, they basically assumed certain bits. There was some detail and outlines. It's weird, but the viability was not done on detail. It was done on outline. So it was assumptions of, from viability consultants, we see house building schemes across the country. We know what mixes you typically see, and I don't pretty much agree with this, the mix that Mr. Mitford Slade's put in place in relation to how many 2-bed, 3-bed, 4-bed properties. There's a slight difference in terms of things that I think could have changed. So you can value those specific units, and it happens all the time through the local plan stage. It happens all the time on other outline applications.
Just to be clear, so you're asking, I've said what the averages are, obviously they can be checked. You've given your view on whether they're useful or not. One thing that does have a bearing on values achieved when houses are sold is the quality of the build, right?
Yes, that can have an effect, yes.
And that can be proportionate to, or expressed statistically, through a proportionate relationship to the costs of the build, i.e. higher build costs can have a bearing on higher values achieved.
To a certain extent, yes, depends on the market, etc.
Depends on the market, but the difficulty that we have here, and it's not something, as I can understand your analysis that you've allowed for, is that you're telling us to go well below lower quartile BCIS build costs to which we'll return. Is that correct?
That is correct, based on detailed evidence base.
Advocating a substantially above average sales costs compared to the 200 comparables that you put forward in this part of Swale.
In terms of taking into consideration location. So as you know,
Right.
you've got two similar houses in two different value locations. You can
Yeah.
build them out pretty much the same if you're in this pretty much the same wider area, and you'll achieve different values. As you
Got
will
it.
know from second-hand market, you can have a house street that's exactly the same on
Yeah.
one street. You can go to a lower value street, house is exactly the same, 3-bed semi, exactly the same quality. They will achieve different values because the location, as they say,
it.
location,
Yeah, I remember
has a
that, yeah.
specific effect on values.
So I think then, just to isolate it, and then I'll move on from this topic, and I'll ask Mr. Mitford Slade about his understanding of the local market. But even I've said to you, your averages support something like £390 a square foot, all of your comps. Your response to me, in a nutshell, you say a number of things, but the most important thing I think is that yes, but most of your houses are coming forward in the high value areas of the south of Sittingbourne.
Exactly that. The
Okay.
south, the southeast, especially as shown by the house price
Okay.
heat map, is a higher value
Right,
location.
that's very helpful, thank you. And I will there crystallise that, park that, and then ask Mr. Mitford Slade about it if I ever get to him. Right. Thank you. That was the first variable on your residential plot table. Serviced plot table for the southern site back in your proof of evidence. The next one relates to build costs. We've heard loads about build costs now. If we just turn back to page 44, you might be there already, madam. 44 of your proof of evidence, back in the table that we were in before. We've talked a little bit about market sales values. The next one down is a difference between us on build costs. We've talked about this in your chief. We talked about it loads yesterday. As you've said, we're at circa £156 as gone through yesterday. We're told by Mr. Spilsbury, you'll remember, that we're way too low. We're way too low at 156. He thinks it needs to be much higher, and he's explained that yesterday. Your position is that we're way too high and it needs to be much lower, albeit, as you say in your brackets, you have, for completeness, as it were, sensitivity tested at £160. And £149.
Yeah, that is correct. And the 160 is probably, I don't know, I can't speak for Mrs. Spilsbury, but it's based on lower quartile, 15%.
Yeah.
Future, as well as the apartment reflection. So
Got it.
probably similar, I summarise, to what his position is.
Okay. And to understand, let's see whether we can do this shorthand. To get to as low as you are at £142.50, which is your primary figure, what you do is, let's just show the inspector, if we just put a pin on that page and turn back in this proof of evidence to page 20. There's a table, hopefully, in the middle of page 20 of the proof. Good. And we can see in the bottom right-hand corner the £142.50 figure.
That is correct.
And so there we go. Bottom right-hand corner. So that's where that, as it were, comes from. Obviously, then features in your table towards the end. And what's happening is that you are starting with a rebased lower quartile BCIS figure, which you adduce at 134.96. Correct?
That is correct.
That's on the left-hand side. And then there are two things, before you start adding on externals and future homes and all of that towards the right-hand side, there are two things that you remove from it, from the BCIS. So we're starting at the lower quartile in the first place, and then from that you strip overheads and profit, and you also strip house builder efficiencies.
That is correct.
And that's how, essentially, mathematically, we end up with a much lower, I say much, whatever, lower figure than our 156 6 or whatever, because we've not, to be fair, nor's Mr. Spilsbury, but we've not stripped out those different things.
Yep.
Sorry.
OH.
That's
It's overhead and profit.
Thank you. Overheads and profits you strip, that's the minus 7.5%, and the other thing is house builder efficiencies. And so, sort of, if you like, methodologically, the key where we diverge is that you make those reductions of 12.5% and we don't, basically.
Yep.
Okay, so that's what it comes down to. You've assumed, I think, is this right, that overheads and profit are costs to developers?
This is a point that is made during the Warburton Lane appeal, made during local plan assessments.
I'm making it now. Is that on the basis upon which you've...
So overhead and profit, because a house builder takes the contractor role and the developer role themselves, through the Warburton Lane decision, through 2 cost consultants there, as well as 2 viability consultants. I know my company was one.
Just answer the question.
But yes, basically the contractor margin is allowed for through the profit margin for house builders, yes, because they take the contractor and developer role themselves, which is normal.
If in fact that were wrong, I don't know about Warburton, our inspector knows lots about it, I don't. But if in this case it was wrong, I don't know what the model was there, but here, if there were in fact contractors who were making a margin into which OH&P goes, then it would be wrong to strip it out here.
So the RSS guidance is clear that you should assess things based on the typical way the market will deliver it in an optimal way. So a typical house builder will always be taking the contractor and developer role themselves. That is the typical of all house builders, whether it's from small to large. And to be honest, most developments of houses nowadays is undertaken that way.
All righty. Well, look.
As well as, look, this is supported by, you can look at the 2 cost consultants that were at the Warburton Lane appeal, which I had submitted.
I wish I'd been there. I tell you what, it would have sounds fantastic.
It was submitted to appendices of my proof to show their approach they have taken.
So let's just. I'm not going to be able to, persuade you out of your view on how the market works. But can I put it like this as an if question? So accepting all the things you've just said, and that's your view.
Yep.
If it is right that OH&P in this case were not to be a developer's cost, but were a contractor's margin, and things aren't operating as you've explained, then it would be wrong to strip out the 7.5%.
Based on this methodology, yes. Hence, there is a sensitivity testing showing that anyway. Exactly. Right. So from a stand-back approach, I have tested.
Good. Thank you.
On those levels.
I appreciate you've done your sensitivities. I've got to try and work through why we're not all aligned on build costs, and that's the first reason why. And the second reason why is householder efficiencies.
Yes.
There's no. How can we put it like this? We don't yet know which house builders are actually going to be building this site out. House builders, plural, because there'll no doubt be many of different scales across a site like this.
That is correct.
We don't know. Presumably, some of them will be big nationals. Some of them could be SMEs. It could be all sorts of units operating at once. So we don't know at the moment what kind of builders or in what proportions.
Yep.
So the 5% that you have set out, the 5% reduction on the basis of efficiencies.
Yes.
Has no. Right way of putting it. It's basically a finger in the air. It has no quantitative, substantive basis.
So it does in terms of Warburton Lane appeal, where again, national house builder. The assessment by the cost.
The most brilliant appeal decision.
The assessment by the my director would say that because he was an expert. But the cost consultants there for national house builders viewed that 15 to 20%. It was argued 15 or 20%, one way or the other, was to reflect the house build efficiencies of a national house builder.
We've already started at lower quartile BCS costs.
That is correct.
BCIS costs.
Yes.
We've obviously talked about the OH&P strip out at minus 7.5, so I put that to one side because that's a different debate.
Yes.
Now we are assuming I think is the right word, because there's no a further 5% knockdown on the basis of a house builder mix and type and all of that that's completely unknown, whilst at the same time telling the inspector that the average sold rates per square foot are going to be well above all the averages and your comparables.
So the reason why this methodology is approached by many cost consultants, such as the two at Warburton Lane, is the weakness, as I've highlighted out, of BCIS. Now, house builders typically, and as my analysis shows, I've actually gone through since 2019 up to 2024, every single publicly available scheme on BCIS, and as that analysis shows, is that house builders are not providing that data. 84% of that data is coming from registered providers as well as councils who have a contractor undertaking that role. Their costs are completely different. From my experience working for local authorities as well as house builders, is the costs are different. And this is the weakness of BCIS, which cost consultants such as at Warburton Lane try to overcome with a methodology approach here. Rossendale local plan, they took a different approach, but their assessment when they got to their base build cost, it was around, I think, 20-30% lower than local quartile. And there are other local plans. Again, these are done by cost consultants. And so this is what it is. I also see standard build costs by house builders. I work for house builders, or in terms of when I'm dealing with selling land and they give me their costs, or through JV. So I see their costs. And for a base build cost, house builders' costs are lower than lower quartile BCIS.
Well, it depends on the house builder, doesn't it? That's kind of the point, is that some of them might be
pretty
well
much above. No, I can get pretty much every single house builder I see, unless they're a specific, they may be a net zero carbon house builder who's building over and above, but we are looking at typical normal development.
Exactly.
RSCS talks about looking at it as how a typical developer will assess it.
All right, I'm going to leave that. The fair enough. I say fair enough. You have in the end, your position here rests on an assumption, which is that the mix of house builders that are going to be coming forward, about which we know, let's be honest, nothing, will be able to produce houses at over £400 a square foot in terms of their sales values, knocking off at 5% from lower quartile BCIS costs. That's your position.
I would also point,
isn't it?
You focus on the southern side. If we look at the northern side,
just hang on, just before we is that I've just tried to summarise it, but
so
everything I've said is correct.
Looking at what a typical house builder of a 120 unit scheme would be. What are the costs of that? And that's how I reflected it through my methodology, as supported by the Warburton Lane decision and local plan viability assessment Rossendale have provided.
Thank you. Right then, if we go back to that table that we were in on same document, but back on page 44. We were looking at some of the differences between you and S&P. We're not going to do all of them, as I've said, just sort of the really big ones. So the market sales value, standard build costs. Those are the top two rows. Over the page, just before we get to the next table, there's a profit margin line, and you set out the profit margin that SP have adopted, that Mr. Mitford Slade has at 18%.
That is correct.
You set out your profit margin here at 16%.
That is correct.
This is the situation where the PPG is suggesting a range of 15 to 20, and we're at 18. I say we, Mr. Mitford Slade's at 18, right?
This is for the service land value. So there's a different approach because of, as you said, well, I'm sure we'll come to your question.
No, different, of course. No, as you say, this is for the serviced land values. For the north, just to compare and contrast, you're at 17.5.
Exactly that, because there's a difference between service land and unserviced land. So in terms of the risk, as well as you talk about service land with planning, so there is a planning risk that has now been taken out because it's a risk-adjusted return approach. So we need to take into consideration there's planning risk gone because it's got an outline consent, as well as the risk in terms of the infrastructure requirements are not on that developer. So the developer can factor in a lower risk margin to themselves on a risk-adjusted return approach. So that's the premise. Now, what I would also add.
Sorry, do go on. Sorry, I didn't mean to.
What I'd also add is in the master developer profit margin, there is, if the southern site was delivered as a normal developer model, you need to take into consideration that there's this layer of profit margin here, which is on the risk of the infrastructure, etc. That equates to about 2.32% on GDV. So factoring all that in, it's why you need a reduced risk, because there's margin there, as well as on service land with planning, you basically have less risk because the planning risk has gone and the infrastructure delivery risk has gone, compared to the northern site where all of that risk is still there, hence why my profit margin is different.
Okay, so your position is that in a circumstance like the north, 17.5%, in a circumstance like this one, 16%.
Based on a risk-adjusted return approach, yes.
Based on the what, sorry?
Risk-adjusted return
not gonna ask
approach.
what that
Again,
means.
as required by the RSS guidance,
Okay.
as well as the PPG if you look into the profit margin.
The Litchfield's research, well, if we just turn up very briefly, Mr. Mitford Slade's rebuttal. Sorry, thank you. Just let the inspector find it. If you've got, it's the rebuttal I was after. There you go. And page 12. Page 12. Have we got that? Have you got that, Mr. Gardner?
Yes, I've got that.
Thank you. 5.18's where Mr. Mitford Slade picks up this topic of profit margin.
That is correct.
He says that the suggested profit margin of 17.5 on private market housing revenues in the north is the same, adopted by Mr. Orst, marginally below where he's at 18. So
That's
there's
correct.
Not much between you on that.
No.
For the service land parcels on the south, an even lower rate of 16 is adopted, which has, he says, no bearing on today's market, on the basis that the Aspinall Verde site-wide viability analysis adopts a rate of 20%. He doesn't see any reason why 18's at anything less than reasonable, and then refers to the Litchfield's report. He notes that it predates the MPPF and's nearly 4 years old, but he says the market's not wildly different in terms of land values, and he produces the report and then goes on to note what the report says. Obviously it's appended, but we don't need to turn up because it's summarised here, that 82% of the viability studies, 76 of the 93, adopted a margin of 20% on private market GDV. Majority of studies used a blended rate of 20% on private market GDV. The only sites with profit margins around the level suggested by you were small sites, on the basis that delivery of larger sites will inherently carry greater risk, not, as you were saying in your evidence in chief, less risk, given the lifetime of such projects, often over a number of economic cycles, and then sets out some of the findings from Litchfield's to do with about 5 or 6 lines down in the next paragraph. Most common approach, set target profit levels for market housing at 20%. So I've not asked you a question yet. That was just
Okay.
That's what Mr. Mitford Slade has said in rebuttal.
Yep.
It's correct, isn't it? That's what the Litchfield's report says.
That is correct on pre-PPG compliant update local plan viability assessments. And one, I haven't gone in detail whether, I haven't checked it, but yes, there was a shift in profit margin assessments in the world of viability and planning with the update in PPG. The 15 to 20% level came. The view of the old historic Shinfield case probably was represented in most of those appeals why they adopted 20%. That has basically not really taken anymore, and as we've seen through many appeal decisions, inspectors are usually recommending 17.5%, and lots of local plan viability assessments, such as the one by P&P Paribas at emerging Wokingham local plan, are adopting 17.5% on GDV for market housing. So the PPG has, update PPG kind of reset viability. It reset a lot of approaches to inputs, especially profit margin was one, which I've seen through my view of local plan viability assessments as well as appeal decisions. And that's why I support the 17.5%, which I've supported with a number of appeal decisions.
Well, we're not far off you on the 70. It's the 16. There's
Yes. So again, the 16, and as I've reflective, is that if this was like the northern site, a scheme delivered on the same basis, so non-service basis, then I would argue 17.5%.
Okay.
Now the developer is not taking that risk. They're not taking the planning risk. So that the planning's gone to elsewhere. So the planning promotion cost of 5.5 million is with the master developer, and they're not taking the risk in relation to the infrastructure, so the service. So there is a difference of risk between a service site and an unserviced site, and that's why there's a difference in profit margin. I mean, it was adopted in other large strategic sites before, and has been commented on other schemes before.
Do you have? Do you provide any comparable examples to the inquiry of circumstances where house builders were prepared to accept a 16% profit in circumstances like this?
I have commercially sensitive red book valuations I cannot provide.
I see.
So I do have ones of 15% on cost on schemes, etc. So I do have profit margins lower than this on multiple schemes, but obviously they are commercially sensitive.
Okay. So it's one where.
But in terms of this is why the guidance is very clear. It's a risk-adjusted return assessment. So this is where the risk-adjusted return is coming in. Now, a view of the risk is different between the service site and the unserviced site, and therefore risk-adjusted return adjustment needs to be made. And look, it's been viewed on other large strategic sites.
Yeah, but that's why I asked. Is there any evidence that's actually before it? And we know that what the sort of standard PPG range of 15 to 20% is. You're suggesting bottom of the range, basically, not 15%, 16%, but towards the bottom of the range. I'm asking you, is there any evidence to support that approach on large strategic sites like this actually happening or being accepted or whatever?
Off the top of my mind, I'm pretty sure Gilston Garden Village, they adopted a different profit margin for the serviced and unserviced. What
were they? Okay.
I can't remember the top of my mind, but I know there's a different approach to profit margin. One was at the higher end and one was at the... I think Mr. Spilsby does even mention in his proof of rebuttal the difference between one or two, and he has seen it. I'd have to try and find the page number.
Okay, all right. Well, thanks. Mr. Spilsbury thinks, I'm just trying to find what his evidence is on this. In the current market, expected to market sales. I think Mr. Spilsbury is at 20% for...
I think Mr. Spilsbury somewhere, and I'd have to find, and I can find it there, he almost would argue it's 20% and then 17.5%.
Yeah,
so he does make an adjustment down from serviced and unserviced in a commentary somewhere. Obviously, my based assessment is 17.5, not 20, so I go 17.5. You take it down. He goes 20. So the premise of making that
and we're
adjustment...
stuck in the middle again.
The premise of that adjustment is supported elsewhere, if you get what I mean.
Yes. Although not the 16%.
Not the methodology per se.
The methodology.
Where that, let's call it the base level, whether it's 17.5, 18, 20.
Okay. Let's call the whole thing off. Okay. So the where that takes us then, those differences in input take us to a fundamental difference, a enormous difference, over 100 million in value of in relation to market serviced land, and we go back, if we could, to page 45 of your proof. As a consequence of the things that we've been talking about, and some of the other things as well, but most of all, market sale values, build costs, profit, we end up with an over £100 million difference between us, and it's this 75 or 76,000 per unit on the one hand, and your 95 or 96,000 pound on the other.
That's correct.
Now, you accept, and I think you've talked about several times. I'm sorry, it's over. Do you see at the stage of the? But do you see it's 136 million because it's per plot, and there's 8,000 or there's 7,000 plots in the south. So it's, although it's only a difference of 20,000 or whatever, it's per unit, and that parlays out over the entirety of the scheme. So you end up with a absolutely enormous difference. So that's a big difference between us. You accept and would speak to, I think, the value of the stand back and common sense check or sense check as something that's recommended by RICS to do.
That is correct.
We've tried to do that. So if we just remember in our minds the market service land values of you're at 96 or 95, we're at 75.
Yep.
In Mr. Mitford-Slade's rebuttal, he talks about some of the sales that he's been involved in on page 12.
Yes, I've seen that and outlined it in my chief.
Yeah. Expect to find it. 5.23 towards the bottom. He says on the second line that the 96,400 is wholly unrealistic and has no correlation with other transactions locally. Now, just before we go into what those transactions are, I think you would accept, wouldn't you, that it's important to try and sense check our findings against local transactions if there are any.
So obviously, if you looked at the RSS comparable in valuation of development property, when you are meant to do a residual land value, this is different to Vibes in planning. You generally do a residual and a comparable method. Now, Vibes in planning, you don't typically, it's not as usual to do. It's not generally done more. Sometimes they do it in a benchmark land value assessment. Okay. But I have no qualms with what he's done, of course.
So it's important, if we can, to have a look and see whether or not, the numbers that we've inputted into our spreadsheets tell us something that's sensible or not, or unrealistic. And he refers to Swans Tree Avenue, that's at 5.24, which is a site that was sold to Hyde Housing last year with a price with 30, it's obviously just around the corner from the southern scheme, which equates to 45,900 per dwelling. And then he refers to Trenport Investments and the land at Frognall Lane in Tenham, 300 homes, 18% affordable housing, and that equated to 77,200 per plot in what he says was a much stronger development land market with active RPs. And he talks about yet another example in Medway for a site for 250 dwellings of a plot value of less than £60,000 per plot. So that's what he says.
Yes.
That's again just summarising what his evidence is. But here's my question to you: have you got any relevant comparable evidence for the inspector to demonstrate plot sales for a scheme like this of over over £95,000 a plot in this market?
So obviously it's service land with all the infrastructure gone.
Yeah.
So there are no comparables. I've looked of this specific ilk. I know of comparables elsewhere in other markets, such as Wokingham, Arborfield Market by the MOD site, which is a large strategic site, and in excess of 100,000, about 130, 140 per plot. It's a bit higher value area, I can see.
Don't get me wrong, I'm sure around the country there'll be some fantastic values.
But as I explained in my chief, is that actually, when you look at my northern site, because these are sites that are not serviced. They are sites they've got outline planning consent or planning consent, but the applicant still needs to do all the servicing. They need to do all of the abnormal cost infrastructure costs. So actually, you can't compare that with my southern site. Well, you can, but you need to do some maths.
Yeah.
But you can compare that to my northern site, as I've shown. And my northern site is at 37,873 per plot, which is lower than the comparable evidence. So if anything, from a stand back approach, his evidence supports my approach.
Just to be clear then, take Swans Tree, Inspector, I think we'll know where that is. We've seen it on some of the plans in the inquiry. That's a 5.24.
Yes.
That's £45,900 for the land sold without line planning permission to a house builder. You're suggesting that is evidence that is it? Is this what you're saying? You're saying that is supportive or correlative with your evidence that serviced plots should be going at over £95,000.
As I said, if you take my service plot, you take off the infrastructure. So you take my service plot 95, you take off the infrastructure, that's 48, and you had a bit of finance costs because of that. I actually get to below £40,000 per plot. I get to round
I
about
see.
35, 37.
So you're saying that actually, at
Yeah,
you're
so
saying yes.
to compare on a like-for-like basis,
I see.
I need to do what, they've got to pay all the infrastructure, the abnormal costs. So
Right.
my 95 is not a like-for-like basis with these.
No. That's why I asked the
And
question.
so, deducting on a like-for-like basis, I actually get to a lower per plot value
I
than
see.
what comparable.
Okay, so
sold
you're
for.
saying actually that yes, you say yes, the Hyde scheme, even though Mr. Mitford Slade thought he was putting it in to show that values are lower. In fact, you say no, it's actually supportive of maybe even a higher plot, or at least as high.
But obviously, this.
Am I understanding that?
Yeah, it's supportive of mine, but obviously you've got to recognise, there are significant abnormal site-specific infrastructure of this site, so it could likely get a lower per plot when you incorporate all those massive high figures we got.
I will ask him about that. So the situation is that we've got some comparables. Sorry.
You said if you take off the infrastructure and
So if you
like to like, what do you get to?
I get to around £37,000 per plot. Roughly, it's because it's hard to estimate what the finance cost.
How much infrastructure? 30.
So the infrastructure is around about £38,000 per plot. Now this is
from what have you derived that number?
I need to check which appraisal, because there's multitudes. It's one of Mr. Mitford Slade's appraisals.
No, I'm talking about Swanstree.
Swanstree.
I'm so sorry. I'm so sorry. We're talking cross purposes.
Yeah. So obviously, a Swanstree, you would add the 48,000 to the Swanstree comparable, for example. You could, and that would get you over 100,000.
So my question is, taking Swanstree as a local example, right?
Exactly.
You've got 45,900 a dwelling.
Yes.
You're saying to the inspector, yes, but that doesn't include. Well, it includes planning, obviously, because planning's been granted, but it doesn't include, you say, infrastructure.
The site-specific
now,
infrastructure.
my question is, how much infrastructure are you suggesting to try and get a sort of apples to apples?
So when you're looking at the service site appraisal on the southern site, that's about £48,000
I know, but it's a completely different scheme. I'm asking about Swanstree.
It is a different scheme, but that's how you can compare on a like-for-like basis.
But it's not like for like if you're comparing the infrastructure requirements of our scheme with the infrastructure requirements of Swanstree Avenue.
It's the only way to be able to compare. Now, I agree that Swanstree could have lower, hence why my figure comes to a lower figure than Swanstree. So it could have less infrastructure, it could have more. But
do you have any idea how much it's got?
I don't know how much it's got, of course not. So
you say of course not, it's all publicly available information.
Not the infrastructure, no, because it's...
Fine. All right then, fine. I will ask...
The householder will know that. They're not going to share that publicly, are they?
Well, I'll ask Mr. Mitford Slade about what that shows. But that's understood anyway as to what you're suggesting the numbers show. Okay. So, long and the short of it, direct comparables, then we'll stop for lunch, direct comparables that actually demonstrate land sales at the equivalent of £96,000 per serviced plot, that you say there aren't any, but I, Mr. Gardner, can infer from the values that have been achieved for unserviced parcels what they would be, and they are supportive of my analysis.
And as well as when you look at my northern
site,
and as well as when you look at my northern site is, I just need to get the per plot figure, is 37,800 per plot. So that includes, that's an unserviced plot. So on a like for like, you can see that's 37,800 unserviced.
Okay.
We're over 45. Obviously, there is then the 70,000 comparable as well. So there's others.
Yeah.
So it's,
we've not got
50
a problem
to 60,
so much
I think
with
he
that,
said.
but it was the 96,000, because obviously, as I say, neither us nor Mr. Spilsbury can get anywhere close, remotely close to your 96,000, and that's why I'm asking the question. And obviously, if you're right about the 96,000, just to make this clear, if you're right and we're all wrong about the 96,000, there's another 100 and, well, at least 120, maybe 130 million pounds in this scheme that we've missed and Mr. Spilsbury's missed, and that's why I'm asking you about it.
That is correct, and as you say, when you do that like-for-like comparison, it actually shows, take the infrastructure off, I'm at a lower per plot basis, so those comparables do support, the findings of my appraisal.
All righty, well, I'll ask Mr. Mitford Slade about it. I will change topic after lunch and pause there.
It would be quite helpful if you don't mind, because you do tend to answer quite fully when you ask a question. If you could just say yes or no and then qualify.
Yep, that's fine.
Sometimes I get so confused about what you actually say.
Apologies.
Because you go off in all directions.
Okay.
So that would be helpful, thank you.
Lovely. Thank you very
Okay,
much.
Very good. Thank you very much. So we will adjourn until 25 to 3. Yeah.
We won't. Let's just work this through. So 25 to 3, finish 3. I don't think we're likely to get the chief. We'll see. I don't think we're likely to get the chief done of Mr. Mitford Slade today, but we'll
I
see.
didn't think so. I've got another witness.
No, I know. But then just
As
that,
I said at the very beginning of the day.
as you said, what? Sorry.
Well, I said we would get through Mr.
Oh yeah,
Gardner and
yeah. No,
Mr.
you were
Finch.
right. You were right. Just the issue then come. Well, we'll see. We'll see how we go. But tomorrow is going to be a challenge, tightness-wise.
You might like to think about starting at 9 o'clock.
Yeah.
I really don't want to go on.
We can't. We can't because of just
No.
knock-on effects on. I thought you meant going onto different days.
No.
Sorry,
well,
I
I don't want to
misunderstood.
sit, beyond about 5.
Yeah. Of course.
But I'm happy to start at 9.
Fine. I'm going to hold you to that.
You thought we'd be halfway through Miss Mitford Slade today, didn't you?
I didn't know it'd be such a debate, such an interesting debate.
Right. Anyway, let's have lunch, shall we? 25 to. Thank you. 2:02, so time for the inquiry to resume.
you.
I'd like to carry on.
Will do. Good afternoon, Mr. Gardner.
Good afternoon.
Just a couple more of the inputs into your appraisal, where there are big differences between us, but I want the inspector to understand what the nature of those differences is, and then in some ways leave it to her to adjudicate on which is the preferred approach. So we were in your proof on page 45.
Yep.
We have now discussed the things that go into what's shown on here as being 136 million. It's slightly different, but it's over 130 million, whatever. So we've talked about that first really big difference between us, and it relates to all the things we were talking about before lunch. The next thing I want to ask you about, won't go through all of these, but just the really, really big ones. The next one is commercial land values, which is two rows down on the next page, on page 46. Just see commercial land values, the difference between us is just over £81 million. At that point, it'll be less now because
Yes.
because of Mr. Mitford Slade coming up from £400 per square
400,000.
acre to 700,000. But in any event, it's still a chunky difference between us, because as we've discussed, we're at £700,000 per square. I think it's acre, isn't it? £700 a square acre. You're at for a square acre. I mean a net acre. £700 a net acre. You're at £1.5 million a net acre, and Mr. Spilsbury's at £500,000 a net acre. That's the sort of nub of it. Yep.
Yep.
Oh, sorry. I'm on page 46 now of the proof of evidence. Sorry. And it's just, we've done, good. So that's I think just for the inspector's note, it's noted in here at £81.3 million as being the difference. I work it out as now being closer to 66
It's
million.
about probably
but
around 50, 60 million, something like that.
it's either
yeah.
way, it's still obviously pretty big. So that's that. So to put it in a nutshell, for commercial land values, where you are is 3 times as much as Mr. Spilsbury and over twice as much as Mr. Mitford Slade.
Yes.
And the basis upon which you reach that view is the comparable examples that you set out in your proof of evidence on page 16, if we could turn to. If you could turn to 16, thank you. There are 6, aren't there? And well, I suppose
Yep.
slight care to be taken. I mean, it's obvious, but it threw me for a few minutes anyway. You've expressed the table, no criticism, but you've expressed it as a per hectare, pound per hectare, when in fact the numbers I've been going through with the inspector just now are actually all per acre. So there's a little bit of conversion that's required.
Yep.
And if we were to do it, actually, I'll just run through them as to what they all are per acre. Number 5 Eurolink is 395,000 per acre. The second one down is land north of, can't pronounce that, Housen Avenue. That's 384,000 per acre, isn't it? The third one down is 435,000 per acre. I'm rounding.
Yep.
But the fourth one is 652,000 per acre.
Yes.
The penultimate one, are you getting these, madam? Yeah, oh, well, yeah. Just good. The penultimate one, block 1, precision 2 industrial estate, is 1.12 million per acre, I think.
Yeah.
And the last one, which is the KSP, is 880,000 per acre. I've just been through those just to try and make it all a bit more comparable with the figures that we'd been talking about before. So to cut a long story short, then there are 6 comparables on which you rely. The first 4 of them are all transacted at under £700,000 per net acre.
Yes.
The last one is the Kent Science Park. It's 27 hectares. It's the whole KSP.
Yep.
And that was, are you aware, or do you? I don't know whether you know or not. That was represented an internal group sale of the entirety of the KSP, as in an internal company sale. So that included all of the existing businesses, buildings, tenants, infrastructure, everything that's there at the KSP within that.
Yeah. From further research, I realise it has the buildings, etc. on. So it's not.
To be fair, not really a comparable.
Yeah.
So to be fair, we should strip that one out.
Yeah.
So the first 4 are all under 700,000 a hectare. The last one we strip out, and we're left with the penultimate one, aren't we? Which is Block 1, Precision 2 Industrial Estate.
Yeah.
And that one is the only comparable in your evidence that results in a cost of over £1 million per acre.
In relation to those comparables in this table, yes.
Yeah, and that one is for a site that is under half a hectare.
Yes, they're all very small sites.
Yeah, so to be blunt about it, your own comparables don't actually come anywhere close to supporting your values. Your table, if you strip away KSP, which we've agreed that you should, your table produces an average per acre sales cost of around £482,000.
That would be the average.
Yeah, and it's a similar problem to the residential values.
Sorry. Actually, the average would be 600,000 if you include
per acre.
if you include the 1.1 million. Are you?
No,
yeah.
I'm including that, but I'm doing it on a per acre basis.
Yeah, it's about 600,000, 597.
Oh, well, I've done my maths wrong, because I'd calculated it at 482. Anyway,
600,000.
Fair, fine.
Yeah.
Whatever. If you strip out KSP,
Yep.
which we've agreed that we should, the average per acre commercial values that you evidence are well under half of what you're actually saying the appropriate commercial values are in this case.
Yes.
Okay. Oh, thank you. There was just one more thing to ask you about in terms of commercial land values.
Yeah.
And it was your reference to your rebuttal. Just find it. In your rebuttal on page 10. So if you could turn to that.
Yes.
Thank you very much. Reference to the map that LSH produced.
Yes, that is correct.
And you said, well, I'm summarising because I don't know exactly what you said. You said we're in Milton Keynes territory, as it were, which is to say that obviously we're not near there, but in the sense that you expect values to be sort of broadly.
My value assessment is, as you said, within the Luton Milton Keynes. Yes.
So that's the sort of thing.
Yeah.
Okay. Milton Keynes is in the Golden Triangle for industrial and logistics.
Yes. Yes.
Which makes it one of the best industrial and logistics locations in England, or in the whole UK, because that means it's within a 4-hour drive of 90% of the UK population.
It is in a good location. I agree.
It's amazing. I mean, Milton Keynes is absolute, in terms of logistics, industrial and logistics, it's absolute primo territory, isn't it? Because you're at the confluence of all of those strategic roads, like the M1, etc. And you can get to London, you can get to Manchester, you can get to Birmingham, you can get to Sheffield, you can get to Leeds. You're in this part, that's what they call it, the Golden Triangle.
Yep.
And we are not, are we?
Not in that perspective. No.
But we're not. So in fact, it would be quite surprising, wouldn't it, for us to stand back and have a think about this data, if in fact industrial logistics values in Sittingbourne were equivalent to, or even, let's be honest, anywhere near those that can be achieved in one of the strategically
I would argue, still strategically in a very good location in terms of motorway as well as ports, etc. As you see, like Thurrock, for example, across the river, similar. Obviously, it's in Essex. A bit closer, yes. Just one point, and I think it's a point. It's about the difference between service and non-service, and obviously that is a factor of contention, but it's a factor of how I've come to my values in terms of, obviously, the values in this table are values based almost, they call it a, almost greenfield assessment, which is no abnormals, no site-specific infrastructure costs. So that's why they're at that level. Now, if in reality at Milton Keynes, if you have a load of abnormal costs, then that level transacted would be lower, and so that's obviously how I've assessed the land value. Again, no abnormals, no site-specific infrastructure costs, because they're elsewhere in the appraisal. Hence, you get to the larger land value.
If the inspector said to you something, words along the lines of a question like, is there any evidence that commercial land for industrial logistics is actually sold at £500,000, what the same should be in city law?
There's the one at 1.1.
Ever? I mean, the answer is, well, there isn't. We've got a 0.4 hectare site at 1.1 million per hectare in the Bingham Road estate. Other than that, your average is down at 600,000 a hectare, or an acre, sorry, which is actually lower than what we've got in our rebuttal.
Quite historic, 2018,
All right.
2019. So, yeah.
Okay.
The reliance on it is there isn't a lot out there, as Mr. Spilsbury.
All righty. Thank you very much. Obviously, yeah, Mr. Spilsbury thinks we're too high. You think we're too low. Anyway, last big item is benchmark land value. Because I think if we turn back to your proof of evidence, your main proof, onto page 46, we see at the bottom of page 46, hopefully, in the same table. 46. There it is, benchmark land value, and that is another chunky difference, where the difference between us is £54 million, as you explained, because our benchmark land value, and this is one where, just to come for the inspector's note, we are aligned with Mr. Spilsbury on this at or around 117 million. On the basis of an EUV plus approach applied across the whole site. You were at 66,467, so...
I would note that you're actually at now 136 million.
Fine.
Mr. Mitford Slade.
Change the value. Fair enough. Yeah, okay. Either way, there is a difference between us on BLV of tens of millions. And that's absolute. I mean, it's an obvious thing to say, but that is a critical difference for your microphone. So just so you know, your mic, that is a critical difference for the purposes of your assessments. All of your sensitivity tests all seek to adduce viability position as against your £66 million benchmark land value.
They do.
So when you come to things like, earlier on you were talking about build costs. And I said, well, your build costs are a lot lower than ours. And one of the things you said was, but I have sensitivity tested up to what I can't remember what it was now, 160 or something. Okay, but that too, that sensitivity test, it shows, you say, viability judged against a benchmark land value of 66 million odd pounds.
Exactly right. Obviously, the inspector could look at my residual land value and judge it against the 136 figure. So
of
it's
course
laid out in the table, so you could judge it.
Totally. I'm not suggesting that she couldn't work that out for herself, of course.
Yes.
But you're presenting it in that way.
Yeah, perfectly correct.
Okay, so it is actually, it's probably the single most important difference between us. It'd be fair to say that the fundamental basis upon which viability is judged, we are out from each other by, well, what is it now? It's probably over 60 million. Is it 70 million pounds? In terms of what the RLV has to get to in order to make everything work.
Updated.
Yes, good question.
About 136 million.
So it's now 136 million. So we could do.
This is just for the southern site. Obviously, the northern sites.
This is all for the southern. I'm just testing it all with the. It's the same sort of thing for the northern, but different numbers. Okay, right. Now, and the nub of it is, the nub of the reason why you do this is,
Yeah.
as you explain in your proof, is because you say that the uplift on existing use value should be applied to the net developable area rather than to the gross site area as a whole.
Yes.
To summarise.
Adopt the same methodology as Warburton Lane.
Yes, Warburton. We are coming to that one. A very exciting moment. We're going to go into the decision in a minute. Can I just ask you a question about your work where you've considered this issue before? So you mentioned in your answers before lunch that you're working on a scheme in Barnsley
Yes.
called Barnsley West.
Yes.
And you're working on the viability side, is that right? Of that,
Yes,
that's what you
yes.
said. I thought.
Yeah.
And in Barnsley West, your firm Continuum put in some viability work earlier on this year.
Yeah.
And as part of that viability work, this is a scheme of what did you say? It's 1,500 or 1,200?
I can't remember.
It's four figures. I can't remember how many units it is, but anyway, I mean it's a hybrid application as you've explained, and you put in a viability work that set out an approach to benchmark land value. Do you remember?
Yeah.
And what approach are you advising the council to take there in Barnsley West? Are you telling them only to apply an uplift to the net developable area of the site, or are you telling them to apply the EUV uplift to all of the site?
I'd have to look back. I can't remember what I applied.
You can't. I can't. It's strange that you can't, because you'd have thought that this approach that you're advocating, based on this Warburton decision, that's clearly a very important decision, and we're going to get to it.
Yeah.
But that you'd thought there'd be no reason, would there, on a sort of site-by-site basis, to do anything other than what you think the right answer would be, which is to say that you'd say, I think, as a matter of principle, you'd always want to do it on the net basis,
yes,
right? You're not saying it's site-specific. You're saying that as a matter of principle, the correct approach, following our inspector in Warburton, which we'll come to, is always do it net. So if your own work 2 or 3 months ago, or what was it, January, had done something different and applied an EUV premium to the entirety of that strategic site, it's a bit problematical, isn't it?
Yeah, could be. Yeah.
Well, that's obviously what's happened. You might as well cut to the chase.
Well, that is what. All right then. Well, okay. What we'll do is because we've got because most of it's confidential, but what we have got on the council's website is a 3-page FVA summary from Continuum produced by you in January of 2025, which does the following things. Let me see if I can help you refresh your memory. No. We've only just. It's because he said he was working on Barnsley that we've looked it up over lunch. So what we're going to do is print it off and circulate it. But it's just to see whether you can remember it, because it's your own work and it's not very long ago. It's this year. The first thing it did was to apply EUV premium to the whole site, not just the net developable area. Do you remember?
Maybe. I need to just look
Need to have a
detail.
look. All righty. Well, you can have a look.
It was a mix of some brownfield with some greenfield, so I just need to have a look.
Okay. Right. Okay. The next thing that it did was to adopt a 20% profit approach to GDV, profit margin on GDV.
Originally, we reduced that down based on the risk assessment with negotiations with the council.
Okay, it's up at 20% in the note. All right then. And what was the other thing that it did? And when it comes to build costs, it uses BCIS figures with no reduction for householder efficiencies that you were talking about earlier on.
Yeah.
So, what does any of this ring any bells with you, or is it too distant in the past to really recall?
Yeah, part of it rings some
Part of
bells.
it. That's good. That's good. So we'll see what it says. But it's important, isn't it, that if we're going to present evidence, professional evidence, to a public inquiry, that we're straight up about it, and that we give the inspector our bet. So it's wrong, isn't it, that when you prepare FVAs for for strategic residential sites. That you always adopt the Warburton approach to BLV. You don't always.
Yeah, in that case, obviously,
Okay.
I'll have to look at. Clearly,
You
did not.
can check it out, but I'm sure you'll remember it when you open it up. Okay. All right then. And there's nothing site specific about this. Just to be clear, is there? There's no reason that we should do BLV uplift, EUV uplift site-wide in Barnsley, but we should do it net developable area in Kent. There's no analytical distinction.
Not fully.
No, I
I'd
can't
have to
think
look
of
in the
one.
gross net and things, but yeah.
Sure. Okay. What is EUV Plus about? It's about, isn't it? Providing a premium, obviously. That's what the plus is. To give the minimum incentive necessary to induce landowners to release their land for development. Is that fair?
Yep, that's correct.
And if that's the principle,
Yep.
we turn to what Mr. Mitford Slade says. Let me just get up his evidence. Mr. Mitford Slade has appendices to his main proof of evidence, and if you could turn up Appendix 7, that starts on page 144. So, I don't know,
What
you
page
tell
is
me,
it?
thank you so much. It's 144, 144.
Yep.
Okay, so this is just the front page of what this is on 145. It's marked draft, produced by Aspinall Verdi.
The
It's
local
called
plan.
That's it, local plan viability study produced for the council back in December of 2020 when they were at that stage doing a local plan, alas.
The
No.
adopted one, was it?
No, the adopted one was adopted
Oh,
in
no, that was
2017.
before.
So
Of course, but
this
the
was part of the then
review.
emerging evidence base that was
Yeah.
supporting the then emerging local plan exercise. This is the viability stuff. Aspinall Verdi commissioned by the council, looking at it swale wide, as it were. So not just this site or even Sittingbourne, but looking at it across the borough. Could you just turn in it to page 167 in terms of the bottom right-hand side pages?
Yep.
And you'll see on 167 at 3.20, excuse me, there's having been through the PPG about premiums, there's a reference to something called the Harmon Report.
Yes, I'm aware of the historic
I'm sure.
2012 report. Yes.
Absolutely. Published in response to viability becoming prominent post MPPF, recommends an EUV plus approach, advocates an appropriate BLV, having regard to plan policy requirements, etc., etc. If you just turn over the page, it says top line, so the report acknowledges that for large greenfield sites, and just pausing here, this is a pretty large greenfield site, isn't it?
Yes.
It's about as large as they get. Landowners for sites like this are rarely forced or distressed sellers. They generally take a much longer term view over the merits or otherwise of disposing of the asset. These prospective sellers are referred to as, quote, potentially making a once in a lifetime decision over whether to sell an asset that may have been in the family, trust, or institution's ownership for many generations. And in these circumstances, Harmon states that for these greenfield sites, that the uplift to current use value, which is, I think, that's the same thing as EUV, right?
Yeah.
Yeah. Sought by a landowner will invariably be significantly higher than in an urban context and requires very careful consideration. Well, here we are considering it, but anyway. So there's a suggestion, isn't there, that for these larger scale land holdings in greenfield areas, just like what we're talking about here, where potentially land's been in a family or in a trust or whatever for a long time, and there's a once-in-a-lifetime decision over whether to sell, you've got to very carefully consider the premium, haven't you? You've got to make sure that the premium's enough to incentivise this once-in-a-lifetime sale happening.
Yes, as the PPG requires you to do, as well as take into consideration the normal costs, site-specific costs, and cost of policy compliance, etc. I mean,
very much so.
This does obviously harm and predate updates from the PPG, but yeah,
Yes.
the premise I don't disagree.
Well, the premise is pretty sound,
Yeah.
isn't it? Because it really is what the PPG is all about. It's trying to make sure that we can actually incentivise land coming forward.
Yep.
And you referred to the PPG, but there's nothing in the PPG, is there, that indicates that the premium on EUV, the plus, should only apply to the net developable area of the site.
Yeah, I agree. There's no definition in the PPG or ICS on whether to apply it to the net or the gross.
To try and test your suggested approach about it being net rather than gross. I say your suggested approach, the approach that you're telling this inspector about, so I'm not sure it is your suggested approach elsewhere in the country. Take this site, take the southern site, assume a couple of landowners, 2 or 3 landowners, this is hypothetical, just to try and test it. You've got this large area of land and you've got it, say, divided into 2 or 3 different landownerships. Let's just say that one of the landownerships has all the, as it turns out, is where all the houses are going to go, as it turns out. And one of the landownerships is where the motorway junction, say, is going to go. And let's say that the third landownership happens to be where, in fact, there's hundreds of acres of open space or green infrastructure, or just parkland or whatever.
Yes.
In a situation like that, that third landowner, on your approach, loses out big time, don't they? Because they're not within the net developable area.
In terms of the way, 'cause the approach kind of adopts how the residual land value dots, which is applies value. Now you can net that back and equalise it all per gross acre, or you can equalise it per net acre, but you could still, everyone get it on a per gross
but that's
equalisation approach.
But the equalisation is not assumed in your methodology.
It can be there or thereabouts. It can be assumed in my methodology. I mean, the methodology is basically following what the appraisal does, which is apply how the appraiser is only applying a value to the value is kind of what the methodology does.
Let's just take a step back.
Yeah.
You've got this area of land, you've got these 3 different landowners. The third one, on your methodology, is sitting on land that's worth, let's say, £10,000 an acre.
Yes.
The first 2 are sitting on land that's worth £100,000 an acre.
Yes.
That's the way, that's what your that's where it takes us, to a world where landowner number 3 is supposed to be induced to sell on the basis of a tenth of the value of the per acre of the first 2, even in a world where their land is intrinsic to whatever the scheme is that's being brought forward. So in this case, there's a scheme with awful lots of green infrastructure. We've heard about it all, not going to go over it, but there's lots of different things, green infrastructure, parkland and open spaces and stuff. The scheme's not coming forward without that. It's coming forward with that, right?
Well, it's unclear. Some parts, it's still a bit unclear on some of the gross acreage areas are correct, that it needs to come forward. But yes, I agree.
Putting aside
the ones that are, it would need, you need this strategic landscaping area.
You need it, don't you? You need it to make the scheme
mitigate
work.
against the harm.
So that the bits with the houses on aren't worth too much if they haven't got all the bits with all the stuff that you need to make the houses work on too. Like ditto the area around the motorway junction. You've got a motorway junction, you've got a road running through it, you've got a lot of green space on either side of the road.
Yep.
You need that land in order to deliver the link road, in order to deliver the motorway junction, in order to open up the
yes, I agree.
the houses. So the point is that you've got all this land, all 3 parcels in my hypothetical, absolutely critical to delivering the scheme, but you're urging on the inspector this absolutely massive differentiation where anything that's essentially green, not being glib about it, but basically anything that's not actually got stuff on it, we're valuing at 10,000 per acre, and anything that happens to have stuff on it is 100,000 per acre. And you do all of this completely you base this approach on the Warburton decision, don't you?
Yes, I do.
And it would be fair to say that you have not referred to any other Secretary of State or Inspector decision where this approach has been expressed.
That is true.
So we've got one appeal decision. Luckily, we've got the right inspector to look at it, but we've got one appeal decision, which is for this point, it's the be-all and end-all in terms of the appeal decisions or Secretary of State decisions that have looked at this question on which you rely. Warburton.
Yep.
Okay. So, if Warburton was a completely different sort of case to this one, we might be all right. We might not need to get too worried about any inconsistencies between what you're saying here and what you've said in other cases, because Warburton's the only appeal or Secretary of State decision on which you rest your case.
Yep.
Okay. Well, let's have a quick look at Warburton. Finally, in your main appendices.
Yep.
So the appendices to your main proof.
Let me just get that up.
So there are rebuttal ones too, but it's the main one. And if you and the inspector turn to, it's page 27, appendix 8 is an extract from it. Did we put Okay. You just tell me when you're there.
I'm there.
Thank you. So this is only an extract.
Yes.
We can obviously put the whole thing in. I'm not sure that we need to, but it's...
Mr. Simons, if it helps, I've got the complete version of the case and I had them printed off.
Oh, in your appendix? Yeah. To your rebuttal? Yes. I thought it was there. Sorry, I'm really sorry. This is... The whole one we've put in, I thought we put it in. It's Mr. Mitford Slade's appendix rebuttal appendix 5 is the whole thing. Sorry. Thanks. I thought we put it in. I couldn't remember where. Okay.
'21.
2021?
Quite a long time ago, wasn't it?
No, not at all.
Amazing. Remember it like it was yesterday.
So, have you got that one, Mr. Gardner? You do. Thank you very much. This is a Red Rose scheme. Again, appeal against Trafford, 400 homes at Warburton Lane in Trafford. Appeal dismissed by what I'm told is a very eminent planning inspector, but I don't know about that. Now, if you could turn in it to the issue that we're talking about now. This is the financial viability assessment. That starts on page 25. In fact, no, it doesn't. It starts on page 24, sorry, of the appeal decision. That's page 83 of the appendices, sorry. So at DL 114, there's a heading, benchmark land value. Have you got that,
Yeah,
Mr.
I'm
Gardner?
on that.
So this is the inspector considering what was happening there. Existing use value enhanced by a premium, that's EUV plus. There was a debate about whether that number should be £10,000 per acre for EUV or £8,000 an acre, and the inspector went with the council's approach. In this case, £10,000 an acre as the EUV level is actually agreed.
It's agreed.
It's one of the things that all three viability witnesses actually agree on, so that makes it a very valuable starting point indeed. 115 of the decision talks about what's in the PPG about reasonable incentive for landowners to bring forward development, etc. And all of that stuff that's at 115 remains all accurate and correct now, I think, doesn't it? At 117, we're told that the appellant originally considered that a premium of 20 times EUV was appropriate. but then they reduced that to 15 times EUV to reflect a particular appeal decision. And 3 lines from the bottom, my colleague indicated that typically 15 to 25 times EUV is applied to greenfield sites, but where that comes from is not made clear. In any event, just to again pause, in this case, not only are we agreed on what the EUV is, which is 10,000 an acre, we're agreed that where there is to be uplift, the areas where there's uplift, we're all at 10 times. So no one's saying 25 times or whatever in this case.
Yep.
Okay, so far, so good. That's 118. The planning practice guidance gives no indication as to what the uplift should be. Square brackets, if only it did, that would make life a bit easier. And the reason is that it'll vary according to specific circumstances. And there's no evidence that I've seen that says the premium should be at any particular value. Again, just pausing there. We actually agree what the premium should be here, we just don't agree the geographical area over which it is to be applied.
That's correct.
Yeah. The last sentence of 118 says the important point is that it should be sufficient to incentivise the landowner to sell the land, and should also be the minimum incentive for such a sale to take place, which is correct. And in fact, I think it's something very similar to what I said to you and we agreed a few minutes ago. 119 is where it's at. 119 is what this whole debate about BLV turns on. In fact, it doesn't even turn on 119, it turns on a footnote to 119. So let's take 119 in stages. 119 says the appellant's assessments on the basis of an uplift of 15 where the council prefers an uplift of 10. Again, we don't need to get embroiled in that debate because we're all at 10. Now, next sentence. It is relevant to note in this case that one of the 2 landowners has agreed in the option agreement to sell the land for whatever is left after a standard residual assessment. You see?
Yep.
We'll come on to what else is said. We're not at the end of the paragraph yet, but that's a particular feature of Warburton, isn't it? You had 2 landowners, right?
Yep.
And one of them, for whatever reason, we know not, we're never going to find out, we don't need to, but
didn't have a minimum price. That's
one
correct.
of them had said that, right, you do your residual assessment, you do that, and what I will do is I will sell the land for whatever is spat out at the end.
That is correct.
They'd agreed for whatever reason, we know not, but they'd agreed to go low, as it were. They'd agreed to whatever I would have been getting. I'm not going to get that much. I'm going to get whatever is spat out as a consequence of your residual assessment that you do. That was in their option agreement.
Yeah, I think the other one had a minimum price per net acre. I can't remember the figure.
So that was a particular commercial situation that arose in that case that our inspector, the inspector said was relevant to note. You can see why it's relevant to note, because it's just been said at the end of 118 that what this is all about is incentivising landowners to sell, right?
Yep.
And we knew that there were particular circumstances in this case of relevance that meant that, yeah, this landowner's going to sell. They might sell for lower than you might expect because they've agreed to the option agreement that's explained in the second sentence, right?
Yep.
Okay, and just to state the obvious, but you can know what the question is and what the answer is going to be as well, but say it anyway. The circumstances there, those circumstances relevant, the basis upon which this decision is made, those circumstances do not exist here, do they?
I've not obviously seen any of the option agreements, so I can't say.
Fair enough.
Because I've not seen it.
From everything you've seen, there's no evidence before the inquiry that the circumstances are comparable.
I've not obviously seen the option agreement, so I can't say one way or the other whether something like this is in it or not.
Okay. So you have no evidence that it is comparable. So doesn't that mean then, even before we see what our inspector actually said about this, we've got to tread very carefully about copying and pasting the sort of logic of 119 to a case where there's no evidence to support the idea that these are even vaguely comparable scenarios? Got to tread carefully, haven't we? Don't you think?
Well, the consultants, I don't think assessed the methodology based on this point.
All right.
Is what I'm saying is that, but before this point came out after the fact of the appeal, from my knowledge of being involved, it was just a methodology adopted by different consultants adopt different methodologies for BLV. So there's always a bit of a difference. But yeah, I can see the point you're making.
All right. 6 lines from the bottom. Well, in fact, I'll just read it. We're almost there anyway. It says, on the basis of an appellant's assessment, this is 5 lines down, with no affordable housing, the residual land value is 2.8 million. But if costs or values change, this would, of course, be a different figure. For example, on the appellant's assessment, with 45% affordable, the residual becomes negative, so non-viable. In such circumstances, the landowner obviously would not sell. I consider that an uplift of 10 would not be unreasonable here, and that results in a BLV of about £2.9 million, footnote, and we see it in the bottom, footnote 13, that is calculated on the basis of the net developable area, not the entirety of the site area.
That is correct.
This is found by our inspector on the facts of that case to be adequate to incentivise the sale of land to bring forward the development.
That is correct.
In those circumstances.
That is correct.
What this decision does not say, does it? That as a matter of generality, EUV premium should only be calculated on a net developable area basis.
Yes, it does not say that.
Because if it had said that, you wouldn't have done what you did in your Barnsley West example.
Correct.
All right. That's that on that. The review mechanism you've not seen, but will hopefully get involved in the 106 session, so I'll park all of that. Just asked you about the review mechanism, and the last thing was something I'm not going to. You caveated your earlier answers about scheme deliverability with reference to Mr. Spilsbury's concerns about cash flow, finance costs, years 1 to 5, what's being occupied in year 2, all of that. I'm not going to ask you about it because I've asked Mr. Spilsbury about it. I'm going to ask Mr. Mitford-Slade to talk us through how his cash flow works tomorrow. Which means, Mr. Gardner, I've got nothing else for you. Thank you very much indeed. And what we will do is circulate the that 3-page thing that I mentioned earlier on to do with Barnsley. We'll do it. We could send it through to the programme officer now, and hopefully it can be printed. But thank you very much.
Could Mr. Simons, could I have a copy now, please? Thank you.
The witness would be so kind as to just go on that side. It doesn't really. I have to see the whites of their eyes generally. Thank you very much. So if you could take up the Warburton Lane decision.
Yep.
And my learned friend was wondering why the landowner in that case might choose to, as is explained in paragraph 119 and recorded by the inspector in her decision, why one of the two landowners had agreed in the option agreement to sell the land for whatever's left after a standard residual assessment. Do you see that?
Yep.
Now, the fact the inspector, who obviously is in this room as well, that inspector, this inspector, decided to note that, means that the inspector obviously thought that was an important point, yes?
Yes.
She says, it is relevant to note, which would suggest it was relevant to her reasoning.
I agree.
Yeah, good. So to understand why that might be, travel back with me to the start of the decision. And if you have a look, please, at the inspector's reasons, they begin on page 4. Do you have that?
I'm on page 4. Yep.
Lovely. And it has planning policy in context. And paragraph 16, the inspector records the appeal site is within open countryside to the south of the settlement of Partington and immediately to the north of the Greenbelt. Under Save Policy C8, it's included in a wider area that is designated as protected open land. Do you see that?
Yes.
Probably all coming flooding back for the inspector as well. Yeah, it's funny, but the purpose of this is to avoid the need to review the Greenbelt boundaries in the event that more land is needed for housing in the longer term following a review of the UDP. Do you see that?
Yep.
This designation was carried forward in policy R4 of the core strategy, where it was termed other protected open land. The policy itself only permits future use for limited uses, which do which do not, do not include a residential development such as is being proposed here. Do you see that?
Yes.
Okay, so this is an extra layer of protection on top of the open countryside, which is, as it says on the tin, seeking to protect the open land, and the inspector will know the significance of the word protected in the context of the MPPF. Now, so I'm being fair, it goes on to say the supporting text explains that the land is not identified for development within the plan period, but may be required to meet future housing needs following a strategic review of the Greenbelt. No such review has been undertaken, right?
Yep.
And for me and Mr. Spilsbury, we've had many happy months in Manchester where that strategic plan has now finally progressed, just the Court of Appeal to jump over. The position is that this land had that extra layer of protection, but what it was doing was signalling that it might be suitable in the future, yes?
Yep.
Okay, but we then need to read it with Inspector Down's paragraph 27, where she faithfully records what the UDP inspector said about the site. So paragraph 27, page 6, do you have that?
Yes.
Notwithstanding the safeguarding of the land to the south of Partington for potential future development needs, so acknowledging that point, which I've just hopefully very fairly put to you, she says, notwithstanding that, the UDP inspector, and you know what I mean by that, the local plan inspector, it's a unitary in Trafford, in his 2003 report, had serious concerns with regards to its suitability for housing. Do you see that?
Yes.
He opined that this land was poorly integrated with existing housing and community facilities in Partington. He saw the Red Brook, its wildlife corridor, and its floodplain as severely inhibiting such integration, yes?
Yep.
The inspector goes on to note a few changes, like a new local shopping centre. And then she says, nevertheless, insofar as the inspector's comments, that's the UDP inspector, yes?
Yes.
Related to the locational relationship of this land with the adjoining settlement, his comments still resonate, yes?
Yes.
The comment you were highlighting was the severe restrictions, the serious concerns the local plan inspector had about the development of this land, yes?
Yes.
Now, I'm a landowner of that land, and that report will have come as something of a disappointment, to say the least, I would have thought, as a consequence of which that landowner's expectations have had to be adjusted, yes?
Yes.
And that would explain, wouldn't it, why, you have to ask yourself, Mr. Simons asked himself, why would a landowner sign up to that? The expectations that had been seriously inhibited for residential development in that area for that landowner would be reflected in the fact the UDP inspector had serious concerns about the site coming forward for housing, yes?
Yes.
So, frankly, that landowner and the other one, if the land was included, which it was, both of them would be frankly grateful for anything if their land came forward for housing, yes?
Based on what you're saying, yes.
Yeah. Now, we don't have that situation here, and you raised a point, I think, in answer to Malone and Friends. One thing the applicant here could do is either provide the legal agreements to show that there are minimum land values, or the solicitor could sign a statement to say that. But we've no evidence at the moment that there isn't a reasonable minimum land value associated with the landowners' agreements here, do we? We don't have any evidence like that. No. And nor do we have a finding from a UDP inspector. And remember, if you get a conclusion like that from an inspector, and your only way forward is an appeal, you've got to then try and persuade an inspector another inspector to come to a different conclusion. The fact is, we don't have an adverse set of local plan inspectors' comments about this site, do we? This one in Sittingbourne.
Not I'm aware of, no.
No, be lucky to have a local plan. So the point is, we don't have that inhibition there. So that would explain, obviously, clearly a distinguishing feature. You accept that, don't you?
Yes.
Good. Okay, now what I'd also like to do, if I may, is have a look at your Barnsley evidence. We've got hard copies of that, or I think others. It's the service I receive, you see, that I get hard copies.
I have just to say, I have emailed it. Well, I think is it the 4-pager?
It's just the executive summary.
Yeah, that's all I've got. I've emailed. It's January 25.
Yes.
I have emailed it.
Oh, November 24.
Oh, I've emailed. We've got Jan 25. It might not matter, but I've emailed you, Chris, and the other barristers, also the programme officers.
Okay.
So it'll be on your email. But I don't know if it matters.
Okay. Do you have a copy of it? Has it come through to you? Okay. Well, I'll read it out, and if there's anything you want to change later, you can come back.
This is this is a November 24 version of the thing that I've sent around. That's January 25. So it's not the same that's been circulated.
If I use the one that's been circulated,
yeah, that would be better. That I think is
yeah,
the one that's been circulated. Yeah. I don't know whether it's got an ID. Let me check. It might do. They're very efficient. Not yet. Not yet.
So
it will be number 52, just to say, but it's not been put on yet.
Yeah. So
it will be, yeah, but it's not on the website yet. Sorry to interrupt.
You wrote this, is that right?
Yes.
You're the author of it.
Yeah.
And as Malone Friend rightly observed, it was actually earlier this year, yes?
Yes.
Things are coming flooding back to the inspector from 2019, but you don't have to stretch your memory that far back. I look down and I see on the third bullet point, the subject site consists of 75.04 hectares, 185.44 acres. That probably the sort of size of site you remember, yeah?
Yep.
And you set out a total Section 106 ask of 23 million or 14,891 per unit, so nearly 15,000 per unit. And then you say this: standard build costs have been adopted with reference to the local plan evidence base and utilising BCIS, yes?
Yes, that's correct.
So what you advocate, because on this occasion you're acting for a developer known as Strata Homes, yes?
Yep.
And whilst acting for that developer, you utilised the BCIS, didn't you?
Yes.
Yeah. You don't actually say which quartile you used, which is unfortunate.
It's lower quartile.
But presumably it was the lower one, yeah. And you say Continuum have utilised that, the estate housing, and generally BCIS figure, which reflects houses of mixed heights. So it's right to record, as Malone and Friend observed, you obviously haven't said to this inspector, goodness, you shouldn't use the BCIS,
yes.
Have you? You have, when acting for a developer earlier this year, used the BCIS, yes?
Yes.
Without deductions, yes?
In this case, yes.
Yeah, well, obviously in this case, but in your application of deductions,
yep.
Please can you point me to any other appeal decision where an inspector presented with the BCIS has made deductions or any other evidence where you've convinced a decision maker to take the lowest of the BCIS figures and then apply deductions to those.
So I know that was the case applied at the not for me.
No, just where in your evidence do you refer?
There's nowhere else. I've only put the Warburton lane.
Yeah, we've got no other evidence. So the inspector is faced with knowing that you, on other occasions, acting for developers, are happy to use the BCIS, yes?
Yeah.
She knows that you've made deductions in this case, but haven't provided any evidence of that being done elsewhere.
Yeah.
Good. Okay. I was also interested, it's a sort of gift that keeps giving, really, this one, that Continuum have then allowed for Part L and future home standards uplift, which equates to 3.74 pounds per square foot and 4.53 pounds per square foot, respectively. Yes.
Yes, which
So-
I have allowed for future homes in my.
Yeah, absolutely. I mean, what I'm doing is, I think my little friend did it with my witness, so I'm doing it with you. I'm just getting you to confirm that on top of the BCIS, you've applied uplifts specifically for future homes, yes, which is
Yes.
the carbon one,
Yep.
and for Part L, which is the building regulations one, yes?
Yep.
Continuum's base build costs equated to 126 per square foot when including building regulation uplifts. In terms of external work, so you deal with that as well, yes?
Yep.
As a separate item, have assessed the edge infrastructure cost plan in order to ensure there's no double counting to the standard external costs. Continuum estimate that edge's cost plan includes £12.98 per square foot for externals. That equates to 10.5%. So we've got externals, as
Yep.
in, your driveway and the path to your house. We've got future standards, and then we've got updated building regulations, yes?
Yeah.
The three of them collectively then coming in at about an 18% increase, yeah? You've got 10.5%, and then against your 123 pounds per square foot, we add another 8, yes?
Yes. So
Yes.
it probably is a blend of 18%. This is a bit of a weird one because the cost consultant provides some externals, so it's
Yeah.
one of those ones hard to
You
estimate.
use the cost consultant. Yeah, okay, understood. All right, so that tells us that what sort of approach that you've taken there. All right, and then what I'm also interested in is the benchmark land value. Now, obviously, we've been discussing that in the context of the Warburton Lane decision. It's right that in this report, the benchmark land value that you'd identify, this is Barnsley, and
Yes.
some people are familiar with that part of the world. I believe it's near Sheffield.
Yeah.
I don't know anybody from there. But that is apparently in the north, and generally not values not so high. And 86,622 pounds per acre, yes?
Got 86,822. But anyway, yeah, per acre.
Yeah, so nearly 90,000 per acre, and that's up in the coalfield areas of the north.
Agricultural land values.
I would say this has brownfield and greenfield elements, but yeah, it was 86,822 per acre.
Yeah.
It was mainly greenfield.
Yeah, now here we are. I can jump on a train and be at Victoria within an hour. I'm definitely in the south of England. Generally, house prices and land values are a little higher there, aren't they?
Yep.
Yeah, okay. So it does make because you don't tell us actually what your figure is a gross figure per acre, gross acre figure. So
Yeah, it's about 50-ish.
yeah,
sub 50,
because we can do the maths, can't we?
Yeah.
You're doing it on a net acre basis, and I've dealt with that and the distinction with that in terms of the Warburton Lane, where the inspector adopted that approach. You can see that from the footnote. But in the context of your evidence, you don't say that, but it is basically just 50%. So
Yeah.
50%. So Sittingbourne, south of England, hour into London. This whole area is identified for large-scale development around the Thames estuary. £50,000 a net acre. and in the north, £50,000 a gross acre in the north, nearly £90,000 a gross acre in Yorkshire. That looks a little incongruous, but let me just ask you this.
Yep.
What comparators do you use for £50,000 a gross acre in this area? Where are your comparators?
I have not provided any.
No, good. Thank you very much indeed.
Madam, just looking at the time, do you mind if we potentially take the break so I can just finish reading through this Barnsley FVA summary? Sorry.
Read the Barnsley decision, the three-page Barnsley.
Same time. It's just in respect of
That's
re-examination.
obviously fine. It's just if would it be all right then if I know it's only been an hour? Has it only been an hour? I can't
I only need about 5 minutes.
If that could be our only break this afternoon, then then that's fine, and we just don't have a later break and we press on.
I'm happy for it only to be about 5-10 minutes.
Brilliant.
Are you happy that we finish Mr. Finch's evidence this afternoon, even if we sort of go to 5:30 or something like that, just so we get a clean
we have
start
to do
tomorrow?
that.
Yeah.
Definitely.
I would like, before you go, just to have a little quick chat about Mr. Mitford Slade's timings, because
Yeah.
I don't actually think, on the timings I've got, that it's going to be.
I couldn't agree more. I think we're in trouble.
I think we're in
I'm sorry to
trouble.
say.
Yes, well, I'm glad you.
Yeah, and I foresaw some of this.
All right, well, let's think about it over the
We
break.
will.
Okay, and then we'll discuss it before we finish.
Definitely.
After
Thank you
we've
very
had
much.
Mr.
So,
Finn.
did we say 15 minutes? 10 to?
Yeah, 10 to.
Okay. Thank you.
It's now 10 to 4, so it's time for the inquiry to resume. And you were going to do your re-examination. Did you want Mr. Garner?
No. I don't have anything in re-examination, so I'm not.
You haven't
going to
got
ask any further
anything?
questions. No.
Oh, right, okay, fine. There you are, let off lightly then. Thank you very much, Mr. Gardner. Right, Mr. Finch. Right, just hang on a minute then in that case. Just a moment.
Thank you very much. Mr. Finch, if I can introduce you to the inquiry. Your name is Colin Finch, is that right?
It is, yeah.
You're the Development Investment Team Manager for Kent County Council's Growth and Communities Division, is that right?
I am.
You have an HND in Sustainable Land Management and over 15 years' experience in securing developer contributions to mitigate the impacts of growth in Kent, is that right?
Correct.
You manage and oversee the County Council's policy approach to mitigating the impacts of residential growth on Kent communities, is that right?
Yes.
And that includes managing Kent County Council's development investment team that consists of 4 area lead officers, finance and management and monitoring officers covering the entire county, is that right?
Correct.
You've overall accountability for responding to all residential planning applications that impact on County Council services, and you're the officer responsible for authorising the sealing of Section 106 agreements on behalf of the County Council, is that right?
I am.
And your team manage you manage and take a lead in the coordinating of Kent County Council services to ensure that responses to applications and appeals are made in a coherent, coordinated and timely way.
I do try, yes.
Yeah, okay. Good answer. Some involvement in all large-scale planning applications in the county includes those currently live at Otterpool Park. That's in Folkestone Hyde, is that right?
That's right.
Oh, here.
Oh,
Seeing as he's cross-examining, do you think we should... Does he not want to hear?
this is just the qualifications and things.
I know.
So,
Okay. Right, carry on then.
Ebbsfleet Garden City,
Yep.
Whitfield,
Yep.
yeah. I just laugh because I'm involved. Chilmington Green,
Shilmington Green.
yes. Chilmington Green, we'll talk about that a bit later. Aside from this appeal, you're involved in other current appeals relating to the land east of Scholes Road, Northfleet, Harbourside and Chilmington Green, is that right?
Yes, other than we've mentioned that the Skockles Road appeal has been determined now, so...
Okay, yep, and the outcome of that was?
Mr. Simons?
we won. That one is the Skockles Road is actually now an inquiry document 100.50. It's one of the 2 that I mentioned the other day. The other one being Faversham. So
This is where the council didn't contest it.
correct. That's right.
Yeah.
That's right.
How do you say that so you can't count?
Shocking.
Not remotely competitive. Okay, and growth strategies for the borough's local plan review, is that right?
That's right.
Your role at the time was as the principal transport and development planner for Canterbury and Swale or Kent County Council's highways, a position now held by your colleague Alan Millard, who we've heard from. And at the time of the submission of the application in September 2022, you changed to your current role and you've been involved in evidencing and negotiating the County Council's requirements for the development to make the provision for education and community services, yes?
Correct. Yeah.
Good, okay. And during the appeal, your role has been to commission legal support, coordinate the input of the various Kent County Council services and any representations that were provided to the appeal, is that correct?
Yes.
And you were also involved in the commissioning of the highway cost report, is that right?
That's right. Yeah.
Yeah, and then obviously in the commissioning of Mr. Spilsbury and his evidence as well.
That's right.
Good. Okay. Your evidence can all be taken as read. What I'd like to ask you specifically about is just basically an overview of Kent's growth and the scale of the application, because this is an area experiencing growth. Kent County Council's got a lot of interest and a lot of large sites.
Yes.
So what's the background really to this growth?
Yeah. So I mean, Kent's population it's 1.5 million, expected to grow by 20% between 2020 and 2040. By 20% between 2020 and 2040.
Just get closer.
A little bit closer.
I said irritating, but you can't move the microphone.
That's all right. Okay. And historically, Kent has been reasonably pro-growth in terms of its strategies. We have our current Framing Kent's Future strategy, which is the County Council strategic strategy, and that sets out 4 key priorities, and I mention this in paragraph 2.3 of my proof of evidence. Priority 2 specifically relates to infrastructure for communities, and my role is to ensure that the communities receive the necessary levels of social and physical infrastructure to avoid unacceptable damages to quality of life. In line with the NPPF, we expect development to make positive contributions to the economic, environmental and health of our new and existing communities. So to turn to this application specifically, if approved, the 2 applications being heard will have a lasting and defining impact on the town of Sittingbourne, increasing its population by 27% from in the region of 54,000 to 74,000. 20,000 new residents that may need access to existing community infrastructure. And as demonstrated in KCC's response letters, or the last response letter, that's 1,400 secondary school children, 2,000 primary school children, and approximately 776 new contacts from ASC, adult social care clients, for which the county has statutory duties. So it's a large application, as we're all aware.
It talks about the growth. Kent County Council is the landowner of a new settlement at Kings Hill. Was instrumental in bringing forward that new settlement. I don't know, Madam, if you've seen that at any stage.
Where is it?
If you go to West Malling, Kings Hill is just behind West Malling. It's where the council's offices are. Yes. I venture to say it's one of the probably the most successful new settlement in the country. If you have a look, they've got supermarkets, large-scale employment, large-scale residential, very attractively laid round cricket ovals and things like that. It's a very successful new settlement and worth a slight detour off the motorway.
Yes.
Say, it was a
Kent County Council were the landowner, and they were instrumental with my client's Liberty in bringing, which is an American investment fund, bringing it forward and really help facilitate it, I think it would be fair to say, and facilitate what is a very successful new settlement.
Who built it out?
Liberty, and then they sold their parcels, like the developer model that the developer here is talking about, sold it out to various house builders. You can generally tell which ones. And yeah, it was airfield, And
Was historic airfield, yeah.
yeah, and Liberty's offices right to the end remained the control tower.
Yeah.
Oh, right. Okay.
Which made for interesting team meetings. But the point is, you can see a successful new settlement attached to a much smaller settlement built off effectively just an airfield.
And how many houses?
I don't know off the top of my head.
We'll have to check. I think it's
Check.
about 8,000, something like that. But we'll
All right.
check. It's a big settlement.
Okay, thank you.
Employment, retail. I think Asda and Waitrose are there.
They are.
All
yeah.
those a successful settlement centre. Right. Enough self-promotion. The viability for both of us. The viability issue here, Malone Friend kindly indicated they don't question, the applicant doesn't question the legitimacy of why Kent County Council are raising the issue of viability. Obviously, the applicant has chosen to do that. The applicant submitted viability reports both for the north and the south. In doing so, the MPPF requires them to justify anything that's a deviation from the affordable housing provision. And we would say equally the Section 106 contributions as well. It might be said against us, well, why wasn't that in your statement of case? Why didn't you articulate things at the time it was going to be determined, specifically about the viability? Why has this issue come to the fore, please, during the course of the inquiry?
Well, it's largely to do with the amount of information that's been coming through the appeal process. So Mr. Mitford-Slade himself completes a re-evaluation in April of the viability due to Section 106 being a movable feast.
Those are his words, in effect, aren't they? Well, his observations are he provided a new viability appraisal in April this year because of the Section 106 contributions, as you say, moving.
Yeah. I mean, recognise that in para 5.1 of my proof of evidence, we recognise that it's not usual practice for KCC to investigate viability of a scheme. Generally, we would rely on the LPA to complete their review and report through local plan or application process. But the county has become increasingly concerned regarding viability, partly through the issues arising from the Chilmington Green application, which we'll touch upon, but also cases in Sevenoaks in which we have been successful in persuading an applicant that they were actually able to provide the necessary Section 106 contributions associated with their development, despite previously submitting viability appraisal. Specifically for this application, the county had considerable matters of information outstanding at the time the appeal commenced, all of which are impacting on costs. You mentioned at this moment, I've just mentioned it, Mr. Milford-Slade's proof of evidence, Appendix 3, paragraph 3, where he again refers to re-reviewing the viability. The County Council's last response to this application highlighted a number of outstanding matters. It was confirmed in Mr. Dygan's Planning Committee report that a lack of information was included as a reason for refusal, or would have been recorded as a reason for refusal, I should say, by the Borough Council. The applicant's team has been very busy in submitting considerable amounts of additional information that we've all waded through during the process of this inquiry regarding the Section 106, archaeology, public rights of way, highways and off-site highways infrastructure, and the National Highways motorway junction design. Five Parishes Group have asked questions regarding deliverability of the road and affordable housing percentages. Madam Inspector, you were invited to walk the entire route and did dutifully walk every inch of the northern and southern relief road, where we found out even more information, I suppose, about the undulating landscape and perhaps difficulties that delivery of the road might encounter. None of this information was available at the commencement of the appeal. The Inspector has also heard most recently from Mr. Spilsbury and Mr. Gardner about a number of other unknown costs attributed to the lack of detail in the submission. Mr. Gardner specifically mentioned... Sorry.
I don't know if you'd be able to shout as well.
If you just come this way a little bit closer, you can get as close under the microphone
The
as
thing's gone off. That's why you can't hear me.
Okay.
Sorry. Yeah, I apologise.
So you said about walking the room, so that none of that information that you've now got is available. That's what I was wondering.
That's correct. Sorry. Yes. And I was saying that, Madam, you'd also recently heard from Mr. Spilsbury and Mr. Gardner about a number of other unknown costs attributed to the lack of detail in the submission. Mr. Gardner specifically mentions the attenuation adaptation necessary at Stones Farm. We noticed that, I think, on our site walkthrough. So the detailed information that has not been provided will make a significant impact on the deliverability and viability of the scheme, magnified by the sheer magnitude of the applications and associated levels of infrastructure. I'll come on to the commission, if you like. So the County Council commissioned cost consultants, Alan Dadswell, who you will hear from later in the inquiry, in partnership with National Highways. That took place in around February of this year, to look at the road scheme deliverability in response to new information being provided during the inquiry. It emerges now that we have a dispute in respect of the highway costs in the applicant's assessment, such that the levels of Section 106 and of affordable housing may be impacted. Due to the gravity and impact of the application on community infrastructure, for which KCC are accountable, it was considered appropriate for an independent viability consultant to then be employed, hence Mr. Spilsbury's involvement. It would be unacceptable to the County Council for the impacts of the local communities not be mitigated, and any unfunded approval impacting on the County Council's ability to deliver its statutory duties. Furthermore, our view would be that any reduction in the necessary Section 106 contributions would make the application unacceptable in planning terms, and again, KCC's ability to deliver its statutory duties.
When you say that reduction in Section 106, are you referring to all the 106 costs, or just the ones that the County Council are interested in? For example, one of the contested ones is the acute care. Another one is national landscape. Are you referring to those as well, or just the things that...
I'm referring specifically to the County Council's Section 106 costs. Affordable housing does come into it a little bit. It's not an area of responsibility or accountability for the County Council, but it does have longer term impacts perhaps on particularly our adult social care services. So it were sufficient levels of affordable housing not to be provided, but it's not our interest. Our interest is focused specifically on county
You're
councils.
referring to affordable housing as well as highway and public rights of way?
I'm referring specifically to just the County Council's Section 106 contributions. I'm just noting that a reduction in affordable housing does have a longer term impact on the social infrastructure of the county.
So there was some discussion about the education costs. We're going to have a separate section, or further separate sessions on that. But you've done a calculation to work out what the per dwelling cost of the County Council's contributions are. As Inspector rightly observed, we're not here concerned with the acute care, the Kent North Downs Authority, nor indeed Swales contributions, but the main ones are obviously County Council ones. And what is the per dwelling figure, please, for the southern site?
So for the southern site, the per dwelling cost of the County Council's Section 106 asks, including education, public rights of way, bus contributions for the primary, etc., would be £13,076.16 per dwelling.
And for the northern site?
Are you with me?
Yeah.
16,000, 16 or 17,000.
16,146 and 36p would be my rough guess.
It is £16,146 and 36 pence.
Lucky guess.
Does that count as a leading question? I don't know.
It was undoubtedly leading, yeah.
That will not include the relief roads because that is a section 38 or section 278. That would not include, thank you, Ms. Cancelboni, that would not include the highway costs because they would be covered by section 38 or section 278.
Got to be considered with in terms of viability.
Absolutely.
Yeah, so Mr. Spilsbury gave evidence yesterday, and he was referring to obviously costs associated with the highway works, in particular, and abnormals. And I think at one stage you asked him a question, madam, about whether the education was included in that. For the avoidance of doubt, it isn't included in his figures. It's this 13 or 16,000 south and north side. These are additional sums per dwelling on top of all the highway works. I think we saw figures of 44,000 and things like that.
The 13 and 16 is education.
It is education, but it's separate from everything that Mr. Spilsbury told you. And I think yesterday he wasn't necessarily clear on that, and so we're just being clear. So the point is, as a highway authority who've been clear, we'd like the road, our clients would like the road and want it delivered, and there's obviously implications of that because the applicant has come forward and said they're not proposing to build out either the north or the southern site until the corresponding relief roads are built. Is that right?
That's
obviously,
right. Yep.
That has to be consistent with their traffic case and their highway traffic case, which is not contentious between us, but is predicated on that assumption. And then separately, there are the county council obligations, which you've just talked about, the 13 and the 16,000. And again, we'll set this all out for the Section 106 session, just a table, in fact, the tables I'm looking at now, really. What you've done is you've taken the cost of providing the relevant facilities and then divided by the number of dwellings. And for those applicable houses, primary is £7,881 a plot. So for
primary new school new build costs. Yeah.
So northern site, primary new build. There's a new primary school. It's for houses. It's £7,081.20. Yeah. For flats, which obviously have a lesser demand for primary school places, 1,770 and 30p.
That's
And the reason those are said to be applicable because some units the contribution is not applicable. It's not many of them, but some of them. Is that right?
That's correct. Yes.
Yeah.
So all of the figures, Mark, will be in the developer contributions guide and the CD. So you may not need to write them down, but all of the figures in terms of the per dwelling costs are in that developer contribution guide and our request letters. So we'll set that out for you anyway.
And just for completeness, the secondary school new build figure for houses is £5,587.19, and for flats £1,396.80. And as you rightly say, it's all set out. The only reason I just highlight that in particular is those two figures together represent 12,500. So the lion's share of the concern is around the provision of the primary schools, yes?
Absolutely, yeah.
Now, Mr. Spilsbury's evidence shows that under various scenarios, not only does all the affordable housing disappear, but also the contributions are then eroded. How much of a concern would it be for the county council to be in a situation where the Secretary of State grants planning permission for this proposal, the developer starts to build it out, and yet the appropriate contributions, particularly for the schools, which form part of their internal trip rates and communities are not actually provided or provided at the right time because the contributions haven't been provided.
That's going to be of huge concern. We have a statutory duty in respect of educating those children. I think Framing Kent's Future is quite clear in setting out that the authority is not in a position to be able to pick up the tab for this, and that's why the MPPF and everything else allows us to secure developer contributions towards it.
Yeah, and those figures, because it follows the policy they've got in place, they're the same for the southern site as well, so I don't need to replicate those. I gave you the figures. They are contained in the...
They're contained in the Developer Contributions Guide, which was a CD we mentioned before when we had the Section 106 roundtable.
It's a core document called the Developers Contribution Guide, Kent County Council. We'll provide the... It's fine. We'll provide the
but we will provide it all for the Section 106 roundtable. That's
And so what you're doing is articulating the county council's concerns about if the viability doesn't add up, literally.
Correct. Yeah.
Now, the position is it commissioned Mr. Spilsbury. Mr. Spilsbury has produced his report. That's part of the Kent County Council's evidence to this inquiry. He says that it's unviable. Both sites are unviable. As has been pointed out, that's an immediate conclusion based on Kent County Council's highway costs for the roads and the relief roads and the motorway. What's the consequence of that then? If Kent County Council's evidence is accepted in that way, and Mr. Spilsbury's evidence is accepted, working the maths through, what is the County Council's position about the grant of planning permission for both of these applications if that evidence is accepted?
The position would be that it's not meeting the necessary tests to approve.
Yeah. So is Kent County Council's position to the Secretary of State to grant or to dismiss these appeals?
If the financial position is as the evidence that I've been provided, it would be to dismiss them.
Yeah. Okay. Now, the applicant seeks to present other evidence, some of which we had yesterday. We've got to work through that, see if that changes the position, obviously. Even allowing for that, even if they were right on all that, Mr. Spilsbury's raised other concerns which erode not just affordable housing, but erode the Section 106 contributions. And he's raised a concern about the appropriateness of the applicant's evidence, not just at the start of the process, but now, the lack of sensitivity testing, the lack of transparency on costs, etc., etc. Yeah. Given his concerns about the adequacy and appropriateness of the evidence in line with RICS guidance, then what is the position, please? Did Kent County Council feel that the applicant has provided the necessary and appropriate viability evidence for permission to be granted?
No, we do not. No.
Right. Good. Okay. I just wanted to finish with a couple of issues, if I may. Just bear with me. Sorry. Yeah, the commissioning of the cost consultants' reports. So Mr. Spilsbury was raising issues about the lack of detail of the costs. We know that the highway works were being considered. We know the motorway junction design wasn't finalised. We know there was an issue about the area, the amount of the area, the land take required for that, and what could be accommodated within the relevant area before you get into a DCO threshold. And all of that was being considered. Why did Kent County Council jointly commission the cost work with National Highways?
Because of the lack of evidence that was coming forward in terms of at that point in time, and the additional evidence, that was coming through, clearly we were seeking to present a joint, effectively, approach to costs rather than having 3 different cost consultants. So we joined forces with National Highways to have a look specifically, and at that time, as you allude to, they couldn't carry out that work until we got additional drawings from the applicant in respect of the motorway junction, because National Highways still had outstanding concerns about whether it could fit in the red line boundary, etc. So yeah, it was to address questions being asked during the inquiry.
Yeah, additional drawings needed to be provided. That design needed to be finalised, and then able to cost
and then
it.
we were able to cost. Yeah, we would. You're not going to have a look at these things before.
Yeah, and it's at that stage that it became clear that the applicant was not willing to look at contingency, and was not prepared to pay a commuted sum for the ongoing maintenance of the road, and particularly the structures. Yes,
that's correct. Yeah. I mean, there is a statement of common ground in terms of with National Highways, which I believe does allude to reference to an unaccounted or an unspecified commuted sum or maintenance cost. I think it's referred to in the statement of common ground for with National Highways. But it's not specific on the amount, because it can't be, because they don't know the full cost of the scheme.
Yeah. And we know, don't we, that the viability evidence was submitted by the applicant on the basis of the information at the time of the planning application. We know that didn't include the final design of the motorway junction and other details. Public rights of way were still to be determined, the type of crossing and so on. Is that right?
Yes, and that's absolutely right. Yes, I mean, we heard in the first week from Mr. Sutherland about an exemplar landscape-led scheme, which Mr. Rustling, my public rights of way colleague, might in turn consider to have been a green bridge, for instance, going across, connecting the northern parcels for the open space and a proposed country park and the southern country park, or at least a grade separated crossing. But we don't know. Yeah. What's going to happen.
Now, ordinarily, one would think when an applicant submits viability evidence required, obviously, to justify any reduction in the affordable housing contribution. I know there's an issue about the interpretation of policy, but as a matter of fact, one site is 10%, the other is 22, I think, or 11.2728. We've got different figures, and neither of them are 40%.
No.
The District Council, Borough Council, would obviously look at that. They did look at that. They had viability experts look at that, but the viability experts didn't investigate the costs of the infrastructure, particularly the roads. And their conclusion was, as Mr. Spilsbury's explained, there were significant risks associated with assessing the viability. And then they didn't take it any further forward. No witnesses presented and so on. A matter for them entirely, other reasons for refusal, as I've said. But what's the concern there when the Borough Council sort of stops at the point where their conclusion is, well, there's significant risks with this? What's the difficulty for Kent County Council when a district or a borough council adopts that position?
Well, it puts us in enormous difficulty, because I suppose there are some benefits to the borough council in terms of some affordable housing, but the lion's share, I suppose, if you like, of Section 106 requirements for education and the rest in the highway schemes, it's their county council responsibilities and their county council risks. And so that's where it comes into play on a site of this, or applications of this scale, that there's a significant impact on the risk associated if those contributions don't come forward.
Yeah. Now, on that issue of risk, then, final topic is that what might be said against you is, well, yes, maybe things will change. Maybe viability will change, and we might not be able to pay for it all, but there'll be triggers. So the primary school doesn't come, there'll be a restriction on occupation before the secondary school comes forward, or the third primary school, or so on. So why are you worrying, it might be said, if there's triggers to stop further occupations taking place? What has been the county council's experience with big schemes?
Well, I was going to say, shall we come on to the big schemes, and we come on to Chilmington Green, which I suppose I highlighted a bit earlier in my evidence.
So just helping the inspector to orientate where that is. That's
yes.
in which district?
Chilmington Green's in Ashford Borough, and that's immediately to the south of Swale Borough. So it's immediately to the south of this borough. So it's sort of a centrally located in Kent.
Okay.
So the Chilmington Green application.
Number of units?
5,750. Subject to a Section 106B appeal that was being heard earlier this year, where the applicant is seeking to discharge multiple conditions and Section 106 obligations. The applicant attempted or has introduced viability as an issue during the inquiry, although we were arguing it shouldn't have been, because 106Bs we don't believe should consider that. And the County Council and the Local Planning Authority are now pursuing enforcement action, potentially through an injunction.
Okay, now let's just unpack that a little bit. First of all, the developer gets planning permission.
Yep.
Says all the things it's going to do, signs the Section 106, education contributions, highway contributions, all of these things to get their planning permission, and then they come back in while they're building it, and they are building it, is that right?
They are, yeah, they have occupied.
First thing they do is they apply to vary the Section 106, is that right?
Yeah, Section 73.
And they in effect want to remove some of the obligations that they said when they got planning permission they'd adhere to.
That's right.
Yeah. In addition, they're in breach of their obligations, and enforcement action is being taken. Is that right?
Yeah, I mean it's been a problematic site for a while. Access was supposed to have been delivered for the secondary school, so probably access to the secondary school that wasn't delivered. The County Council had to step in and provide the access for the secondary school. These are obligations, so it is a particularly difficult application, but it is a large scale application, and I guess at 5,750, I think we've noticed in Kent that a lot of the larger scale applications are in need of some kind of central government support or funding to enable them to proceed.
In terms of the building out, what's happened, because they've been building the houses, what's happened there?
Well, they've been building out in terms of the houses. They've not been providing the levels of 106 that they were supposed to be, and that's why we're in the position we're in now.
There was a threshold, as I understand it, of 400 units,
400
which
units.
they should not go over.
That's right.
Have they gone over that?
I believe they have gone over that.
And as I understand it, we can't say too much at this stage, but soon we may be able to enlighten the inquiry as to legal proceedings surrounding enforcement issues. Is
Correct.
that right? Yeah. Okay.
You said there was an appeal, didn't you?
Yes, it was a Section 106A application. I believe it was non-determined, and so the applicant submitted a Section 106B appeal, which was originally rejected by the planning inspector, but then subsequently accepted by the planning inspector.
Rejected on procedural matters?
Yes, yeah, but then accepted. Sat earlier in the year, I think April time. No decision yet. Well, no.
It was a transferred decision, was it? Inspector's decision, not.
It was yes. The inspector was there. Yeah, we had to keep our jackets on, which it was very hot in that room as well. He did. I think he did give us.
It shows how lucky you are.
It does. Yeah, he did give us. Did give us permission to remove our jackets, but yeah.
But anyway, so there's no decision.
No decision as yet. No, I think it's anticipated. October, Mum, but I don't know for sure. I think it's anticipated in October, but I'm not sure, Mum. But yeah,
Okay, that's a long time.
it's a long time. Yeah, it might come sooner. I might be.
As soon as we
I think
receive
that's
it, we
what-
will of course provide.
I think that's what I was
the
expecting. I don't know that for sure. I
Okay.
don't.
Yeah. Okay. All right. So that's Chilmington
Yeah,
Green.
Chilmington Green.
Then there's Otterpool Park.
Otterpool Park. Yeah. So
Just help us. I think I said Folkestone Hyde.
Folkestone Hive, yes, an application. So, Mr. Mitford Slade introduces reference to Otterpool Park in his proof of evidence, CD 37 13.2, paragraph 3.38, para 3.38, 3.38, we're suggesting that approximate infrastructure costs are being comparable to that of Highsted, and therefore a reasonable assumption. So Otterpool Park is an application for 8,000, a potential allocation of 10,000 homes. But it's a matter of public record that the Section 106 is not completed, and that Folkestone and Hive District Council have initiated assistance from Homes England to review the infrastructure levels and the current heads of terms to assist with issues relating to financing the project and bringing the site forward. It's sat there with a resolution to grant, but no Section 106. Possibly taking a similar approach around submission of a business case to government, such as was mentioned by Mr. Spilsbury regarding Worcester Park. But in my opinion, the Otterpool Park site should not be used as a comparable to Highsted. Otterpool Park has readily available and accessible transport infrastructure and a topology that would require significantly less land engineering. Otterpool Park doesn't have any confirmed infrastructure costs. It can't have. They're still being debated. And I would argue it would be expected to be lower than that of the Southern Highsted application, and yet it remains unable to progress due to financial viability.
Yeah, so I mean, a lot less to spend in terms of infrastructure. It's already on the motorway, as I understand it. Motorway junction's already there. It's right next to it. Relatively flat land. Developers got planning permission. In they come, and sorry.
It's resolution to grant.
Resolution to grant. Now the Section 106 is all up for reconsideration.
They want to have a look at it. Yeah. That's right. Yeah, with Homes England's assistance. Yeah.
To their credit, the developers there have been liaising with Homes England, who I think actually own part of the site. Is
they
that
do.
Right?
That's correct. Yeah.
And therefore, Homes England are involved in the delivery of that site.
Correct.
I think they've got a short-term agreement. Is that right?
There's a short. There's a collaboration agreement which was reported by their committee.
Yeah. Do we know how long their involvement is, or?
Testing me. I think it runs until the end of all. I think it was a 6-month agreement.
6 months.
I think.
6 months. If you want to know more about the short-termism of Homes England, do watch Have We Got Planning News for You tomorrow night. Just a plug. Yeah. Now I don't do LinkedIn. Somebody else does that for me. Okay, but in all seriousness, I mean, there seems to be a growing concern about the actual veracity of what's said by developers on these big sites and their deliverability, not questioning their desire to deliver houses, but how much of this is a concern, a growing concern for Kent County Council?
It is a growing concern, and I think in my experience of reviewing such applications of this scale, they generally all need a little bit of help, whether that be through an accelerator grant, a loan. So the last Bearing Fruits local plan, in 2017 local plan, had an early review on the basis of the inspector at the examination in public raised issue, I think it was issue number 9, regarding the need for additional highway infrastructure, and Mr. Bircher will come to this later in his proof, but that was subject to a £38 million home housing infrastructure fund bid, which we were successful, and Mr. Millard referenced it in terms of the Grove Hurst A249 improvements. Otterpool Park, as we said, is likely to need some additional funding. Even the Ebbsfleet Garden City, which has has been accelerated really through a developer corporation, have received £74 million a grant for a land assembly.
Bringing the site forward.
Yeah, bringing the site forward. It was for what you call it, land levelling. It's an old pit, so it's getting the land in a suitable state and bringing the utilities in. It is a brownfield site. Yes, yeah. It's land preparation and contamination and utilities. Yeah. And that was initially part approved in 2002. And, the Ebbsfleet Development Corporation was established in 2015, and obviously since then it's been delivering houses very well. 600, I believe, per annum now they're up to. So it's a working site, delivering houses. But it took a long time to get going. It needed initial support.
And just to finish, Mr. Gearing's proof of evidence at paragraph 6.6, he gives examples of master developer schemes provided without government intervention, the point that you've just raised.
He does, yeah.
Just want to go through those briefly. Urban and Civic's Holton site, I think that's in Rugby, 6,000 homes.
Yeah, 6,000 homes, 3 primary schools, 1 secondary school, Link Road, received £35.5 million loan from the HCA.
6.6 of Mr. Gearing's proof of evidence.
It's his first rebuttal, which is core document 37.14.1 on
some of the sites.
Yeah, I think that's not what it is.
So,
thank you. 37.14.1 is the document.
I have a paper copy, Mum, if it's quick for you. It's 6.6. Yeah, so in that paragraph, he references some examples of master developers-led schemes without government intervention: Urban and Civic, Catesby, the Duchy, Corinthian and Buckley. I didn't review all of them. I had a look at a few from Urban and Civic, Catesby, Catesby, thank you. Catesby. Urban and Civic, Halton, 6,000 we've mentioned, 35.5 million loan from HCA. Urban and Civic, Alconbury Weald, 6,500 homes, 3 primary, 1 secondary. Reserves a site for a railway station. Received 45 million loan from Home Building Fund to accelerate vital infrastructure. Catesby, Middlebeck, includes the Newark Southern Link Road, which was started in February 25, received £20 million levelling up. The Duchy I didn't look at. I don't expect they will need any additional public sector support, but well, not direct public sector support anyway. But yeah.
Yeah, right.
Did you say about the Urban Civic one?
Alconbury Weald, Mum, or
I don't know.
Halton. Says
received 35.5 million.
35.5.
Alconbury Weald, also Urban Civic, received
45.
£5 million loan these are loans from the Home Building Fund to accelerate vital infrastructure.
Yeah.
Catesby,
Got that one.
they received 20 million, and then the Duchy
We don't think it
He's
is.
got other kinds of finance called us. The loyal subjects. So, yeah, I mean, just your general observation on that. You know, how common is it, even looking at the examples that he'd highlighted, that public money is needed to make these schemes work?
In my view, it's an almost absolute certainty that sites of such magnitude and scale, certainly to get them going, are in need of government support. And my conclusion on the basis of Mr. Parks and Mr. Spilsbury evidence is that, you know, a grant would be an absolute requirement for a site should Madam Inspector make recommendations for approval, or the Secretary of State decide that it should be.
Yeah. So some form of public money is, as you've just said, an absolute requirement for this application on the evidence.
I believe that to be the case. Yeah.
Good. Okay. Thank you very much indeed.
Half an hour, something like that, 20 minutes. Just a
Would
few
you like me to
things.
move, or are you okay?
Yeah, I'm good if you're. Are you
yeah,
all
I'm
right
good. Yeah.
there?
Yeah.
Great. Just a couple of things. The first is procedural, if that's the right word. The awful lot of criticism, not from you, but from others, about how poor the applicants have been in producing their cost stuff late in the day, or substantiating viability objections or whatever late in the day or whatever. Let's just be clear about the way in which this has all come about, the way in which we are all come to be sitting here talking about this topic. The first thing to say is that during the application period, which is to say between 2021, 2022, 2023, 2024, so that obviously we get called in 2024, but
Yep.
what is that, 3 or 4 year period? Kent did not request any information whatsoever in relation to either costings of the roads or viability. Correct?
That is the case. Yes, we were still requesting other information.
You were requesting other stuff,
Yeah.
but not the stuff we're talking about now. Not the stuff that you think means we have to refuse the whole applications. Application gets called in. Application gets called in by the Secretary of State. That's a time that a few of us remember quite well, because all of a sudden we're on the clock and we've got to start working out how we're going to do our tranches of evidence and all that stuff. And the first thing that happens, you might remember, because we had a CMC with our inspector, and she said, right, statements of case. We need to do our statements of case, and then everything's going to flow from all of that, work out who's saying what, proofs of evidence, work out a programme, all that. Do you remember? You remember?
Yep, I do remember.
Vividly etched in our minds. Statement of case, Kent produced one. It says nothing, not a sausage on road costs, not a sausage on viability, nothing, right? Correct?
It does, however, still say that there is information not yet provided. But
It wasn't info you wanted. You wanted info that's led to the withdrawal of your objection on highways grounds. And we've provided it, and we've reached a full statement of common ground on highways. That's why we've moved on from there. But on costs and viability, to be, fair to us, we're now, 4.5, 5 years in or whatever, and Kent has not, at this stage, post-call-in, even raised the issue. Not saying you can't raise it now, as Mr. Young said. I'm not taking a procedural objection, but that's factually correct, isn't it?
That is correct.
Thank you.
But it's to do, as I say, to do with the fact that, at the point of which you might consider that
Right.
evidence, and so there was still a raft of evidence that hadn't been provided.
Yeah.
And we understand, the process and why that was, and where
Okay.
we got to with the swale, and that's why you wouldn't necessarily look at, you wouldn't necessarily go to that expense before.
Okay, well, all right. Well, that's your explanation, and we'll have to, bear in mind whether that's a credible one or not. I mean, you're saying that it only became worth looking at basically in the spring. That was of this year, so which is a couple of months ago.
I'm just saying that you wouldn't consider it until the information
Until the
available to take until the information was provided, so
In
that
the
you can
spring.
in terms of the
All right.
highways.
Then. So what happened? Go on. Did you have more to say?
Clear answer there. You said information had been provided in relation
to highways,
To highways, right? Which was in the
which
spring.
which
Okay.
well the the statement of common ground was relatively recently.
Oh,
completed,
is that the
wasn't it?
information
Yeah.
you meant? You mean the signed statement of common ground with Kent and the applicant? and
Yeah, I'm
highways?
saying that there's still a lot of information outstanding up until the point that the statement of common ground was
Gotcha.
was
But hang on. The highways. Sorry, I didn't expect you to say that. The highways statement of common ground with Kent. Let me just check it. My computer's decided to die. Here we go. That was in. Come on. That was in March. Is that the time? Is that the time at which it becomes Kent's concern to do a viability exercise, cost exercise?
we started to look at the cost exercise in February, working with National
Okay.
Highways.
Right.
A little bit before then, as information was coming to light.
And what happened procedurally is that Kent, as you've explained, decided to undertake. Sorry, a road costing exercise together with National Highways,
Correct.
which we'll hear about obviously in 2 weeks' time in lots of detail. So it's just obviously we'll come back to it because that's the cost.
Yes,
stuff.
yeah. I mean, these are matters probably for Mr. Parks. And
Of
Mr.
course,
Birchall,
it
sorry,
is. Yeah, I'm not going into the detail of any of that.
Thank goodness for that. Thank you.
That costs exercise. You commissioned it though, right?
Yes.
You commissioned it. They did it
alongside Mr. Birchall.
alongside
yeah,
him.
Yeah,
so I'll
that's
come
right.
back to
Well,
that.
yeah.
And that formed the basis of Mr. Spilsbury's instructions, who we heard from yesterday.
Correct.
Right. Okay. And because you commissioned it, you know what they were asked to do. What you asked them to do was to look at the drawings that have been provided by Mr. Wilde and his firm, the highways drawings, to assume that those were the roads that would be built out strictly as per those drawings, I think.
They, in fairness to, I think we are drifting into evidence from Mr.
Really?
Parks, but I will answer the question. Sorry, I don't
It's
mean
about
to
what you
be.
were asking him to
Yes,
do.
to look at those drawings because they're the only drawings
Fine,
that are available.
fair enough.
Yeah.
And you also asked, I'm not going to, Mr. Parks obviously needs to speak about what he
Yes.
did.
Yeah.
So last question on this. You asked Dadswells and Mr. Parks to cost those roads in isolation, which is to say you didn't ask them to cost the roads as part of a wider scheme of residential mixed-use development.
They were aware of what it was forming part of, but they were specifically requested to look at the drawings. Yeah.
Okay.
Yeah.
Thank you. Right then, so we'll come back to that stuff in lots of detail in a week or two. Next little mini topic is what's the purpose of all of this? What's the purpose? A sort of existential question. Mr. Gearing's first rebuttal, which is the one that Mr. Young took you to, actually, 37.14.1, if you could.
Yes.
It was the one that you've hopefully already got out, madam, if you've not. And if you could turn in that to section 4, which starts on page 10. Have you got that? It should start background on highways costs.
Yep, got it.
Lovely. 4.1 is making a point about the difference between a public authority doing this and a privately funded. Well, that's all for the cost session. But I did just want to check your understanding of the planning practice guidance and what the purpose is of Kent getting involved at all in this debate. Do you see at 4.2 references to the MPPF and the PPG? And in the second bullet, there's a quotation from the planning practice guidance that says that viability is not a calculator. You'd be forgiven for missing that in the last 2 days of evidence, but anyway, not a calculator, not a calculator. Instead, saying that in plan making and decision making, viability helps to strike a balance between the aspirations of developers and landowners in terms of returns against risk and the aims of planning system to secure maximum benefits in the public interest, right?
Right.
And when it comes to the topic of contingencies, which is the next bullet point, contingencies, ... have to be justified. They've got to be justified for contingency relative to project risk and developer's return. Yeah?
Yep.
So it's really important, isn't it, from Kent's point of view, that we don't lose sight of the role of viability in all of this. It's an aid to decision making as part of a wider balance that's being struck between aspirations and the public interest.
Yes, it's evidence along with everything else.
It's not some
that
sort
needs to be
sorry,
considered.
I didn't mean to cut you off. Please, I didn't mean to cut you off.
It's evidence that needs to be considered along with everything else. Yes.
It's not some sort of be all and end all. It helps. It helps us to strike a balance. That's what all this viability stuff's about, isn't it?
It is, but as I say, the county council, in terms of the elements of risk for the county council and the budgetary pressures, that if the viability evidence is suggesting it isn't affordable, then it would be rather negligent of me not to take that into consideration.
The risks for the county council, such as you allege, I'm going to come back to them in a minute, but those are around the non-delivery of things that are committed to through the Section 106 and through planning conditions.
They are, yes.
I mean,
no contestant that the applicant has suggested they will provide all of the Section 106.
Do all the stuff. So if the planning system works in the way that the planning system should, and I'm really underlining that because Chilmington is clearly an example of the planning system not working in the way that... But Chilmington, it's the enforcement process is now taking its course, isn't it? Maybe some might think later than it should have done. But anyway, the enforcement process is taking its course, and we'll see what happens, be it through PINs or the courts or whatever. Mm-hmm. But we've got to work, haven't we, not just on your objections, but in general, on the basis that what's in a 106 is actually going to happen.
If it's
legally
it is a legally
deed.
binding document, yes, but what we don't, it would be a travesty, wouldn't it, if we sat here for what it's going to be 14 weeks enduring this heat, and then have to then come back immediately for a Section 73 or whatever. So I think we just need to take it into consideration.
Sorry, I didn't mean to cut you off.
Yes, it would be a travesty of justice, wouldn't it? If, a complete waste of all our time and public money if we were then to have to come back because the viability evidence was completely discounted, or our viability, and then we're back to a Section 73 or 106A application, whatever it will be latterly. Let's
be super clear about it, though. A Section 73, we're not for a moment suggesting that this is likely, but if a Section 73 happens in the future, sorry?
Section 73
it's a variation.
Conditions, isn't it? Are you not talking about variation of the legal agreement?
Do you mean a 106?
I mean a 106 variations.
Okay, a 106 variation, if that's what happens, and we're not suggesting it is a completely separate proceeding that sits well outside the scope of an inquiry like this one, isn't it?
Yeah.
And the pros and cons of whatever it is that's happening in the future will be a matter for Swale or for I guess for the Secretary of State, maybe, who knows? Depending on whatever on earth is going on in those circumstances, wouldn't it?
It would be, yes. Yeah, that's right.
And so, and it's not just on your highways points, it's on everything. When you're at a planning inquiry, the inspector has to operate on the basis that what's in a 106 is actually what's in a 106 and is legally required to happen unless a deed changes it through another proceeding, and that it's going to be delivered.
Yeah, that's reasonable, yes. I mean,
Yeah,
I think, but
thought so.
it's just that obviously our evidence in terms of Mr. Parks and Mr. Spilsbury suggests that there are issues in Mr. Gearing's rebuttal. So 30 again, the same document, 37.14.1, paragraph 6.5. He refers to the differences with Chilmington Green.
Yeah.
But his point, thirdly, where he starts thirdly, is he's saying, Mr. Gearing, 6.5, and he's made three points to say that why Chilmington isn't the same as this application.
Oh, yeah.
But thirdly,
Have you got that, madam, just to check? Yeah, sorry. Sorry.
Thank you, Mr. Simonson. Was that thirdly, it says exactly the role of the planning process to allow for reconsideration of viability matters through Section 106B application. So he's not suggesting that it would happen, but he is suggesting that it's a perfectly valid process, which it is.
Yeah.
But that's by even raising it, it still would give us concern.
The fact that he's mentioned that there's a legitimate process to go through, that gives you concern.
It does.
And do you know, what about the last bit where he says the key difference is that here, Grampian conditions for Highsted are pre-commencement. It's a completely different situation to Chilmington Green.
No, the Grampian conditions are helpful. I acknowledge the Grampian conditions are helpful, but they don't.
Okay.
Unfortunately, if the ship's sunk, it's not leaving port, is it?
It's difficult sometimes to understand why these risks that you're so concerned about at Highsted are said to be risks at all. Because if the conditions in the 106 are to be taken as read, which you agree that they are, because if they're to change, to be a Section 73 or a 106B or whatever, then everything is triggered. Then everything is triggered at the appropriate level, and we meet all of your policy requirements, don't we?
You do, yeah.
But there's a problem, you say, and it's a problem that Mr. Spilsbury's very concerned about, and it's a problem that Mr. Birchall's very concerned about, and it's to do with all these costs. And obviously, I won't go into the costs now. That's, as I keep saying, for 2 weeks' time.
No problem.
But you know, don't you, all about... You've read Mr. Birchall's evidence,
yes.
I'm sure, and you know, I won't go into the detail, but just high level, you know that one of the things that he talks about is contingencies and risk allowances.
It is, yeah.
And just to sort of summarise, 10% contingency, he says, then on top of that, 15% project risk allowance. This is all for the road. And then on top of that, scope risk allowance as well. Right? You know
Yes,
that's what he says.
right, yeah.
And the effect of all of that across the north and the south is just on the risk allowances alone. So putting the contingency at 10% aside, the risk allowances alone add up to a difference between us of, it's £70 million plus, £77 million of just risk that you incorporate in your concerns and Mr. Spilsbury's modelling and all of that, right?
Yes, you've gone to paragraph 3.6.
Yeah.
Yeah.
Now, on this risk stuff, we're going to come to it, but you're the one who is driving the need to go there, the need to consider all this risk, and it's the risk that you're describing, the Chilmington Green Star risk, where someone doesn't observe their legal obligation, goes off and does something different. Yeah. Are there appeal decisions or Secretary of State decisions that you put before us that endorse Kent's approach to 10% scope risk, 15% project risk in the case of a privately delivered scheme?
These are questions for Mr. Birch.
Are they?
Fine.
Sorry, fair enough.
I do apologise.
Or that's a fair point. I'll ask him then.
Unique proposal anyway that hasn't actually been
Okay.
done anywhere else, is it?
All right, I'll ask Mr. Birchall. the motorway's unique, but lots of other schemes have delivered infrastructure. And my question is whether or not this idea about 10%, you aren't answering it, I'm just explaining what the question is.
Yeah.
What 10% scope risk and another 15% project risk on top of that, whether that's ever been looked at and endorsed by anyone. But anyway, well, that'll be something for Mr. Birchall. No, sorry, that's just to be clear. It's for everything. So it's that's why it's over £77 million just risk. We've got a bit of a problem, don't we? Because Kent, you explain in your proof of evidence, is strapped for funds. I'm putting it in broad brushed. Money is tight, you say.
Adult social care bills are rather large, yes.
Absolutely. So money is tight.
Yes.
Infrastructure needs are growing.
Yes.
Because of the growth that you've alluded to in your evidence in chief.
Yeah.
So we've got this problem, and it needs the private, among other things. Obviously, it needs more central funding too, but it needs the private sector to get on and come forward with proposals to deliver some of this infrastructure if it's going to happen. Right? Is that correct?
Yep, that's right.
So. Is that
That's
correct?
right.
Sorry,
That's correct. Sorry.
So in theory, before we come to viability, this is the kind of thing that Kent should be absolutely delighted to see, which is to say infrastructure-led mixed-use development.
Absolutely
meeting
correct.
some of your big problems
Yep.
that you've recognised in your local transport plan. But here's the problem. Putting aside the detail of the figures, which I'll ask Mr. Birchall about, if you crank up risk costs so high, you're in a catch-22. You want roads, you want the private sector to help you deliver them, but you're adding so much risk into your viability appraisal that no scheme's ever going to be able to satisfy you. Do you appreciate the problem?
I appreciate the problem. I still think it's a matter for Mr. Birchall, but I think it's
I'll ask him about
proportionate
it.
perhaps to the level of information that's being provided within the application, and I expect that. And again, it goes back to all of those issues issues.
Who says
Yeah.
that?
So I think he said virtually that it's about the amount of detail and the size of the scheme.
That's correct.
I think he said.
All right, I'll ask him about it. Chilmington. I think we've talked about Chilmington a bit already, but it'd be fair to say that it's got almost literally nothing to do with this case at all, does it? I mean, so the first thing is that it, other than being, I suppose, in Kent, it's a different site, different developer, different local planning authority.
Different site, different, yeah, absolutely. But it's still a large application and one that obviously maybe influences the way that the counties start to look at viability because of that.
I think it's relevant, I guess, in as much as it's affected. It's probably why we're here, because Kent has reacted to what happened there, and is now and here we are arguing about road costs. But anyway, the Quinns, the applicant in this case, you are absolutely clear in your proof of evidence that you're not aware of any incidents where have not paid their full contributions, or indeed where there's been any delays in making their contributions to Kent.
That's absolutely correct.
So clean bill of health for this applicant, for what it's worth.
Yes.
And to that degree, a very different situation to Chilmington.
Yeah. They'll still try and negotiate with me, but they'll still try to negotiate with me, but they do deliver.
Okay.
They have delivered.
But there are other differences to Chilmington, aren't there? Because one of the big differences to Chilmington, without going into, well, I was going to say without going into too much detail of it, well, I suppose we're going there now, but that's not a master developer model in that scheme, is it? The developer bought all the land outright and has had a big old debt secured against the land right from the start, which is obviously part of the reason that they're now in the viability challenges that they claim to be having. Are you aware of that?
Yes.
So it's not just a different developer, different LPA,
they
different
have
everything.
sold off parcels to,
Yeah. But the fundamental model's different.
Yes.
So there's no reason, therefore, I don't really know whether you're asking her to, but there's no reason for our inspector to give any weight whatsoever to what has either happened or not happened at Chilmington in her determination of these applications.
No, I'm asking Madam Inspector just to bear in consideration the county's experience of other large-scale sites in the county. I'm not suggesting that they are an exact replica of this application, but I am suggesting that it's a large-scale application in Kent that's suffering issues and has caused the county council significant pain.
Yeah. All right. Thank you very much, Mr. Finch. I've got
Thank you, Mr.
a lot
Simons.
to ask Mr. Birchall about, but that'll be not for now.
Sorry, Mum. Just to apologise for my brief absence, I had to go and ask Mr. Garden about a point before I confirmed my position or cross-examine. Sorry, I was absent briefly at the start of Mr. Finch's. I was just apologising. It was just because I had to speak to Mr. Garden about a point before finalising our position on cross-examination.
Yeah.
Thank you. I didn't have any points, but I do have one point that Councillor Bonney's raised, and it's just a point I want to ask now, but we'll come back to in the Section 106 sessions in October when I won't be here.
Yep.
Obviously, KCC has statutory responsibilities in respect of health and social care, and we've heard from the NHS that there is a particular emphasis that they need contributions to be able to provide the level of services that they anticipate will be needed. The question is simply, has KCC been liaising with the NHS over this?
No.
Would you expect to?
We would expect, I suppose, to have some discussions in where there are synergies with children's services, for instance, but not no.
And so would you expect to have had some liaison by the time we get to the 106 sessions in October?
Not ordinarily. We would still have I suppose look internally at ourselves, and the NHS will do the same. So but once they're done, we can look together. Yeah.
Thank you. I have no further questions.
That was a no. Yeah.
Sorry, I did take that to be a no.
I haven't got there yet. There was just one thing I wanted to ask you, if I can find my notes. Just a minute. Mr. Finch, where are you? Hold on. Sorry. I know you're somewhere here, but I'm not quite sure where. Oh yeah. Might have been answered. Can I just have a quick look at the point 219? Maybe it's rebuttal. Yeah. Just a minute. I just you talked in your rebuttal about the obviously very current yesterday when you wrote this spending review would suggest that it is, and this was about government investment, would suggest that it's now a much more plausible proposition. I just wondered what you meant by that. Actually.
Yes, I think it was regarding the announcement that the funding was going to be available towards accelerating or delivery of the 1.5 million homes.
Oh, I see. Okay, just one other thing. So Kent County Council is obviously, or would be, a signatory to the Section 106 agreements.
It will be. We will expect to be a signatory, yes.
So if you're, so how does that affect your concerns and objections then?
Well, significantly, because we would need to make sure.
Does that mean you wouldn't sign it, or?
Oh, in terms of no, I don't think it would mean that we wouldn't sign it. No, I think we would still. I mean, I'd have to take legal advice, but I would expect us still to sign it.
Right, but it'll be negotiating triggers and things. That's really
Absolutely, yeah. I mean, but we did hear, I think that.
okay. Thank you very much.
Agreed.
That's all I got.
Can I just help you with that last one? I remember at the very start of my career, Persimmon Homes were doing a case against Redditch Council, and Redditch Council decided that they wouldn't sign the Section 106, so they got absolutely nothing. That's what happens if you don't sign it. It's a without prejudice basis, the Section 106. So we could not sign it and as a sign of strength, but the consequences would be dire.
Okay.
But I'm probably getting into closing submissions. So to the questions my own friend asked you then, and what he said was, in effect, there'll be a Section 106, and Kent will be a signatory to that. There'll be conditions, they'll be attached to the planning permission, and that is how the inspector must judge the application. You remember those questions?
Yes.
Yeah. And, the prospect of a Section 106B application or a Section 73 application is for another day. That won't be the basis upon which this inspector is considering it.
That's right.
Yeah. Just consider this for a moment. Imagine Kent County Council had not submitted any evidence on viability. So it had nothing to say that the scheme is unviable and contributions couldn't be provided and question marks over the road and the funding gap and so on. How legitimate would it have been for the council to say in closing submissions, well, we don't think this will be developed in the absence of any viability evidence?
Yeah, it wouldn't be possible. It wouldn't be appropriate to say that. It would be.
So how important is it then that there is viability evidence if a party, in this case Kent County Council, thinks that it is unviable, that there is a big funding gap and a hole in the finances?
Absolutely essential. It's completely necessary and appropriate to do so.
Yeah, now that evidence has been provided. We've had Mr. Spilsbury's evidence. He said both schemes are unviable, not just in terms of losing the affordable housing, which is not making it unviable, it's just losing a policy compliant, but then eroding the contributions, and then I think on the southern side actually being in deficit to £80 million. How legitimate then is it for Kent County Council, concerned with the roads, concerned with the schools, concerned with social care, to be raising viability if it's got such concerns?
Yeah, it's completely legitimate. It would be, as I probably said before, but almost negligent not to provide that information to the Madam Inspector. And and I think, and again, a bit of perhaps a waste of all our time if we weren't to do that, and then the decisions were made on the basis of without that information.
And then my learned friend made a very bold claim. He said, we're only here because of Chilmington. Just help me with this. Is the only evidence that the County Council provides to just draw a parallel with Chilmington?
No, I provided a number of sites in my evidence.
And is there any site-specific evidence on viability in relation to this site?
Sorry, say again.
In relation to this site,
No.
Is there any site-specific? If it's we're only here because of Chilmington, has Kent County Council provided site-specific viability evidence on this site, as in Highsted?
Yes.
Yeah.
Yeah.
So, what does that tell us about we're only here because of Chilmington?
No, we're here because of Highsted.
Yeah. are there parallels to be drawn with other examples of major development schemes which are now in difficulty or have required public subsidy?
Yeah, no, there's a significant pattern emerging in terms of the large-scale developments that have occurred in Kent and indeed nationally.
Good. Thank you very much indeed.
Thank you.
Now, just before I let you go, let's consider Mr. Mitford Slade and how far we're going to go with him, shall we?
Absolutely.
So, I mean, there's obviously a lot of things have arisen, haven't
Yeah.
they? And he's at the end, unfortunately for him.
Yes,
So,
of course. Yeah, I'd said 1 hour and a half originally. I'd prefer to have 2, but we should be all right with 2. Yeah,
So you think 2?
I think so. Yeah.
All right. Right.
So if we started at 9,
So, yeah, hang on a minute.
yeah.
So, what about you, Mr. Young?
4 hours. I think we won't be longer than 4 hours.
Right, you won't be less.
I think we'll say 4 hours is probably
Right,
the
okay,
safe
fine.
thing. If I'm less, then we can all
Go in early.
get out the bunting. But
Right,
yeah,
okay.
I'm rarely less.
That's fine. Mr. Bell, you said 2 hours, didn't you?
So obviously I said 2 hours. We've since obviously seen how KCC have been advancing their case on viability, and there is an area where we significantly overlap in terms of the amount of evidence and quality of analysis. So subject to Mr. Young KC's questioning, I won't be intending to duplicate on that. So I don't think I'll be needing 2 hours, and I may be closer to 1 and possibly a bit less. But
Right.
it depends very much on Mr. Young's cross-examination.
Right, well, let's say if we said 1, that's still 7 hours, isn't it? And also, I can't promise I won't be interrupting because
I very much want you to interrupt.
because there's obviously lots of things I need to be explained.
Definitely, yeah.
As I have with the others, so
Of
I don't
course,
think
of course.
Mr. Mitford Slade will get off scot-free, unfortunately. So, that's going to add a bit of time, I'm afraid.
Of course, no, of course it
So
will.
there is quite a possibility we won't get Mr. Mitford Slade finished, I'm afraid.
Yep.
I'm happy to start at 9. I would like to finish at 5. It's been quite a heavy week. Yeah. So,
Just checking to see, because if we don't get him finished, then there's a question of what we do.
well, ideally we would just carry on the 15th.
Oh, that was just checking he's available. on the 15th.
Yeah. What? You're not there? You said you'd be available any time we needed you, Mr. Young.
That was in the end of. I should be in Venice listening to my daughter sing,
You can't do
will
the
you?
15th.
Oh, that's nice.
which would be lovely.
also-
and I should be thinking of you all, obviously.
So you-
No, but as long as I finish my cross-examination. Oh, I am.
oh dear.
That's why I have such a good instructing system. You're right, as it happens. Yeah.
How
So
does
you
everyone
will
else
be-
know when your daughter's in Venice singing
Yeah.
and not you?
So you'll be here on that Tuesday.
Yeah, I'm sorry. I thought you were thinking just run over into next week, but we're not sitting next week.
Yeah.
Yeah.
Can
Because
I?
I hope you're going to be here for all of next week, the week after.
Yes, I've just got my weeks confused.
Right.
forgive me.
Just to say, Mr. Mitford Slade can do the 15th,
Oh, thank you.
so if need be, which it may
it would
well
only
be.
be the more, I expect it would only be a little bit.
Note of caution, in general, is that, as I've said, Mr. Goodwin is restricted to appearing that week that he's programmed with the week of the 15th. So, and I know, should be fine, but we really.
Well, hang on a minute.
He's the TBC witness starting on the 16th. So we'll see how we go. I do just remind you of that because obviously, as Mr. Young said yesterday, it'll take as long as it takes. But I suppose we've always as long as he's heard that week, it may be that Mr. Gearing gets pushed back, etc. But anyway.
Well, Oh yeah, Mr. Gearing's after him anyway, but...
Yeah, of course.
I mean, that's on Thursday, so I would hope that we would
Yeah,
to him by the Friday.
I hope so too.
But who knows?
Alrighty.
But you know, then... Oh yeah, then we've got one more week, and then, of course, we've got our long break, haven't we? We have got a slippage day, though, if you please
Yeah.
know, on the 25th. So, you know, we have got time to carry on
Yep,
if need be.
absolutely, yeah.
Good. All right then.
Thank you.
Let's see how we get on.
9 o'clock tomorrow.
So 9 o'clock tomorrow. Thank you very much. We'll adjourn till then.
Just